This week, no matters when fresh matters unless it is head going. It is full and I can't take beyond 120 or 115 a day. 1st April will definitely take 300 or 400 avattu kodi because I have 3 days holidays. Ashte, that's all. Give all the memos now. Surface matters, naale sale iradu, ivat sale iradu matra 230 kodi.
My lords.
My lord.
Surface matter, my lord.
Surface sale iradu matra kodi. Possession I'll take, wait.
My lord, surface position matter, my
All
lord.
sound illa.
My lords, the respondent bank is taking the position, my lords.
Give all the memos.
Yes, my lords.
My lord, possession.
Fresh matters matra kodi. Pending kodbedi, wait. Fresh matter kodbedi. Pending kodbedi, wait. That's all right. Yes.
My lord.
Give.
My lord, it's a matter involving a pre-EMI matter.
Wait. Now, whoever has given the memos, please move. We will hear others. Sir, parvailla, tondre. Yes. ಕೊಟ್ಟಿದ್ದೀರಾ ಮೆಮೊ? Yes. ನಾವು ಸೇಲ್ ಯಾವ್ದು ಕೊಟ್ಟಿದ್ದೀರಾ ಈಗ? ಸೇಲ್ ಇವತ್ತು ನಾಳೆ ಸೇಲ್ ಯಾವ್ದಿದೆ ಕೊಡಿ. ಇವತ್ತು ನಾಳೆ ಸೇಲ್ ಮಾತ್ರ. ಎಲ್ಲಿದೆ? ಸಪರೇಟ್ ಇಟ್ಕೊಂಡಿದ್ದೀರಾ ಮೇಡಮ್? ಅದು ಸೇಲ್ದಾ? ಇವತ್ತು ನಾಳೆ ಸೇಲ್ದ ಅದು? ಎಲ್ಲ ಒಟ್ಟಿಗೆ ಕೊಟ್ಬಿಟ್ರಂಗೆ ಇವತ್ತು ನಾಳೆ ಸೇಲ್ದು ಅಂದ್ರೆ. ಆಕ್ಷನ್ ಟುಮಾರೋ ಇರೋದು ಕೊಡಿ. Auction today, auction tomorrow, give it. What for feature, sir? Wait. All of you don't tell at once, yes. Can you be silent when somebody else is talking? Yes. 2:30. Now tell me. Yes, sir. Redelivery of possession. Comply ಮಾಡಿದರೆ entry ಮಾಡ್ರು. Tomorrow ತಗೊಳ್ಳಿ. ನಾಡಿದ್ದಾಯ್ತು ತಗೊಳ್ಳಿ. Give it. Give the memo. Yes. Pending matter. No dates on pending matters. Yes. Repossession. ಯಾಕೆ ಕೊಟ್ಟಿಲ್ವಾ? ದುಡ್ಡು ಕಟ್ಟಿದ್ದೀರಾ? ಗಿವ್ ಇಟ್, ವಿಲ್ ಸಿ. ಎಸ್. ಹೊರಗೆ ಮಾತಾಡಿ ಸರ್. ಯಾವತ್ತು ಮಾಡಿದ್ದಾರೆ? 18th. ಗಿವ್ ಇಟ್ ಟುಮಾರೋ. 2:30. ಕರೆಕ್ಟ್, ತೊಂದರೆ ಇಲ್ಲ. ವಿಲ್ ಸಿ. ಗಿವ್ ಇಟ್. ಪೆಂಡಿಂಗಾ? Monday, first. Vacating entry ಮಾಡಿದ್ರೆ ಕೊಡಿ. It will come on Wednesday or Thursday. Thursday, yes. Wait. Yes. What is that? Make a mention when that is called. Make a mention when that is called. Yes. ಕೊಡಿ ಸರ್. 1ನೇ ತಾರೀಕು ಬರುತ್ತೆ ಕೊಡಿ. ಯಾವತ್ತಕ್ಕೆ ಹಾಕಿದ್ದೀನಿ? ಈಗ ಅರ್ಜೆನ್ಸಿ ಇದೆಯಾ? ಎಲ್ಲಿಗೆ ಹೋಗ್ಬೇಕು? ಕೊಡಿ. ನಾಡಿದ್ದು ತಗೊಳ್ಳಿ. ಇಲ್ಲ 2:30ಗೆ ತಗೊಳ್ಳಿ. ಎಸ್. ಕಂಪ್ಲೈ ಆಗಿದೆಯಾ? ಸರಿ. Give it. Pending matter. 1st April. Yes. 2:30. Parole. Give it. Parole ಎಲ್ಲ Friday. ಈಗೇನು ವೆಕೇಟಿಂಗ್ ಸ್ಟೇನಾ? ಏನ್ ಬಂದಿಲ್ವಾ? ಆಯ್ತು, ನಾಳೆ ಕೊಡಿ. ಪೆರೋಲ್ ಟುಮಾರೋ ತಗೊಳ್ಳಿ. ಆಯ್ತು, ಪೆರೋಲ್ ತಗೊಳ್ಳಿ. ಏನೋ ಕರ್ಗ ಕೊಡಿ ಎಲ್ಲ. ಗಿವ್ ಇಟ್. ಎಸ್. They have to, without any number, don't give it. Take it back. Don't throw anything that you find to this court. Yes. All right. When was that done? When was that done? Huh? Give it tomorrow. Karga matters alla kodi. Yes. Karga tomorrow alla. Tomorrow. Yen surface act. Vacating stay na. Kodi. 2:30. Pending fresh. Give it, yes. Yen parvaila. Yes. Give all the memos there. Fresh matter, yes, except surface, no other matter I'll take. Give it, yes. Huh? Sorry? ಏನು ಯಾವತ್ತಾಗಿದೆ? When? I know that. When was it issued? Give it tomorrow. 27th, tomorrow. Already appointed. Pending. First. Already appointed. ಆಯ್ತು 2:30 ತಗೊಳ್ಳಿ.
There is a tender called without marking my boundaries, my lord. The action is on 28th.
Yes.
Urgency that is being worship, I have given my objection to respect to selection of one of the bidder. In spite of that, my tender has been rejected on 17th. So because of the shoe 30.
ಆಯ್ತು ಕೊಡಿ.
Petitions are aggrieved home buyer. It's a pre-EMI matter. It was supposed to be listed today. Not there. If it might be.
First.
Threat of disposition.
ಏನ್ ಡಿಸ್ಪೋಸಿಷನ್
Disposition.
ಅಂತ ಅದೇನ್ ಇರೋದಿಲ್ಲ ನಿಮ್ ಕೇಸಲ್ಲಿ.
Public premises eviction act, my lord.
ಎಲ್ಲಿ ಯಾವ ಶಾಪ್ ಅಲ್ಲಿ ಇದ್ದೀರಾ?
My lord, the shop premises belonging to
Where?
Balabhavan, my lord, Tumkur.
ಬಾಲ್ಭವನ್ ತುಮಕೂರ.
Please, my lord.
ಯಾವತ್ತು when is the contract over?
Earlier, my lord, last month it was over. Earlier, my lord, notice was issued. Challenging that, I preferred a writ petition. Now, during the pendency of this writ petition, matter is not yet posted. One more notice is issued, directing us
2:30
to
ತಗೊಳ್ಳಿ. ಅದ್ರಲ್ಲಿ FR ನಂಬರ್ ಆದ್ರೂ ಇದೆಯಾ ಇಲ್ವಾ?
writ petition number.
ಹಾ ಕೊಡಿ.
My lord, without issuing show cause notice, my lord.
Wait, I'll come back. Yes.
Electricity is disconnected, my lord.
My lord's one.
2:30.
My lord's matter for 2:30, my lord's tender matter, I've submitted my financial bid as well, my lords. But in terms of the square meter, I've quoted, whereas the other two
How do you
tenders.
know you'll be rejected?
My lords, the other two tenderers have quoted in lump sum, my lords. Now, my lords.
What is the ground for 2:30? Nothing.
my lords,
How do you know everything? Codes of everybody, financial codes of everybody?
As terms of the query that was raised by them, they've submitted, my lords. Now, if it's not taken up at 2:30, my lords, they'll start issuing the work order. my
Very
lords.
good. Yes.
My
2:30 ಕೊಡಿ. Yes. Pending matter memo ಕೊಡಿ. No, sir. Give the memo, sir. Pending matter seniority ಪ್ರಕಾರ ಪೋಸ್ಟ್ ಮಾಡಿಸ್ತಾ ಇದೀನಿ. Give it. Yes. No, sir. You'll get, all of them will be listed according to seniority. Yes. ಅದು ಕೊಡಿ. Covered.
DMKB matter, electricity.
This is
Legal.
Wait. I'll come back. Give the memo.
Position notice.
ಯಾವತ್ತು ಕೊಟ್ಟಿದ್ದಾರೆ?
18th.
ಹಾ?
18th.
Give it.
Two matters is there.
Tomorrow.
Possession is taken, my lord.
Already taken?
Already taken.
First.
Electricity.
1st April.
Third time moving the memo, my lord.
ಆಯ್ತು 2:30 ತಗೊಳ್ಳಿ.
My lord, stamp act matter, my lord, covered judgment, 2005 agreement of sale.
April 2nd.
Please. Date.
Executive officer.
Huh?
Chief executive officer heard this matter.
Of,
The temple mail, other day mail.
all right.
Chief executive officer. Submit an officer. Festival, annual festival, 5 AM it starts.
Pending matter.
Pending and you are also direct to the post in fresh matter. After no
ಈಗ ಇವತ್ತು ಸ್ಟಾರ್ಟ್ ಆಗುತ್ತಾ?
ನಾಳೆ ಬೆಳಿಗ್ಗೆ 5 ಗಂಟೆ.
ಆಯ್ತು ಕೊಡಿ 2:30 ತಗೊಳ್ಳಿ.
Because lift irrigation matter, we are trying from last 1 month, some urgency.
1 month ಇಂದ ನಾನು ಕೂತೇ ಇಲ್ವಲ್ಲ? All right. ಅದು VC, please be quiet. Yes. ಆಯ್ತು ಕೊಡಿ ಅದು. 1 minute. Yes. Fresh pending. First. First. First April, kodi. Pending matter. 2nd April, give it. Yes. No, I thought it was the 9th April, give it. No. 3rd April, all right, give it, yes. Why? That's all right. Adu 2:30 yake? Nale, yes. Which one? Where is your memo? Yes, possession 2:30 ga. FR, go and comply. Yes. Then fine, it will come, leave it, yes.
My lord, it's
Don't come in there. Right? You're developing a bad habit. Go, come, be there only. I'm telling you, counsel. Don't come in there. Yes. Covered by judgment. First ವರ್ಗ ಆಗಲ್ವಾ? ನಾಳೆ ಕೊಡಿ ಆಯ್ತು. First. ಅದೇ first or second, yes. ಕರ್ಗ ಮ್ಯಾಟರ್ ಎಲ್ಲ ಕೊಡಿ 2:30. Which bank is that? Indian Bank. What bank wants to indulge into bodybuilding? Anyway, give it. Tomorrow.
The fresh matter, national highways were built.
First. Give it. Infectious, sir. 2:30. Yes.
Renewal of passport, my lord. I not have heard this matter. Some urgency, my lord. Renewal.
We'll have it tomorrow.
Day after.
Day after tomorrow. All right.
Pending matter, 482 your lordships had.
Second or third, give it.
Fresh.
Wait. Yes.
Second.
My lord, stay vacating up with it.
Kodi. Yes.
A fresh matter, my lords, is a tenant.
First.
Possession has been taken by the bank.
Taken already. Yes.
ಅಲ್ಲ printing press ನಡೆಸ್ತಾ ಇದ್ದಾರೆ. Everything is materials, machines, everything is locked.
Kodi. Yes. 2:30.
Tomorrow.
2:30. Yes.
Obliged.
Disconnected. Right. Give it tomorrow. ಕೊಡಿ ಆಯ್ತು. ಫಸ್ಟ್ ಬರುತ್ತೆಲ್ಲ ಕೊಡಿ. ಅದ್ರಲ್ಲಿ ಏನ್ ಅರ್ಜೆನ್ಸಿ ಇಲ್ಲ ಕೊಡಿ. ಎಸ್. ಏನ್ ಕಟ್ ಮಾಡ್ತೀರಿ? ರಾಯಲ್ಟಿ ಕಟ್ ಮಾಡ್ತೀರಿ, ಎಲ್ಲ ವಾಪಸ್ ಬರುತ್ತೆ ಬಿಡಿ, ತೊಂದ್ರೆ ಇಲ್ಲ. ನೋ ಪ್ರಾಬ್ಲಮ್. ಫಸ್ಟ್ ಹಾಕಿ ಅದು.
Matter, there is issue of extension.
Pending matter.
Matter also. 5th move ಮಾಡಿದೆ. 18th.
ಪೆಂಡಿಂಗ್ ಮ್ಯಾಟರ್ 3rd April. ವೈ ಪೊಸೆಷನ್ give it 2:30. Yes. ನಾಳೆ ಆಗ್ಬೋದಾ? Yes.
My lord,
Pending matter, my lord.
Give it. Pending matters ಕೊಡಿ ಅಲ್ಲ.
my lord, fresh matter.
my lord,
Third or fourth will post. Give it. Pending matters I'm posting according to seniority. There should be some method in there. It will become chaotic. Give it. No problem, sir. Give it, sir. Yes. ನೀವು 10ನೇ ಸರಿ ಮೂವ್ ಮಾಡಿದ್ರೆ ಸೀನಿಯಾರಿಟಿ ಫ್ರೆಶ್ ಮ್ಯಾಟ್ರಾ ಕೊಡಿ. FR ಕಂಪ್ಲೈ ಆಗಿದೆಯಾ? FR ಕಂಪ್ಲೈ ಆಗಿದೆಯಾ? ಕೊಡಿ. ಕಂಪ್ಲೈ ಮಾಡಿ ಹೋಗಿ 2:30 ತಗೊಳ್ಳಿ. ಆಯ್ತು ಕೊಡಿ. ಬಟ್ ಗೋ ಇಫ್ ಕಂಪ್ಲೈ ಆದ್ರೆ ಮಾತ್ರ ಬರೋದು.
My lord, fresh matter. In
First April. 1st April, sir.
My lord,
1st April will list it. We'll list it on 1st April. Don't worry.
My lord, this is a pending matter, my lord. I seek for
ಟ್ರಯಲ್ ಕೋರ್ಟ್ ಯಾವತ್ತಿದೆ ಸರ್? 24th ಇವತ್ತು. ಆಯ್ತು ಅದು ನಾಳೆ ಟುಮಾರೋ ಹಾಕಿ ಮೇಡಮ್.
my lord, this is a
You have joined now, wait. Yes.
my lord, this is a pending matter, my lord. I'm seeking for first week of April. The urgency is, my lord, that the bank, my lord, was supposed to give an NOC pursuant to a settlement. That NOC is not being given, my lord.
1st April.
Much of,
my lord, this
First
is
or 2nd April.
much of.
fresh application, it's a parole. Mother is.
First.
in IC.
ಪೆರೋಲಾ?
Mother is in IC.
ಪೆರೋಲಾ?
Mother is in IC.
ಬೇರೆ ಪೆರೋಲಾ ಅಂತ ಕೇಳ್ತಾ ಇದ್ದೀನಿ. ಕೊಡಿ.
Matter
Tomorrow.
pertains to financial aid to manual scavengers. They cannot even afford basic necessities.
Correct. You have
Government
been
is
moving this for the 3rd time.
They're pressurizing them to withdraw the matter, my lord, the government.
You wanted it 2:30 or tomorrow?
My lords, tomorrow, my lords, is extreme.
ಅದು
urgency.
ಮೇಡಮ್ ಅದು ಹಾಕಿ tomorrowಗೆ. In whatever stage it is posted tomorrow.
Dharwad page matter.
Friday. Give it.
Pending matter.
Tomorrow, give it, yes. Parole. 1st April. KDB allotment. Men and material. With men, material, machinery. Oh, you are attacked by triple M now. Early Kodi. Yes.
Mallards.
2:30. Tomorrow, na?
Mallards.
Fresh matters all first Kodi. Sak in the memos.
Pending matters, it's maintenance of senior citizen, Mallards.
Maybe, sir. 1st April. 1st April.
My lords, this matter pertains to nomination of syndicate members to the university.
Fresh matter.
No, my lords.
Pending, give it, yes.
My lords,
pending
those
matter,
who are
madam.
not eminent educationist, they
We'll
have been
see, we'll
nominated.
see, yes. Ado, selection it tagoli, it should not become infructuous later. Ad tagoli madam, 3rd April haki.
Pending matter.
Give it. Pending, 1st April. 1st April, yes. Compassionate. Friday. Yes.
May I make a mention, Madam?
I didn't see you, sorry.
No, I can understand, but but
Further hearings?
He Russian, but he should not.
May I make a mention, Madam?
Yes, sir. Dharwad, wait. No.
Please, Madam. Memo for posting, Madam. Pending matter pertaining to outsourced employees.
Friday.
Please, Madam.
Even Nadaf, Nimdo Friday.
Milords, ali, adu 2 advocates matter, Milords.
What happened to that?
you're
I'm moving a memo today, Milords. Abhishek Patil, my friend is there, Milords.
I thought if he has moved the memo, I will take it.
Please, sir, please.
Yes. That in fact I had written as heard in part.
Yes, Milords.
Yes.
Grateful.
We'll begin with this today.
yes. I have a written note on my submissions.
Yes.
There's one additional note given by Mr. Prasanna. And
Yes,
then I have
sir.
a comparative chart of the various statutory provisions.
Yes.
I have an index at the beginning of my written note, my lords. My first contention is this, that the pardon grant, I'm sorry,
Yes, sir. Very. Yes, sir.
pardon granted by the special judge would neither be under 306 nor 307, but it would be under section 5(2) of the Prevention of Corruption Act. which is a
Prevention of
special-
Corruption Act.
Yes. Kindly have a look at section 5(2) of the Prevention
Whatever.
of Corruption Act, which is there in my comparative statement.
Yes. But the judge has granted it under 306 and 307.
Section he may mention, but essentially the power flows from 5(2). Whether it is the alternative submission is, it could be 307, but my main contention it is 5(2).
Under 5(2).
Kindly have a look at the last page of my statutory provision, the landscape page, my lord. Landscape page,
A landscape page.
where I've extracted.
Comparative
the
chart. Is this the one, sir? Yes.
What, the last page of that, those
CC
statutory
Act,
provisions.
yes. Sir.
But earlier, it was before the 1988 Prevention of Corruption Act, the powers were conferred under the Criminal Law Amendment Act of 1952,
Yes.
Section 8. That I've extracted on the left-hand side column,
Yes, it's here.
because some judgments refer to Section 8, some judgments refer to 5(2). Now kindly have a look at Section 5, my lord, of the Prevention of Corruption Act. A special judge may take cognizance without the accused being committed to him for trial, and in trying accused person shall follow the procedure prescribed by the Code of Criminal Procedure 1973 for the trial of warrant cases by magistrate. Then subsection 2, which is important. A special judge may, with a view to obtaining the evidence of any person supposed to have been directly or indirectly concerned or in privy to an offense, tender a pardon to such person on the condition of his making a full and true disclosure of the whole circumstance within his knowledge relating to the offense, and to every other person concerned, whether as a principal or an abettor, in the commission thereof, and any pardon tendered shall, for the purpose of subsection 1 to 5 of 308, only for that limited purpose, 1 to 5, 308 of the Code of Criminal Procedure, be deemed to have been tendered under section 307.
So only for the limited purpose of punishment of 308 section, it is treated to be under 307. Otherwise, it's a pardon granted under 5.2. Now kindly have a look at subsection 3. Save as provided in subsection 1 and 2. The provisions of the Code of Criminal Procedure shall, so far as they are not inconsistent with the Act, apply to the proceeding before a special judge. So 1 and 2 are saved. Therefore, if 2 applies, the provisions of CRPC do not apply. Therefore, 306 and 307 will not apply excepting for the limited purpose for the purpose 308. For the purpose said, the court of special judge shall be deemed to be a court of session, and person conducting a prosecution before a special judge shall be deemed to be a public prosecutor. So the submission is this: when a special judge, it is not disputed that the tender of pardon has been given by a
Special judge, yes.
who is appointed under the Prevention of Corruption Act. When he gives pardon, he gives by virtue of powers conferred to him under section 5, subsection 2. And subsection 3 says that other provisions will apply, but for 5, 1 and 2 are saved from the application of CRPC. So essentially, it is a pardon tender under 5.2, whether section nomenclature doesn't change. Now kindly have a look at 2 judgments on this point, which are citing, my lords.
You've given?
Now the 2 judgments, the proposition for these 2, the principle of these 2 judgments are when there is a special law, the special law will prevail and the general law will not prevail. But when there's a conflict between the special law and general law. But here the special law says that CRPC will not apply where 1 and 2 applies.
Yes.
Now kindly have a look at my note, my main argument note about 2 judgments which I've cited at page number 3. It's there, compilation is there, but Suresh Nanda versus
Suresh Nanda, yes.
Suresh Nanda versus CBI.
Given a compilation to the court, given a
Compilation is given?
So it's given,
Compilation
it's
is given,
here,
Judge.
it's here.
But I've extracted, so no
It's
need
here,
to.
extract is also here.
The compilation is also given
Yes,
separately.
yes.
Kindly says Suresh Nanda versus CBI, which is there in extracted at page 3, my lords. Thus, the act is a special act relating to a matter of passport, whereas section 104 of CRPC authorizes the court to impound document or thing produced before it. Where there is a special act dealing with a specific subject, resort should be had to that act instead of the general act providing for the matter connected with specific act. As the Passports Act is a special act, the rules that general provision should yield to the specific provisions is to be applied, then etc.
Now, Prevention of Corruption Act is a special act, so that will prevail over the CRPC, the submission.
That's
Yes.
the first submission. There's another judgment. I need not bother
Yes,
my lord
yes,
with that.
yes, yes.
Now, the alternative submission is this. Assuming that my lords hold that 5.2 is not applicable. Now, kindly have a look at 306 and 307. It is there in my statute also. 306 and 3.
Yes.
I'm coming to 307 first, my lords.
Yes.
Which is on 3rd page of my landscape.
Yes, sir.
So kindly compare it with the wordings of the previous section 5.2, my lords. They're almost identical excepting the stage.
Yes.
At any time after commitment of the case.
Yes.
Whereas 5.2 says, doesn't use the word after commitment.
There is no committal here.
There's no committal here.
Yes.
There could be a committal, but we are not considering in the particular case.
There is no committal in this.
Yes.
Yes.
Now, as far as the special judge is concerned, now kindly, before the judgment, the court to which the commitment may with a view to obtaining at the trial the evidence of any person supposed to have been directly or indirectly concerned in or privy to any such offense, tender a pardon on the same condition as such person, my lord. Now kindly look here, my lord, as far as 5.2 is concerned.
Yes.
With a view to obtaining that same, with a view to obtaining the evidence of any person supposed to have been directly or indirectly concerned. That is also same as far as 307 is concerned, or privy to an offence, tender pardon. My lords have got it?
Yes, yes.
Tender pardon on the condition of his making full and true disclosure of the whole circumstances within his knowledge relating to the offence and to every other person concerned, whether as principal or an abettor. Therefore, whether as principal or abettor is there in 5.2, but it is not there in 307. Therefore, what 5.2 essentially does is, it incorporates provisions of first subsection 1 of 306, full disclosure, etc., incorporated, which is not there in 307. 307 says in the same condition. Now, 307 has been interpreted same condition means only subsection 1, the other subsection do not apply.
Yes.
So whether it is 307 or 5.2, now kindly have a look at my written submissions of page 4, D, my lord. Neither section 306 nor 307 uses the special judge, and there is no commitment in a case of a special judge. Therefore, 307 will not apply to a special judge, it's a 5.2. 5.2 is a code in itself. It doesn't say that provisions of 306 apply, unlike 307, which says on such terms. Yes, I'll come to that. On same condition to such person. Those words are missing because those conditions are incorporated in 5.2.
Those are missing in 306 and 307.
307, the same, on the
307.
same condition is missing because 307 has a reference to 306 because
Yes.
it uses the word
Conditions
same,
are there.
same condition.
So 5.2 does not.
Therefore, a controversy had arisen. Well, what do you mean by same controversy? Whether all the provisions apply or not, which has been settled by the Supreme Court. But in 5.2, there is no such thing as same condition. The condition has been bodily lifted and incorporated in 5.2. Therefore, if 5.2 applies, there is no question of recording any reasons. There is no question of giving any copy. All that is not required. This is the first submission. The alternative submission is, let us assume that 307 applies. Then also, the application of 307 does not mean that all the conditions of 306 would apply. What are the conditions that apply? Kindly have a look at Pascal, which is cited by them.
Pascal Fernandez.
Pascal Fernandez. Now kindly have a look at page 4, last paragraph.
Yes, sir.
Refer to para 10 and 11 of Lieutenant Commander Pascal, para 10. When the case is before the special judge, the tender of pardon can only be by the special judge and is deemed to be under 338. 338 is similar to my main note, my first note.
The comparative chart,
No. The main submission.
landscape.
The first one, first submission.
Yes,
Wherever.
sir. Yes.
Kindly go to page 4, my lord.
Yes.
Therefore, Pascal says 338. Therefore, I am saying, let us assume that 337 applies, 307 applies, because Pascal says 338.
Yes.
Pascal has not gone into the question of whether special law, general law is not gone into by this Pascal judgment. By E, my lord, E at page 4, my lord. Refer to paras 10 and 11 of Lieutenant Commander Pascal Fernandez of the state of Maharashtra. My lord, I've extracted para 10. When the case is before the special judge, the tender of pardon can only be by the special one and is deemed to be under 338 for the purpose of 339 and 339A. So for the purpose of 339 and 339A, which is 308 under the new under the CRP symbols. As explained, the fiction is necessary because no committal proceeding is necessary before a case is sent to special judge. The words underlined by us in 337.1 cannot apply to a tender of pardon by a special judge, as some of the words of 338 do not apply to them. 337 is 306, my lord.
Yes.
It follows that the powers of special judge are not circumscribed by any condition except one, namely that the action must be with a view to obtaining the evidence of a person supposed to have been directly or indirectly concerned in or privy to an offense. So that is the only condition with which the special judge is concerned. 5.2 also says the same, my lord. The pardon so tendered is also on condition of his making full and true disclosure of the whole circumstance within his knowledge relating to the offense and to every other person concerned, whether as a principal or abettor, the disclosure must be complete as to himself and as to any other person concerned as the principal abettor. There is no provision for recording of reasons for so doing, nor is the special judge required to furnish a copy to the accused. Now, this requirement is because of 306. Kindly now fall back to 306. The requirement of recording of reasons and furnishing a copy flows from subsection 3A. Kindly come to 306, my lord.
Yes.
Now kindly have a look at subsection 3 of 306. Every magistrate who tenders a pardon under subsection 1 shall record his reasons for doing so. Supreme Court in Pascal, 3 judges say not required. Therefore, subsection 3 doesn't apply. Whether tender was not accepted by the person to whom it was made, not required because that condition is not applicable. The acceptance is not a part of, which is part of 306A, is not a part of 307. Even the deeming fiction of as such conditions will not include this condition. And shall on an application made by the accused furnish him with a copy of such record free of cost. This does not apply to a tender of pardon under 5.2 or under 307. Now kindly have a look at now para 69 of Srinivasulu, which I've extracted.
Yes, Srinivas.
I've done this so as to save the time. Otherwise,
Yes,
I take
sir.
my
Yes,
notes.
yes. That will in fact save a lot of time.
Yes.
Yes.
Para 69 is extracted.
Yes, yes.
In contrast, section 5 subsection 2 of the PC Act does not speak about a stage at which pardon may be tendered by a special judge. This is perhaps in view of the express provisions of subsection 1 of subsection 5, which empowers the special judge himself to take cognizance without the accused being committed to him for trial. But the second part of subsection 2 of section 5 of the PC Act creates a deeming fiction that the pardon tendered by the special judge shall be deemed to be pardon tendered under section 307. However, as rightly contended by the learned senior counsel, this deeming fiction is limited for the purpose of subsection 1 to 5 of 308. So that fiction of application of section 307 is only for the purpose of 308, where a person resides from. So only for that limited purpose 307 applies. Otherwise, it is only a
yes,
only a pardon which is tendered under 352. And 5.2 does not require any giving of copy, recording of reasons, etc., which is required under 306. 5.2 is a code by itself. It's a special law that will prevail. So all arguments regarding the procedure with the procedural aspects do not apply in the case of a pardon tendered under 5.2. Thus, the deeming fiction under 5.2 of the PC Act is only for the restrictive purpose 308 of the code to lay down the consequences in case the approver does not comply with the tenders of pardon. The power is drawn from 5.2 of the Act. The only condition common between 5.2 of the Act and 306 is full and true disclosure for the whole circumstances within his knowledge relating to the offense and every other person concerned, whether principal or abettor, in the commission. This is the only thing common between 306 and 5.2. That is the only thing that is required. Now, the alternative submission is in case my lord holds. Don't know, it is not a pardon under 5.2, it is pardon under 307. Then my alternative argument is argument 1A. Even if it is 307, the conditions other than the first condition do not apply. So both my submission is 5.2, conditions other than the first condition do not enter. The first condition is incorporated in 5.2. 307, they are not incorporated, but such conditions has been interpreted by the Supreme Court, and such conditions as interpreted by the Supreme Court are concerned. The first part of 306 is applicable, other part, procedural parts, are not there when the tender is accorded. Tender of pardon is accorded by the court under 307.
Yes.
Now kindly have a look at my second submission. Without prejudice to the condition that pardon can be granted only under section 5.2 of the PC Act 88, it is presumed, and it is presumed the sanction is under 307 of CRPC or 434 of BNSS. 434 is then also it would make no difference in the, as the present matter is, as far as the present matter is concerned. I'll tell my lords why. Section 307 reads as follows. The word same condition to such person indicates the conditions which are there in 306 would apply. Rest of the portion being procedure and not conditions would not apply. What is the condition in, therefore, kindly now have a look at 307, my lords.
Yes.
Come back to the third page of my landscape page, my lord, where statutory provisions are there. 307 is in the middle, my lords.
Yes.
At any time after commitment of a case, but before a judgment is passed, the court to which the commitment is made may, with a view to obtaining at the trial the evidence of any person supposed to have been directly or indirectly concerned in or privy to such an offense, tender a pardon on the same condition to such person. What is the meaning of the same word, same condition in 307? Does it mean all 1, 2, 3, 4, 5 of 306 or only one subsection 1 of 306? According to me, it's only subsection 1. Now kindly therefore have a look at two judgments in this connection, my lord. Kindly turn to my written submission, page 6.
Yes.
So one has to interpret, and it has been interpreted. What do you mean by same condition? So there are several things which 306 requires. Not only tendering pardon, supply copies, record reasons, etc. Is it required? Now kindly have a look at Srinivas Sulu's judgment first, my lord.
Paragraph 80.
Paragraph 80.
Yes.
Therefore, it is clear that when the special judge chooses to take cognizance, the question of approver being examined as a witness in the court of magistrates as required by section 3064 does not arise. Therefore, he need not be examined. Otherwise, if it was under 306, he has to be examined because it is a condition of 306 subsection 4A. So that is not required. See, Padmesh Mishra, learned counsel to the respondent, is therefore right in relying upon decision of this court in Sardar Iqbal Singh and Abdul Razak so and so. In Sardar Iqbal Singh, the offence was triable by a special judge who took cognizance. Therefore, there was no committal proceeding. Though Sardar Singh arose under the 1898 code, subsection 2 of 337, which was pari materia to section 306 4A of the joint. Therefore, the ratio laid down in Sardar Iqbal Singh was rightly applied in Yaqub Singh's case for coming to the conclusion that where a special judge takes cognizance of the case, the occasion for examining the approver as a witness arises only once.
Yes.
Now, Devendran goes against me on 1 or 2 points, my lord, that as far as 460G is concerned, but since it applies to me.
Subsection 1, that's all.
Yes, sir.
Concerning subsection 1, interplay between 306 and 307 is what you want. Yes.
But there is one point regarding 460G, which I argued on the last time.
Yes.
It goes against me.
Yes.
Therefore, because it says that it applies only to a pardon under 360.
Yes.
So 306. So I must fairly state this, my lord. Reference may be made to A. Devendran versus State of Tamil Nadu, the para 11. The correctness of the rival submissions again would depend upon the true interpretation of section 306 and 307 of the code. Under section 307, when pardon is tendered after commitment of the proceedings by the court to which commitment has been made by the legislative mandate, either the pardon would be tendered on the same condition. The expression of the same condition obviously refers to the condition of tendering pardon engrafted in subsection 1 of section 306. The said condition being that the person concerned makes a full and true disclosure of the whole of the circumstances within his knowledge relating to the offence. Subsection 4 of 306 cannot be held to be a condition for tendering pardon. A combined reading of subsection 4 of 306 and 307 would make it clear that in case exclusively triable by the Sessions Court, if accused is tendered pardon and is taken as approval before commitment, then compliance of subsection 4 of 306 becomes mandatory. Non-compliance would be issued the proceeding. But if an accused is tendered pardon after commitment of the court by the court to which the proceedings committed, the exercise of powers under 307, then in such a case, the provisions of subsection 4 of section 306 is not attracted because it's a procedure, it is not the condition. The condition is only there in subsection 1. That, my lords, may, at the cost of repetition, my lords may say, the para 11, the first part which I've said.
Pascal Fernandez.
Obviously refers to condition engrafted in subsection 1. That is the only condition which is meant by same condition in 307. becomes mandatory. But if an accused is tendered pardon after commitment by the court to which proceedings is committed in exercise of powers and treason, in such a case, the provision subsection 4 of this would not be attracted. The procedural requirements for all procedural requirements, including 3064A to examine the accused after tendering pardon, cannot be held to be a condition of grant of pardon. The case in Suresh Chandra Bari versus on which the learned counsel for the appellant strongly relied upon deals with the case where pardon has been tendered to an accused before commitment proceedings. So they have relied on Suresh, heavily relied on Suresh Bari. It doesn't apply. And the question whether non-compliance of 4A of section would vitiate the trial. The court held that provisions contained in subclause A of subsection 4 of section 3 is mandatory in nature, and therefore non-compliance of the same would render that order of commitment illegal. It is no doubt true, as contended by so-and-so learned counsel appearing for the case, that the procedure indicated in subsection 4A of the code is intended to provide a safeguard to an accused inasmuch as the approver has to be make a statement disclosing his evidence at the preliminary stage before the committal order is made, and thereby the accused becomes aware of the evidence against him, and further such evidence of an approver can be ultimately shown as untrustworthy during trial when the said approver makes any contradictions or improvements to his earlier version. The same arguments canvassed by the other side. But still, when the legislature in section 307 has made specific reference only to such conditions and not to any other other procedures in section 306, it would be a rule of interpretation to hold that even subsection 4A of 3 would also be, it would not be a rule of interpretation to hold that even subsection 4A would be applicable to such a case. Then, my lord, Pascal again, my lord, kindly have a look at Pascal para 11. It follows that powers of special judge are not circumscribed by any condition excepting one, namely that the action must be with a view to obtaining the evidence of any person supposed to have been directly or indirectly concerned in or privy to an offense. So only one condition, this is the only condition, not recording of reasons, not giving a copy, other 3A, 3B not required. Only one condition. The pardon so tendered is also on condition of his making a full and true disclosure of the whole circumstance within his knowledge relating to an offense and to every other person concerned, whether as principal or abettor. Disclosure must be complete as to himself and as to any other person concerned as a principal or abettor. There is no provision for recording of reasons for so doing, nor is the special required to furnish a copy. So 4A, 4B do not apply. 3A, 3B, I'm sorry. The last conditions, these last conditions referred to in 3063. So 3063 is not applicable because it's procedure, it is not a condition. Despite the fact that the concerned court did not take on its proprietary of tendering pardon, the Supreme Court, that is not necessary for the court which tenders pardon go into the proprietary once the process. That is a different point. This line has been wrongly stated here, but I'll come to that a little later. A lot was said. The trial court must look at the evidence, decide whether there is sufficient evidence or not. And then, my lord, the court which tenders pardon must see that there is no sufficient evidence, therefore approver's evidence is required. So detailed analysis of what the approver has to say, detailed analysis of the evidence is there in the court has to be made before tender of pardon is required to be made. Now in Pascal's case, such an inquiry was not made. What one of the contentions is trial court has not done this. The Supreme Court says it is not. Supreme Court says when the court which tenders pardon accords tender, it is actually acting on behalf of the prosecution. When it is acting on behalf of the prosecution, if prosecution says we consent to the granting of pardon, then that's the end of the matter. The court need not examine this aspect whether evidence is sufficient required to be examined. Now kindly have a look at 3 or 4 paragraphs of Pascal, my lords. 2A, my lord. Supreme Court has held in Pascal's case that the application not tendered by the prosecution, the special judge by deciding to accord tender pardon, essentially performing the role of the prosecution, which is a role which it should avoid. Such a role being the role of the prosecution, consent given the prosecution would do away with the requirement of the special judge in going into the issue of examining whether the tender of pardon is required in the facts of the case. In fact, in Pascal case, in the High Court, the prosecution has given the consent which was relied upon to overcome the hurdle of court having not gone into the propriety and the extent of culpability of the person to whom the pardon is granted. In this regard, reference may be made to para 15. Directly on the point. Ordinarily, it is for the prosecution to ask for a my lord, sir, I'm sorry.
Yes.
Ordinarily, it is for the prosecution to ask that a particular accused out of several may be tendered pardon. But even where the accused directly applies to the special judge, he must first refer the request to the prosecuting agency. It is not for the special judge to enter the ring as a veritable director of prosecution. The power which the special judge exercises is not on his own behalf, but on behalf of the prosecuting agency, and must therefore be exercised only when the prosecuting agency joins tendered pardon, because it does not need approver's testimony. It may also not like the tender of pardon to the crime or the worst offender. The proper course for the special judge is to ask for a statement of the prosecution on the request of the prisoner. If the prosecution thinks that the tender of the pardon will be in the interest of a successful prosecution of those other offenders whose conviction it is not easy without approver's testimony, it will undutifully agree to the tendering of the pardon. Prosecution says court has to agree. The special judge must not take up on himself the task of determining the propriety of tendering pardon in the circumstances of the case. The learned special judge did not bear this consideration in mind, took on himself something from which he should have kept aloof. All that he should have done was to have asked the opinion of the public prosecutor on the proposal. But since the public prosecutor, when appearing in the High Court, stated that the prosecution also considered favorably to tender the pardon to Jigashia, who was the approver there, we say no more than to caution the magistrate and judges. Therefore, the Supreme Court disallowed this contention. That the magistrate, therefore, when the prosecution joins in the tender of pardon, a request for tender of pardon, that exercise which my learned friend said the court has to undergo, which has to undertake, is not required to be undertaken. And in this case, the prosecution has consented to it. That's the end of the matter. Otherwise, the court would be required to function as a prosecutor. This is as far as the other this question is concerned. Now, kindly have a look at, they said acceptance of pardon. They said pardon has not been accepted. Therefore, the order is vitiated. Cases cited by them are all cases where the prosecution applied. Where the accused applies, there's deemed consent in the application itself. Now, kindly therefore have a look at the cases which they have cited. The cases where the prosecution applies, and in one case where the prosecution applied, the approver said, I don't want to be an approver. Those cases can't be cited to buttress a submission where the approver himself has made an application. Now, kindly have a look at two cases, my lord. My submission number Roman 3.
Yes, it's a
Question of acceptance of pardon does not arise if the application is moved by the proposed approver himself. It is a claim of the opposite party that unless there is an express order or otherwise accepting the pardon granted to the proposed approver, the pardon so granted is not complete and bad in law. They rely on Bipin Chandra Sarkar and Santosh. Now, pausing here for a moment, my lord. Now, kindly have a look at 3063. The requirement of acceptance flows from 3063B,
yes.
which is not required to be complied because that's a procedural. Whether 307 or 52, this is not a part of 52, not a part of 307. Only subsection 1 is part of 307 and 52 not even subsection 1, only for the purpose 308, that's all. Therefore, this requirement that accepted which comes under 3A is not warranted by the reading of 307 itself and by reading of 52. Even if it is assumed to be warranted, then, my lords, the cases on which they relied upon are cases of prosecution mode. Now, therefore, kindly have a look at first Bipin Bihari Sarkar would reveal that the pardon application was moved by the prosecution in para 6 on 22/6/57. On 1/8, he was granted pardon. The accused thereafter claimed to have made a confessed statement as he was assaulted by the police, did not wish to become an approver. Now, facts of that case, he went and recorded his 164 statement. And then the courts, he said, I don't want to be an approver. There was no consent. Therefore, the argument was, if there is no consent, there can't be a prosecution. But that is a requirement of 306, not a requirement of 307 or 52, not a requirement where he has himself made an application. Second, my lord, Santosh Kumar Satish Barrier, that page 190 of volume 6 of their compile would reveal that again the application of pardon in 307 it was moved by the police inspector. Pardon was granted in 306. Reliance on para 30 merely reiterated the conditions already there in 306. The pardon was 306 compliance. There is no requirement of any compliance. Then B, in the instant case, the application pardon is made by the accused himself, that the aforesaid judgment do not help the opposite party at all. Now, I'm sorry, madam. Kindly have a look at the highlighted portion of the earlier subsection 4 of 306 is procedural in nature.
Yes.
Now, therefore, kindly have a look. Is procedural in that procedure doesn't apply when it is 307. The condition mentioned in 307 refers to condition as laid down in subsection 1 of 306, namely that the person in whose favor the pardon has been tendered will make full and true disclosure of the whole of the circumstances with his knowledge. Power of such session is not hedged by any other condition. There was a condition to accept the tender, etc. is not part of that. Is what I essentially. In the instant case, the application for pardon is made by the accused himself that the aforesaid judgment do not help the opposite party at all. There is deemed acceptance of pardon when the accused himself is moving the application. There is another thing, but he has entered into a box in support of the prosecution case. What more do you require for exceptions? Now then, my lord, the learned messages need not discuss evidence, need not go into issue of whether there is other evidence other than the approved evidence is sufficient for that. I've shown from Pascal, etc. I need not repeat that. Then for the purpose of tender of pardon, my lords, it is immaterial whether the person to whom that pardon is tendered is principal or abettor, my lords. That is mandated in the section itself.
Yes.
Kindly come back to the comparative chart, my lords.
Yes.
Kindly have a look at.
Yes, sir.
3061.
Yes.
Last 4 lines of subsection 1. Whether as a principal or abettor in commission thereof. This condition applies to 307. So it is immaterial whether the principal or an abettor. Now kindly come to 5.2, my lords. The last page.
Yes.
5.2 also says, uses the word, whether as a principal or an abettor. So it is immaterial whether it's a principal or abettor. Once the prosecution consents, that's the end of the matter. Now, my lords, may kindly have a look. The alternative submission is the facts of the principal case is the principal, not the abettor. For that, I'm relying on para 34 of Ashok Agrawal's case, which I cited on the last occasion, where lordships have held that the person who's a mercenary and goes to execute the murder is not the main accused, but the person who hatches the conspiracy, who gives the money, and who orders the carrying out of the murder is the main culprit, is the principal accused. The one supported by myself when I say that he's the main, the accused number 15 is the conspirators who had the conspiracy are the main person accused and not the person who has committed the murder. He may be given he may be a poor person, you may give him money, give him some money, give him some, say, I'll give you a job, etc. So he may be lured by that offer, but he has no motive, he has no intention, but he's only carrying out the, because for earning a few rupees. Therefore, he's not the principal offender. Huh? 34, I need not, because I've read earlier, my lord. Then para 5 of on this point, I have given two or three other judgments. Then my lord, change of circumstance. There are 3 or 4 points, my lord.
Change circumstance.
Yes.
Point number 6.
Yes, point number. The first principle is, I will not go as per my note, my lord, but I will just go up and down, change the sequence. My lords have seen Pascal's judgment. Pascal says consent of CBI is required. Therefore, if CBI consents, that's the end of the matter. Now, CBI never consented when the first application was given. When the second application was given, it consented only after the 164 statement came. The basis for the CBI to accord consent in the second application was the 164 statement, which my lords have discarded. The CBI consent was not there at the time of the first or second application, it came at the third application. This is a very vital and material change in circumstance. Number one, my lord. Second, my lords have held in the earlier judgment that threat is a change in circumstance. Therefore, threat is already there. That's a change in circumstance. Now, the third contention is the change in circumstance is all because of the principle of res judicata. Because once you have decided, then you can't have a second inning, third inning, fourth inning. But sir, in criminal matters, principle of res judicata does not apply. There are 3 or 4 judgments where I've cited what applies is issue estoppel. Issue estoppel is similar, but the issue has been decided. The matter, it's the particular issue for which the principle akin to res judicata would apply. I have 3 judgments cited in this connection, my lords. Change in service is required to overcome the hurdle of res judicata, strictly speaking. In criminal matters, the principle of res judicata does not apply. In this regard, reference may be made to Kalyan Chandra Sarkar versus Rajesh Ranjan. The principle of res judicata and such analog principles, although are not applicable in a criminal proceeding, still the courts are bound by the doctrine of judicial discipline regarding the hierarchical system prevailing in our country. Findings of a higher court or a subordinate must receive serious consideration at the hands of the court, entertaining a bail application. This was in connection with bail application. So strictly speaking, res judicata does not apply. Then, my lord, Devendra was the state of UP, para 25 extracted. Mr. Das, furthermore, would contend that the order of the High Court dated so-and-so would operate as res judicata. With respect, we cannot subscribe to that view. The principle of res judicata has no application in a criminal proceeding. The principle of res judicata, as enumerated in section 11 of the Code of Civil Procedure, or the general principle thereof, will have no application in a case of this nature. Criminal proceeding generally res judicata does not apply. If res judicata does not apply, then what would apply, my lord?
Issue
Before I go to that, even where res judicata applies, that is my third contention, it does not apply, my lord. May I read the third point?
Yes.
Even if res judicata is made applicable to criminal proceedings without admitting that it is so applicable, then also the principle of res judicata is not applicable in case of error of jurisdiction. In this regard, reference may be made to para 118 of Ashok Lenon's case. Principle of res judicata is a procedural provision. A jurisdictional question, if wrongly decided, would not attract the principle of res judicata. When an order is passed without jurisdiction, the same becomes a nullity. When an order is a nullity, it cannot be supported by invoking the procedural principles like estoppel, waiver, or res judicata. Question has since been considered in Ramnik, Vallabhdas Madhwani versus Taraben, where para 50. So far as the question of rate of interest is concerned, it may be noticed that the High Court itself found that the rate of interest would have to be determined 6 months. The principles of res judicata, which according to the High Court would operate in the case, in our opinion, is not every. Principles of res judicata is the procedural provision, the same as no application. Then Chief Justice Andhra Pradesh was Dikshitalu. As regards the above, Sri Vepa Sarthi appearing. Huh? Very well. Now, what has happened in the first 2 applications, Madam? First 2 applications is this. First application was not decided on merits. It was decided simply because the application did not contain the requisite requirements. Therefore, essentially a jurisdictional error.
Second application on procedural aberration. Yes.
It's fair is it that it has been decided on merits? It's only when it is decided on merit that the principle of res judicata applies. A person who wants to be an approver, his application in first instance is thrown out not because he's not competent to be an approver, because he has not disclosed certain things in his application. Second application is thrown out because the judge commits an error in referring him to 164. Therefore, these two orders cannot operate as res judicata, cannot operate as a bar. Where is the finding that he is not fit to be an approver? He does not do nothing on the merits of the matter. Therefore, the res judicata will not apply. Then my lords may come to my lords. Therefore, para 4 at page 14, for the doctrine of res judicata to invoke, there should be effectively be an adjudication on merits, and in absence of doctrine, in its absence, doctrine of res judicata is not attracted. I've cited 2 cases there, my lord, that my lords. Then issue estoppel. What is issue estoppel, my lords? The only principle is the principle of issue estoppel which may apply in criminal matters. Since the issue of merits has not been decided independently, the question of issue estoppel will not arise in the present case. Therefore, the issue regarding merits has not been decided. Therefore, issue estoppel, that issue has not been raised and not been decided in the first 2 applications. Therefore, the submission is that issue is open. There is no issue estoppel also in the present case. I have made reference to certain. Then what are the change in circumstances I have enumerated in paragraph 16? I have said threat is one, my lords. Then I have said, my lords have accepted, and they have not challenged that order of my lords, wherein your lordship, judgment of my lords, where my lords have said that threat is a change in circumstances. They have accepted it. And that threat continues, my lord. It's like a continuing offense. Then second is consent of CBI, my lord, that I've dealt with. The third is the difference in the contents of the application. First application was a bald application, nothing was mentioned. Second application was also similar, excepting there were 164 statement. The third application, one looks at the contents of the third application, contains in detail the role, etc. of the approver. Unlike a bail application, as I pointed out in the earlier occasion, approver there cannot be a change in circumstance that it has to come after the decision is made. Yes, when it is on merits, that's a different thing. But when it's not on merits, it's a different aspect. Then I've said, earlier order dated 4/12/24 did not set aside the order on merits, but mere technicality procedural lapses that is there in my application. And my next submission is third application is a mere continuation of the second application. My lords may kindly appreciate the order of this honorable court sets aside the order passed on the second application granting tender of pardon. The only ground on which the tender of pardon is set aside is because the learned judge relied on a 164 statement, which he could not have done. And therefore, my lords have not said that the second application was bad in law. There is no reference to the second application. On the contrary, my lords have said, go back and make an application. Therefore, essentially, the third application is a continuation of the second application. It is a continuation of the second application. It is in fact a continuation of the second application, because the second application was not rejected on merits. That I've said in para 19, my lord.
Yes.
Page 19.
Yes.
I have made, my lord. Now kindly have a look at page 20, my lord. F, my lord.
Yes.
Without prejudice above it is stated, principal changes may apply while moving the second application only and only if the first application has been decided on merits. In state of UP versus Kailash Agrawal, the first application for grant of pardon was made by respondent number 2 and 3. Therein, same was rejected by learned magistrate, see para 5. Second application moved by the state. Thus, the principle of change of circumstance was highlighted in para 15 of Kailashnath. The first rejection was decided the issue. So the two judgments cited by them. First is Kailashnath Agrawal. There, the decision was on merits, unlike the present case. Second, my lord, West Bengal versus Adisheshan. Specifically mentioned the earlier application of grant was decided on full consideration of the matter. So where it is decided on full consideration of the matter, the situation is different. In the instant case also, the first rejection of pardon dated so-and-so was an issue, was not an issue deciding on merits of the case. Therefore, principle of change of circumstances would not apply, making of the second application, etc. that I've stated in para 20, sub-para 3. My accused number 1 is still under the protective umbrella of CRPF, which the trial court has recognized. Therefore, threat continues. Imminent threat to his life. Large number of witnesses have turned hostile. That list is there in the list which is given by Mr. Prasanna, my lords. Then, my lords, there's a contention raised that there is sufficient evidence. A list of witnesses was tendered to my lords on the last occasion, wherein it was said that there is evidence, there are witnesses for motive, there are witnesses for the actual commission of the act. That, as I said, is not necessary in view of the fact that CBS consented. The second submission is this. The person is an approver, granted pardon as a tendered pardon as an approver, because for conspiracy, it is difficult for the prosecution to prove without the approver's evidence. My lords are aware that conspiracies are hatched in secrecy, and they're very difficult to get direct evidence of conspiracy. I have cited 2 or 3 judgments, Namlar and Popley, etc., that conspiracies. So there are compartments as far as the prosecution case is concerned. One is the actual act of murder, one is the act of conspiracy, one is one is where the guns are, etc., are obtained. So there may be, if the submission of what the other side has made, there may be evidence as far as one compartment is concerned, but there are different compartments where there is not sufficient evidence. Yes. Now kindly have a look at Ram Narayan Popley's judgment, which is cited at page 21. Privacy in para 347.
Yes, yes.
Privacy and secrecy are more characteristics of a conspiracy than a loud discussion in an elevated place open to public view. Direct evidence in proof of conspiracy is seldom available. Offenses of conspiracy can be proved by either direct or circumstantial evidence. It is not always possible to give affirmative evidence about the date of the formation of the criminal conspiracy, about the persons who took part in the formation of conspiracy, about the object which the objector set before themselves as the object of the conspiracy, and about the manner in which the object of conspiracy is to be carried out. And this is necessary as a matter of inference. So inferential evidence, which is circumstantial. Therefore, when the learned judge said circumstantial evidence, he was criticized a lot before my lords. But circumstantial evidence, as far as conspiracy is concerned, they said there is a witness who is witness to the actual incident of murder. Yes, but the part that there is part of the prosecution case which has to be proved by circumstantial evidence, which has to be proved by inferential evidence, is there, and for that purpose is a crucial witness. I'll come to that chart, my lord, a little later, my lords. So they have glossed over the fact of conspiracy and the evidence of conspiracy as far as even tendering of the papers, which according to me cannot be looked at this stage. But then locus standi, my lords. My lords have said that they are entitled to challenge the tender of pardon.
Only on procedural.
Only on procedural grounds.
In this case, there is no
There is no
procedural.
procedural grounds because procedure is 306(3)(4)(5), which is not applicable. So in a case where pardon is tendered on 307 or 5(2), there is no procedure. Therefore, there can't be a challenge on procedural ground. Therefore, they have no locus. That's my main submission. That is what I've stated, my lord, in my paragraph 18. That is going to be the gist of. Therefore, where is the procedure? Procedure, he did not record reasons. Procedure, he has not accepted. And this all proceed. This is not applicable in a case of 307 and 308. All other submissions which they made are on merits of which they are not entitled to. Now coming back to the other aspect, my lord, kindly have a look at the landscape note which Mr. Prasanna has prepared. Is that part you want to show me? Kindly have a look at first column, serial number 8. The contention that there is ample, my lords have got it?
Yes, yes.
The contention, that is their submission. First Second column is their contention that there is ample evidence that there is nothing which is new which would be elicited from anyone who is tendered pardon, as the same is already obtained from the evidence of other witnesses who have been examined by the prosecution. As on the present day, prosecution examined 26 witnesses, out of which PW1 is the eyewitness who has turned hostile. It is pertinent to note that out of 26 witnesses, 14 have turned hostile. Majority witnesses have retracted from their statements recorded in 164. Clearing fact, the police officer in the rank of ACP also turned hostile and retracted a statement. So in the facts of this case, where witnesses are right, left, and center turning hostile, approves evidence is more necessary. This is my submission. Then, my lords, on the points that the witness have turned hostile, the approver has given evidence. So the evidence of approver would be required. Now, my lords, I had on the last occasion made two submissions of 460G and 465. For 460G would not be a correct submission, my lord. I'm in view of the fact that it applies only to 306. And that is what the Supreme Court has said. So I can't argue something with the Supreme Court.
We'll leave that.
So I'm not.
Yes.
Now kindly have a look at 465. 465 is.
Yes.
$465 was glossed over, saying that it applies only to appeals, etc., my lord. Therefore, kindly have a look at 465, my lord. It is not restricted to appeals, and in fact, one case it was 482. Which was that? Supreme Court Pascal or Srinivasa was 482. Which was that case? 465. Yes, that or Fartigo was the case where it arose from 482, my lords, which I had the occasion to argue, my lords. You get Fartigo's case. Now, kindly have a look at 465, my lords.
Yes.
Subject to the provisions herein before contained, no finding, sentence, or order passed by a court of competent jurisdiction. It doesn't say at the stage of appeal only. It doesn't say final order. It says no order. It's very specific, my lord. No finding, no sentence, or sentence. It may be that some portion of it may apply to an appeal, but it's not necessary that it should apply to an appeal, my lord. Passed by a court of competent jurisdiction shall be reversed or altered by a court of appeal. So shall be reversed or altered by court of appeal, confirmation of revision on account of any error, omission, or irregularity in the complaint, summons, warrant, proclamation, order, judgment, or other proceedings before or during trial, and in an inquiry or other proceedings under the court, or any other irregularity in any sanction for the prosecution, unless the opinion of the court failure of justice has in fact been occasioned thereby. So kindly have a look, my lord. It is not restricted to a stage of appeal. It can be, my lord, if an order is passed, it says, if there's an irregular in a complaint, summons, warrant, proclamation, order, judgment, or other proceedings. This would fall under other proceedings. Therefore, that when it comes to 465 is not restricted to appeal, has been pointed out. Now, kindly have a look at Fartigo, my lords, which is there. That was a case which arose. That was not a case of appeal where the Supreme Court applied this principle. That was a case where, my lords, the CVC sanction was required to be taken by the CBI. They did not take the prosecution CVC sanction. And in that context, Supreme Court relied on 465. Now, kindly have a look at this. Facts of Fartigo, my lords. It is at page 233 of CBI volume 5. Where's the first page? Give me the first page. First page is a 216, my lord. Now, kindly have a look, my lord. The facts. Leave granted, all these appeals challenge the same. Challenge the common judgment ordered passed by learned single judge of Allahabad High Court in so and so. Facts giving rise to the present appeals are as under. Whole India, etc. New policy, I will skip that. FIR was para 2.3. FIR was registered by CBI is para 2.3. Competent authority granted sanction to prosecute is para 4. Then para 5, learned single judge of the High Court, what is order dated 24th of February to frame the following 4 questions for determination. Whether the investigation conducted by CBI in these bunch of cases is illegal and without reason for non-compliance with Section 6 of the DPSC Act. Whether the cases were orally and predominantly civil nature, purely cases of breach of contract and criminal procedure, where CBI did not follow the doctrine of parity in filing the criminal prosecutions, whether the absence of officers so and so could be made out. So these are not questions which are raised at the time of appeal, my lord. Now kindly have a look at para 4. But this was proceedings which was under 482, para 4. I'm obliged to my learned friend. This was para 4 of this judgment, placentamy. Whereas petition approached the High Court by filing petition under Section 482.
Yes.
So this was a case of 482. At the stage of 482, the High Court decided, and in this context, that the findings in Vertigo are made. It was not in the context of bail appeal as was canvassed by my learned friend. Now kindly look at what was the findings in Vertigo. Page. Kindly come to page 233, my lords. Now kindly come to para 15.
1.5.
1.5, where the submissions were made by me. So-and-so learned additional Solicitor General would submit the prior consent under Section 6 of DPSC Act is not mandatory but directory. That was the difference. He submitted that in any case, unless the appellants point out that on account of procedural irregularity of not obtaining prior consent, prejudice is caused to the appellants, or it has resulted in miscarriage of justice, investigation would not be initiated. In submit the appellant, private individual is concerned, the grievance of said appellants is totally unwarranted. Insofar as public servants are concerned, the learned ASG submitted, in any case, the consent has been granted after completion of investigation. As such, a defect in stand cured. He submitted that in any case, there are no pleadings by the appellant's public servants with regard to prejudice caused to them or with regard to miscarriage of justice. This was a submission that was made and which has been considered. Kindly come to, after the lordships have extracted 465, kindly come to, my lords, para 24, where Prakash Hindudas case is extracted. Is that? 23. I'm sorry, but para 23, placentum E. It is provided, where after 465 is extracted, what their lordship say. It is provided the finding or sentence passed by court of competent jurisdiction would not be set aside merely in the ground of irregularity if no prejudice caused to the accused. It is not disputed that this question was neither raised by the accused at the trial, nor any prejudice pleaded either at the trial or at the appellate stage. Therefore, in the absence of any prejudice, such technical objects will not affect the order of sentence passed by the competent. Apart from 465, 462. That was on the facts as far as Kukpaswamy order is concerned. But now kindly come to para 24, my lords. Prakash Hindujas case. This court, para 21 is extracted. This court, after referring to Prabhu versus King Emperor and Lumbadar Jutsi, held that if cognizance is in fact taken on a police report initiated by a breach of mandatory provisions relating to investigation, there can be no doubt the result of the trial which follows. It cannot be settled unless illegality in investigation can be shown to have been brought about miscarriage of justice. That illegality committed in course of investigation does not affect the competence and jurisdiction of the court for trial. This being the legal position, even assuming for the sake of argument that CBI committed an error or irregularity in submitting the charge sheet without the approval of CVC, the cognizance taken by the learned specialist on the basis of such a charge sheet could not be set aside, nor could further proceeding pursuant thereof be quashed. The High Court has clearly erred in satisfying the order of the taking cognizance. Therefore, this was not a case of final disposal. CBI did something wrong, which was probably a mandatory provision. But since the court had taken cognizance, we said they must show prejudice, they must plead prejudice, which was not pleaded. Now kindly come to para 27. In the present case, there are no pleadings by public servant with regard to prejudice caused to them on account of non-obtaining private consent under section 6 or require them specifically in addition to general consent in force, nor with regard to miscarriage of justice. Therefore,
But here there are pleadings.
that pleading, my learned friend said the pleading, but when he argued, he didn't show the pleadings, my lord.
Yes.
Unless I missed it.
No.
Let us.
The argument is that there are pleadings, we will see. Yes, yes.
Counter is not, let us have a look, my lord. Para 8 of the counter.
Counter? Which
Counter can't be
counter?
pleadings.
Counter filed to their application before the trial court.
Trial court. There you have pleaded.
Here is, no, he has to plead here. That is as far as the application is concerned, but when he's challenging the order, where is the pleadings? They were rightly, my lord, I'm sorry, my learned friend did not refer in his, because there were no pleadings. And in a way, I cannot say it's misled, but he did not refer to it. He has to show here that the order is vitiated on account of prejudice.
In the averments in the memorandum of the petition, there are no pleadings as well.
Yes, that has to be, because he's challenging that order. So that order cannot be set aside unless pleadings are there. What are you saying that I did it before the order was passed? I'm really surprised. Because my learned friend specifically argued that there are pleadings. And I said I did not see the pleadings. Now when my lord said that he's showing in the trial court pleadings, I don't know what to say, my lords.
Yes.
Sometimes silence is better than speaking, my lords.
Most of the time.
Huh? One of their contents was the right of silence.
Right, yes, correct.
Relying on probably
Right of silence goes.
But it's on a different context.
Yes.
Then last I said object of tendering pardon. Therefore, if this order is set aside, it would defeat the object of tendering pardon. That is my last submission as far as 11 is concerned. This is the gist of my submissions, my lord.
Yes, sir.
I could have gone on and on, but I've tried to be brief, my lords.
This is quite comprehensive.
This is anything else?
Yes.
Mr. Prasanna. You want to show from your notes?
India.
That argument I did not make that he was not a party, though saying that is his argument. So I did not make that he was not a party. What is the effect? Therefore, that would buttress my submission that is a continuation of the second because he was not heard then. Therefore,
that's all. Then, as far as Nagendra Naik, I'll take it in the evening.
Legal issues.
ಯಾವ legal issue?
One is on the PC Act and one more, my lords, 306 not applicable to 307. These are two legal which we will take.
Evening. Yes.
I may be permitted.
Yes,
to
sir,
come
that's
back. There's another matter after this, madam. My lords will take.
You're there in that also, sir?
Second, yes, quashing matter. Yes, sir, that is what I said. I want, if you don't want, we'll take a date. You want to.
We'll take it another day?
Another date, my lords.
Probably 2nd of April. 2nd ಆಗ್ಬೋದಲ್ಲ?
For little later,
All right. No
Your lordship may recall to your lordship's memory. What is the procedure that is to be followed? Is it under the CRPC or is it under the BNSS?
Correct.
531 of BNS.
That is one legal issue that is there.
Is it after under
There's no difference
231?
Whenever he wants. Whenever he wants.
When do you want it, sir?
My lords will keep it in 8th of April.
8th of April, yes.
Interim order to continue.
That will continue. The 8th of April, you will take it at 2:30? No problem. Then we'll take it at 2:30. Serial number 2, Harid Swan Madi, list the matter on April the 8th at 2:30 PM. Interim order subsisting will continue till the next date of hearing.
Matter 2:30 or 4 o'clock?
ಯಾವುದು? 4.
4 o'clock.
2:30 reservation ಇದೆ. Yes. Yes, no problem. And serial number 3, Sandesh, I have already heard it. Complainants notice ಆಗ್ಲಿ ಅನ್ಬಿಟ್ಟು ಮಾತ್ರ ಇಟ್ಕೊಂಡಿದ್ದಷ್ಟೇ. ಎಷ್ಟು ಸರಿ ಸಬ್ಮಿಟ್ ಮಾಡ್ತೀರಾ? Everything you have done. Yeah, for what purpose, sir? Correct. There a lot of law developed after that also, latest judgment allo ಇದೆ. ಮತ್ತೆ hear ಮಾಡಕ್ಕಾಗಲ್ಲ. See, this is how it has been stuck in further hearing. So much you argued. At evening. 4 o'clock.
Please.
Yes.
In fact, they had completed, I gave a reply. And
Exactly.
then, my lords,
What is this?
it was at that point of time.
Just because time has passed doesn't mean that you can say that it's.
Sita, sorry.
ಸಾಯಂಕಾಲ ತಗೊಂಡು.
Sorry.
Both these. ಇದು ಜಲ್ದಿ ರಿಪ್ಲೈ ಮುಗಿಸ್ಬಿಡಿ. ಯಾವ್ದು ಈಗ SV ರಾಜು ಅವರು ಹೇಳಿದ್ರು.
ಹೌದು.
Only
Two legal contentions we will touch upon.
Two will have application or not.
Because the only thing new is with regard to PC Act.
PC Act.
Otherwise, everything is done.
Yes, my lords. Only the other thing is the 306, my lords. They said how it is not applicable to 307. These are the only two new.
ಅದು ಹೇಳಿದ್ದೀರಾ already. With
Other than
judgment
we will
that-
just,
Yes, that is already you have said.
because what judgments are relied on is only 306(4) is procedural in nature. It has no effect on 307. Rest of it is mandate, my lords. We will point that out.
It's procedures.
Only 306(4).
It's procedure.
Otherwise, without acceptance, I think it will become very dangerous.
It's procedure. Yes, we'll see. We'll take it at 4:30.
4:30.
ವೆಂಕಟೇಶ್ವರ ಭಟ್ ಅವರು 4:15 ಬಂದ್ಬಿಡಿ. By then I'll finish the list.
Yes. Three is taken as reserved, my lords.
Which one?
Serial number 3 or 4:30, we'll have to make.
3
a
ಯಾವ್ದು?
motion, because they want to point out Sita
ಅವರು
Soren.
ವೆಂಕಟೇಶ್ವರ ಭಟ್ ಅವರನ್ನು ಹೇಳ್ಬೇಕು ಅಂದ್ರಲ್ಲ.
Sita Soren, they want to point out.
Correct. ಸಾಯಂಕಾಲ. Yes. Complaints are served, right? That's it. Yes.
Matter number 4.
Jafar ಇಲ್ಲಿ. Ask them to come. ಇದು 1 week ಬಿಟ್ಟು ಹಾಕಿರಿ ಮೇಡಮ್. Yes, next.
5.
The petition, my lords, we have taken steps in the last date of hearing.
What steps? Post immediately after service of notice upon the first respondent or the 20 better or the 4th of April, whichever is earlier. Yes.
Senior counsel is engaged. He's on.
ಏನು? Vignesh
Sale notice
Shetty.
is challenged.
Huh?
Sale notice was challenged.
Correct.
There was an interim order.
There is an interim order. I know.
40 lakhs was paid out of 75 lakhs. Now, my lord, second sale notice has been issued and sale certificate also issued.
Why, what were you doing then?
But no notice is given to me. I'm not a borrower, I'm a guarantor. No notice is served.
ಪರವಾಗಿಲ್ಲ. If the borrower is served,
We are not aware, my lord. We have been fraudulently led into this mortgage. But I'm ready to redeem. Day after tomorrow, 50 lakhs I'm ready to pay, and within 30 days, I'm ready to redeem.
Seniors here. ನೀವಿದ್ದೀರಾ? ಬನ್ನಿ. ಅಲ್ಲ, he says that you had no notice at all.
Yes.
Despite the interim order, second sale is issued.
Lords, that's the only point, my lords. Lords, this honorable court passed an interim order. Lords, it did not say in the usual sense what your lordship directs that interim order will be vacated in the event Lords, there is a fault on our part also.
Delayed payment, is it?
Yes, lords. We did not make the entire payment. Most of it we had paid, some portion we had not paid. But when the interim order was still subsisting, it was extended, my lords, when the matter came up before this honorable court. To take out a second sale notice and then again sell the property, even again thereafter also, my lords, no notice is issued for the second sale notice.
Vignesh. Second sale notice. ಆಯ್ತಾಯ್ತು. ಅವ್ರು
Take his
just
breath.
relax.
No problem.
ಅಲ್ಲ, you are panting. ಕೂತ್ಕೊಳ್ಳಿ. ಓಡ್ ಬಂದಿದ್ದೀರಾ? Yes.
Lords, the interim order which was granted by this honorable court.
ಅದಕ್ಕೆ ಕಾಫಿ ಟೀ ಎಲ್ಲ
Yes.
ಕುಡಿಯಕ್ಕೆ ಹೋಗ್ಬಾರ್ದು ಮಧ್ಯದಲ್ಲಿ. No. The only thing is, see, there is an interim order granted on 24/6/2024. Subject to deposit of 75 lakhs on or before 27/7.
No. It's not there.
That's only my orders, sir. ಅಲ್ಲ ಆರ್ಡರ್ ಬೇಕಾ ಆರ್ಡರ್ ನೋಡಿ ಫೈಲಿಂಗ್ ವಿಚ್ ಅಂತ ಇಲ್ವೇ ಇಲ್ಲ. ಅಲ್ಲ ಫೈಲಿಂಗ್ ವಿಚ್ ಅಂತ ಇಲ್ಲ ಇಲ್ಲಿ. ನೆಕ್ಸ್ಟ್ ಡೇ ಅಂದ್ರೆ ಯಾವತ್ತು? 29/7. Interim order granted earlier transaction. All right, again on 12/3/2025 ಬಂದಿತ್ತು. There is an order passed again. Sale ಮಾಡಿದ್ದು ಯಾವತ್ತು? Which one? 29/7/2024. What was the date of sale?
15/12/2023.
ಅಲ್ಲಲ್ಲ, second sale.
Second sale, my lords, is
13/12/2024.
yes.
13/12.
Please.
Long after this. When did you make the payment?
Payment of 42 lakhs was made on
On
26/7/2024.
42 lakhs, 26/7.
26/7/2024.
But 75 lakhs was not paid.
Remaining 33 lakhs was not.
Why?
Some health issues.
ಯಾವ health issue? ಅಕೌಂಟ್ಗೂ ಹೆಲ್ತ್ ಸರಿ ಇಲ್ಲ. There is no indication. You should have taken the permission of the court. ಅಲ್ಲ, ಈಗ ಒಂದ್ ನಿಮಿಷ. ಈಗ ಫಸ್ಟ್ ಸೇಲ್ ಆಗಿದೆ ಯಾವತ್ತು? 13/12.
First sale notice, my lord.
First sale notice 17/5/2024.
17/5.
2024.
First sale.
Lords, first sale notice is dated 17/5 for the auction to be conducted on 25/6/24.
25/6/24. So 24/6 you approached this court previously. It was stayed. And on 26/7/24 you paid 1 month later. Correct. Yes. But liberty was reserved to you to seek vacation
Modification. That's what I want to point out.
So that day sale did not take place. First sale did not take place.
No, there is no such notice.
Orally. Orally.
In fact, we visited the place and all, that is a critical item. They are not complied that order. As well as they are not filed an application before the court for extension of time. Left with no other option, my lord, we should have sale. And my lord, we concluded a sale. Now, my lord, what they filed an interlocutory application recently before the.
Was he notified for the sale?
No.
Second
Not
sale.
No.
The sale notice, RPAD, eviction, and publication, all three modes, my lord, which should really comply. That, my lord, tomorrow I'll produce before the summons.
ಈಗ you are ready to redeem the entire.
Yes, my lords.
ಎಷ್ಟು ಕೊಟ್ಟಿದ್ದಾರೆ auction purchase?
3.38 crores.
38 crores. For recovery of my lord, 4.7 crores.
It's all right. Whatever auction purchaser has paid, you may recover anything. 3.38 CR.
Please.
ಅದು ಪೇ ಮಾಡ್ತೀರಾ?
Within 30 days, we'll redeem it.
By day after 50 lakhs.
My lord, may I make only one?
Yes, sir.
I will make them a party. my lords.
Make him a part.
Let them furnish the information.
I'll furnish today. They can.
Huh?
Assume that is appeared in the paper from other proceedings in a very same matter for the auction purchase.
Stock auction purchaser.
ಅದು ಹಂಗೆ ಅನ್ಸ್ತಾ ಇತ್ತು ನನಗೇನು. ಇರ್ಲಿ ನೀವ್ ಹೇಳಿದಲ್ಲ ಅದಕ್ಕೆ ಹೇಳಿದ್ದು.
All right, I'll pass an order, I'll grant you time. I'll pass. The subject petition, I heard the learned senior counsel, the subject petition is preferred, calling in question a notice of sale dated 17/5/2024, which directed that the property of the petitioner, the guarantor, the property of the petitioner, to which the petitioner had stood guarantee, to be held on 25/6/2024. The previous day, i.e. on 24/6/2024, the coordinate bench grants the following interim order. The interim order was clear that the petitioner was to deposit 75 lakhs on or before 27/7/2024 with the bank, which would be 4 weeks from the date of grant of the interim order. Liberty was reserved to the respondent to seek vacation, modification of the order. It transpires that on 26/7/2024, a day before the completion of 4 weeks, the petitioner deposited 42 lakhs, but did not deposit the entire amount. The matter was not moved either by the petitioner or by the respondent bank, respondent bank, notwithstanding the fact that the bank was reserved with the liberty of moving for vacation or modification of the interim order. The bank then proceeds to auction the property, auction of which takes place on 13/12/2024. 13/11/2024. The contention of the learned counsel of the petitioner is that no notice was issued to the guarantor or the borrower, which is seriously disputed by the respondent bank, counsel for the respondent bank, Vignesh Shetty. The issue now would be, in the teeth of the subsistence of the interim order, without seeking its modification, the bank prima facie could not have put the property to sale. Permission ought to have been taken at the hands of this court, as there was an interim order operating, bringing it to the notice of this court that the petitioners have violated the interim order, therefore permission to be granted to put the property for sale. The bank has not done that, but chosen to proceed with the second sale in the teeth of the interim order, and have proceeded to issue a sale certificate even. The learned counsel for the respondent bank submits that the present petition is rendered infructuous in the light of the date of auction having spent itself, and the second sale certificate is already issued. Therefore, therefore the petition should be rejected. The submissions are noted only to be discarded for the reason that the bank has chosen to put up the property for sale in the teeth of the interim order on the score that there is violation of the interim order, as the petitioner did not pay the entire amount of 75 lakhs, but an amount of 42 lakhs was already paid. The matter again comes up before this court on 12/3/2025. The coordinate bench again passes the following order. The order was not again, the order did not nowhere again indicated that the subsequent sale would be ought to have been challenged or otherwise. The fact remains that there is sale done by the respondent bank in violation of the interim order. If the interim order had not been complied with, it was open to the bank to have filed an application with regard to non-compliance with the interim order and get it vacated. It was open for the petitioners also to seek extension, but that has not been done. Both the things have not been done, but the interim order still operates. Therefore, the auction purchaser, therefore the details of the auction purchaser shall be divulged to the petitioners, and the petitioners shall implead the auction purchasers as party respondent to these proceedings. List the matter. When do you want? List the matter on 27th. interim order subsisting would continue till the next date of hearing.
Okay.
ಅದು ಹೇಳ.
Within 30 days.
Last al ಬರ್ಕೊಳ್ಳಿ madam. The learned senior counsel submits if 30 days, say 4 weeks or 4 to 6 weeks are granted, they are ready and willing to redeem the entire property by payment of 3.38 crores as is paid by the auction purchaser. ಅದಾದ್ಮೇಲೆ entry ಮಾಡಿ.
Please.
ಅರ್ಜುನ್ ರಾವ್ ಇಲ್ಲೇ ಇದ್ರಲ್ಲ. Yes, Arjun, you appear for this auction purchaser? You appear, shall we show your name? I'll ಬರ್ಕೊಳ್ಳಿ ಮೇಡಮ್. Implead ಮಾಡಿ ಈಗಲೇ. Counsel, learned counsel for the bank Vignesh Shetty submits that counsel Shri Arjun Rao appears for the auction, correct adu? Appears for the auction purchaser. Therefore, the copies of the petition be served upon Shri Arjun Rao and the registry to print the name of Arjun Rao is appearing for the second respondent, auction purchaser. Second respondent ಅಷ್ಟೇ ಅಲ್ಲ? ಈಗಲೇ ಇಂಪ್ಲೀಡ್ ಮಾಡಿ. Yes. ಕಾಪಿ ಕೊಡಿ ಅವ್ರಿಗೆ ಅರ್ಜುನ್ ರಾವ್. Yes.
7.
ಏನ್ ಮಾಡಿದ್ರಿ ಕೊಟ್ರ?
They have validated the.
ವ್ಯಾಲಿಡೇಟ್ ಮಾಡಿದ್ರೆ 3 crores ಬಂದಿದೆಯಾ ಈಗ?
Yes.
Yes, bank.
Lords, they have.
Ravishankar sir,
Lords,
ಬಂದಿದೆಯಲ್ಲ?
prayer, my lords, lords is my kindly see, because prayer B, my lords, if your lordships are directing us to consider, we'll consider in the teeth of SBI judgment.
ಅಲ್ಲ SBI ಇರ್ಲಿ.
First part has become infructuous, my lords.
All right.
Second part is concerned, let them give
now,
the representation, we consider.
3 crores ಇದೆ.
Lords, 22 crores.
ಅಲ್ಲ ಆಯ್ತು. By and by will direct them to pay.
That's
What,
true, my
what is the amount that is to be paid to make it regular or something?
Lords, to regularize it, it's almost about 14 crores.
Lord, 7 crores was what was.
OTS ಆ?
There, my lord, they had, at that time, they had agreed for 9. My lord,
No, there's
in
no
fact, the
agreement.
agreements, my lord, documents we have produced where there was an exchange of mails between them. There was a draft agreement also was to be exchanged. Lord, we are not sticking on to 9, my lord, we would pay a little more. Lord, but, and.
Don't sit across and.
So far as OTS is concerned, my lords, I have instructions to say that OTS is not acceptable. My lords, for the nature of stand which he has taken. Lord, he has gone to the extent.
Don't get touchy about all
The
this.
reason is this, my lords, he cannot come before the court and make a false statement saying that there was an exchange of the draft, because, my lords, the officers there will be held responsible. They should also understand, my lords, what happens. Now some officers are being held responsible because they are the recipients of some mail. Lords, no OTS is coming to existence.
Now you leave, what, let bygones be
14,
bygones.
14
Now
crores.
amount has come.
3 crores,
3
my
crores
lords,
has come.
Yes.
So they will also pay.
My lords, the question is this, my lords. 22 crores. We are from 2021. This is the first payment. Because of your lordship's indulgence, we are getting the first payment from
That is why
2021.
we
I
will-
understand, my lords.
Yes.
Now, the question is 22 crores is what is outstanding, my lords, as on today. Lordships may direct them to deposit 20% of this 22 crores if they want an extension of the interim order, which your lordship usually does, my lords.
No, I will-
Otherwise,
I
the
will-
interim order.
I will, 1 minute,
3 crores.
1 minute,
Lord,
1
if they
minute.
agree to something, my lord.
1
please.
minute, sir. I will impose that condition definitely, but let them sit with you and
Yes.
talk. I'll post it the next time, then I will impose that condition.
Lords, absolutely no difficulty. Lords, if they want to come, lords, this is the reason why I said, my lords. If they come with a false statement, making allegations against.
Lord, I didn't make,
No,
my lord, document is there. He should not be making such.
No,
Right.
this, my lords, I am just telling this again. If they want to assert it, I am telling that this is already a shut door. There is nothing which is going to open up.
Not asserting that. my lord.
It didn't happen. Whatever happened, my lords, they are asserting it
All
didn't
right,
happen. There is
now-
no approval of the
no.
OTS.
Now, let's, I will pass some order now.
Yes.
They heard the learned senior counsel, so on for the petitioner and learned senior counsel for the respondent. In terms of the earlier order, it transpires that the petitioner has got the demand draft revalidated and paid to the bank. Therefore, the amount as on today paid to the bank is 3 crores. The learned senior counsel for the respondent submits that the amount totally recoverable or the amount to be amount that is to be paid to regularize is about 14 crores. The 14 crores. The learned senior counsel for the petitioner submits that if they would consider the case of the petitioner for a one-time settlement or otherwise, which was earlier offered, it would be helpful for the petitioners. Therefore, the petitioner shall approach the bank and approach the bank with a representation, and the bank would consider the same and indicate to this court whether it is before passing any order, indicate to this court whether they are agreeable for any amount, any settlement or otherwise. So further condition for extension of interim order would be imposed on the next date.
Please.
I'll take it next Friday.
That's it.
List on next Friday, the next in the fresh matters.
Please.
The 4th April. Yes.
Fourth bed.
ಬೇಡವಾ?
ಅಲ್ಲ fourth ಬೇಡ.
ಯಾಕೆ ನೀವು ವೆಕೇಶನ್ ಜಾಸ್ತಿ ಇದೆ ಅಂತ ಎಲ್ಲರೂ ಹೋಗ್ತಾ ಇದ್ದಾರೆ?
ಧಾರವಾಡದಲ್ಲಿ ಅಲ್ಲ ಅದಾದ್ಮೇಲೆ 10th or 11th.
ಅಪಿಯರ್ ಆನ್ VC ಸರ್.
ಇಲ್ಲ ಅವರು ಎರಡೆರಡು ಐಪ್ಯಾಡ್ ಇಟ್ಕೊಂಡಿರ್ತಾರೆ ಅವರು ಎಲ್ಲಿ
ಮತ್ತೆ ನೀವು ಒಂದೊಂದು ಕೋರ್ಟ್ಗೆ ಒಂದೊಂದು ಐಪ್ಯಾಡ್ ಅಪಿಯರ್ ಆಗ್ಬೋದು.
ಇಲ್ಲ ಹೊರಗಡೆ ಬಂದು ಇನ್ನೊಂದು ಐಪ್ಯಾಡ್ ಅಲ್ಲಿ ಲಾಗಿನ್ ಆಗ್ಬಿಡ್ತಾರೆ
ಅಷ್ಟೇ.
ಮಾಡಂತೆ.
Fourth come.
Please.
ಅಲ್ಲಿಂದಾನೆ ಬನ್ನಿ.
Accommodate me in case if I am held up in the.
I will pass it over.
Please.
Yes. Interim order subject to the aforesaid shall stand extended till the next date of hearing.
That's for the petitioner. The grievance of the petitioner is that on 19/6/2024, a hold was placed on the account, please, my lord. Subsequently,
ಈಗ
another hold
freezing ಅಲ್ವಾ ಇದು?
freezing, and it was placed on 26/2024. Subsequently, I've been asking them, what is the reason why hold has been placed? The respondent bank. They replied.
State Bank of Vignesh, ನೀವಿದ್ದೀರಾ ಯಾರಿದ್ದಾರೆ? Satish Kumar ಅಂತ ಯಾರು ಇದೆ? Registered to delete the name of Satish Kumar J as appearing for the respondent. Why, sir? Account is refrozen? ಇದು ಮೇಡಮ್ ಅಲ್ಲಿ ಪೇಪರ್ ವಿಘ್ನೇಶ್. ನಾವು ಸ್ಟೇಟ್ ಆಫ್ ಎಷ್ಟಿದೆ ಅಮೌಂಟ್, ಡಿಸ್ಪ್ಯೂಟೆಡ್ ಅಮೌಂಟ್?
55 lakhs.
ಅಕೌಂಟ್ ಅಲ್ಲಿ ಎಷ್ಟಿದೆ?
And there are some other money. Only this money may not pass the lien.
ಆಯ್ತು, 4,20,000 ಬಿಟ್ಬಿಟ್ಟು
My lords, may
ಅದು
kindly have
ಬೇಡವಾ?
the application dated 10/12/2024, please, my lords. There is an annexure L which we have placed, page number 6. We write them a mail on 9th December 2024.
ಈಗ ಒಂದ್ ಮೇಲ್ ರಿಪ್ಲೈ ಮಾಡಕ್ಕೆ ನಿಮ್ಗೆ ಅಲ್ಲ, ಸಿ ಭರತ್ ಕುಮಾರ್ ಹಿಮ್ಸೆಲ್ಫ್ ಹಸ್ ಸೆಂಟ್ ಅ ಮೇಲ್.
ಅಲ್ಲ, ಏನಾಗಿದೆ ಸ್ವಾಮಿ ಇಷ್ಟೇ? ಅಲ್ಲ, I'll just take a
ಆಲ್ ರೈಟ್ ವಿಘ್ನೇಶ್, ಯು ರಿಪ್ಲೈ ಟು ದ ಮೇಲ್.
ಇಲ್ಲ
ಎಲ್ಲಿದೆ?
My lords, may kindly see.
ಈಗ ನಿಮಗೆ ಡಿಫ್ರೀಸಿಂಗ್ ಬೇಕಾ ಇಲ್ಲ
But at least let them say.
ಈಗೋ ಸೆಟ್ಲ್ ಆಗ್ಬೇಕಾ?
The ego, sir. All I'm asking in my mail is this much: which police station, which is the transaction which you have placed a hold?
23 ಬರ್ದಿದ್ದೀರಾ? ಎಲ್ಲಿದೆ?
ಒಂದು FIR ನಂಬರ್ ತೋರಿಸ್ಬಿಡ್ಲಿ ಸ್ವಾಮಿ, I'll withdraw the petition. ಒಂದು ನಿಮಿಷ, ಇದರಲ್ಲಿ ಪುಂಡಲಿಕ್ ಅಂತ ಕೊಡಿ.
Bank will not do all that. Maharashtra, there are many cases every day that Maharashtra police, Chhattisgarh police, cyber crime will have indicated freezement of the account because there is a suspicious transaction between the accused there and here. That's all right. ಇಲ್ಲಿ 4,20,000 ಇದೆ, ಅದನ್ನ ಲೀನ್ ಮಾರ್ಕ್ ಮಾಡಿ ಮಿಕ್ಕಿದ್ದು ಆಪರೇಟ್ ಮಾಡ್ತಾರೆ.
ಅಲ್ಲ, my only thing.
ಅಲ್ಲ, ಅದು ಬೇಡ ಅಂತಂದ್ರೆ will adjourn it.
ಅಲ್ಲ, my only thing is that 4,20,000, where should I go is the question which I will ask myself, please, my lords.
No problem. By then we will get the info completely. What is the
It's been 1 year.
1 minute. ಈಗ
ಅಲ್ಲ, ಇವ್ರಿಗೆ ಫೋನ್
1 minute.
ಇವ್ರಿಗೆ ಫೋನ್ ಮಾಡಿದ್ರೆ the person whose number is indicated there, he has moved out, please, my lord.
Sir,
He
it
doesn't take a mention of.
is State Bank of India, sir.
No, they have given a police constable's number.
Correct. It is State Bank of India. You will hardly get replies from them.
Now, my only concern is this. I'll just take a minute.
That's all right. Now, if you want a reply from them, I will direct a reply. ಈ 4,20,000 ಎಲ್ಲಿ ಹೋಗ್ಬೇಕು ಅಂತ ಫಸ್ಟ್ ಸ್ಟೇಟ್ ಆಫ್ ಕರ್ನಾಟಕ ಪಾರ್ಟಿ ಮಾಡಿ ತೊಗೊಳ್ಳಿ.
My lords, one humble.
Bharat Kumar, listen. It is state of Maharashtra. I cannot issue any writ to state of Maharashtra. Why I ask you to make state of Karnataka a party is I will direct the state to communicate to their counterpart and get the every detail. Then I'll resolve that 4,20,000 also. You don't want that? No problem.
If I may make one.
Yes.
My lords, I will make Union of India a party.
Why, sir?
For the reason being, this is happening day in and day out, please, my lords.
This Union of India party model, it is not going to solve the problem because cyber crime is on the rise. Cyber transactions which are suspicious are on the rise. I will not give a blanket ban on anything. It is only on case-to-case basis.
My lords have given a direction, please, saying that the communication which is from any of the governmental authority to the bank should at least indicate what is the FIR number, what is the transaction.
That is why we will get it. The state, no state of Gujarat, Chhattisgarh, so many communications are there. It is a transaction through the intermediary. That's all right.
Ask
Now
is
make,
this much, please.
you don't ask any other question now. Now, you want to ask question?
No.
Answer it.
4,20,000, my lords, 4,20,000.
4,20,000 ಏನಾಗ್ಬೇಕು ಅಂತದ್ ಆಮೇಲೆ ಈಗ ಸದ್ಯಕ್ಕೆ ನೀವು ಅಕೌಂಟ್ ಆಪರೇಟ್ ಮಾಡ್ಬೇಕಾ ಬೇಡವಾ?
Operate.
ಅಷ್ಟೇ. Yes, make state of Karnataka a party. Going on arguing will be neither here nor there.
I just
Unless
want
I
to-
have the information about 4,20,000, I will not pass any order.
That
Yes.
has been, I've been asking
No.
them for the past 1 year, please.
ನಾನು ಮುಂದೆ ಫಸ್ಟ್ ಟೈಮ್ ಬರ್ತಾರೆ. That's all right. Yes. The petitioner is before this court seeking the following prayer. The learned counsel appearing for the petitioner submits that for the last 1 year, the petitioner has been communicating with the bank to receive the information with regard to the reason behind the marking of lien or putting on hold of the operation of the account, as the case would be by the State Bank of India. The State Bank of India has appeared to have the representations given to the State Bank of India appear to have gone unheeded, and therefore the petitioner is now agitated. The learned counsel, Vignesh Shetty, submits that they have an information from the state of Maharashtra, the cyber crime, to put the account on hold due to certain suspicious transaction. According to the bank, the suspicious transaction amount is 4,20,000. ಎಷ್ಟಿದೆ ಟೋಟಲ್ ಹೇಳಿ?
5,09,000.
ಎಷ್ಟಿದೆ ಟೋಟಲ್ ಅದು?
My lords, may kindly
That's all right. One ನಿಮಿಷ. So and so. In that light, in the light of the communication from the state of Maharashtra being the reason for putting the account on hold, I deem it appropriate to direct the petitioner to implead the state of Karnataka as a party respondent to these proceedings. The learned AGA is directed to accept notice for the respondent to strike out a communication between in the state of Maharashtra and get to know the details about the reason for the direction so issued of putting the account on hold. Madi. Yes.
It may be had 24th, sorry.
24th ಇವತ್ತು.
28th, please. In the fresh matters.
20 ಅಷ್ಟರಲ್ಲಿ ಸಿಗುತ್ತಾ ಇನ್ಫಾರ್ಮೇಶನ್?
Yeah,
We'll post it on list the matter on 3rd April. Yes.
The fresh matters.
Preliminary hearing. List the matter on 3rd April in the preliminary hearing. Yes, next. Dwarf ಏನ್ ಮಾಡಿದ್ರಿ?
I'm filing my objection.
Dwarfಗೂ objection ನಾ?
ಇಲ್ಲ, I will. So what is that?
Not sir. ಕೊಡಿ.
File their objections. And so far as what they say is, my lords, one is that we are not recognized, my lords. I file a memo to that effect. And what they say is, my lords,
ತಗೊಳ್ಳಿ ಮೇಡಮ್.
and what they say, my lords, is the policy that is now in place is one of 2017, which is clarified by the division bench also, my lords, of this honorable court. My lords may kindly take page 12 of the statement of objections. Lords, wherein the Paralympic Committee of India, that is at column 26. My lords, I am recognized by the Paralympic Committee of India. I have also placed on record at my memo, page 14. Specific letter was written to the commissioner. Paralympic Committee of India, PCI, is a national sports federation recognized by the Government of India, Ministry of Youth Affairs and Sports, and affiliated to the International Paralympic Committee, Germany. Paralympic Committee of India is the body responsible for selecting para-athletes to represent India at the Paralympic Games and other international sports championships. In respect to the above, I would like to inform you that, like other parasport competitions that are conducted worldwide, the World of Games are also an IPC and PCI recognized events. My lords, so on this score itself, I am recognized. And my lords, the other aspect, my lords, of the policy that is now placed, my lords, may come to page 9 of my memo. which is the division bench order of this honorable court.
Yes, para 6 of that.
Please, my lords, para 6. Very clearly says that events held prior to 9/10/2017, the government orders of 2013 will apply.
Government order of 2013 recognized your,
Please,
when was this event held?
on 4th to 12th August 2017.
4th to 12th August. When did the government order come?
Government orders in 30/11/2013.
13, alala, the new one.
New one, my lords, is
9/10/2017.
9/10.
9/10?
2017.
All right. Yes, sir.
Our only thing is, my lord, along with our statement of objections, my lord, I have submitted the list of the recognitions by the Ministry of Youth and Sports, my lord, Union Minister. There, my lord, these federation also is not recognized. What it says is, my lord, when somebody represents a country, my lord, there should be an internal selection process, and that everything has to be done under a federation. There's no registered federation here, and these people are not selected, and it is an invitational game. Your lordship can kindly see the document.
Earlier on the same invitation you had paid.
That in the discretion of the minister that is paid, my lord. But then, as a matter of right, they're not entitled for the incentives. As a one-off case, first time when they're represented. Now, this is the third time that they have gone. Now, what has happened is, my lord, if your lordship look at R1, R1 is, my lord, the representation by the president of the Dwarf Association, where he is requesting for funds for them to travel. That itself shows, my lord, if you are representing the country, the sub-federation or the association which they are affiliated to, everything is sponsored by the government, and government selects a candidate and they are sent to represent the country before this, in that event, my lord. So this is kind of an invitational event where they, on invitation, my lord, they go and participate. My learned friend in his pleadings has said that there was a selection process, but there are no documents forthcoming to say which is the authority that has conducted the entire selection, shortlisted the team, and allowed them to participate, my lord. Our case is, my lord, in the list that is produced by me, along with my statement, does not recognize this DOF Games Association. Of course, then, my lord, what has happened is that my learned friend anyway has pointed out that the latest 9/10/2017 policy, where at page 21, my lord, they say, Olympic Games, Asian Games, Commonwealth Games, World Cup, ಚಾಂಪಿಯನ್ಶಿಪ್ ಭಾರತ ಸರ್ಕಾರದಿಂದ ಅಂಗೀಕೃತವಾಗಿ ಭಾರತ ತಂಡದ ಭಾಗಿಯಾಗಿ ಪ್ರತಿನಿಧಿಸಿರಬೇಕು.
ಅದು 1/10/2017 ಇಂದ.
ಯಾವುದು?
ಹೌದು. ಮುಂಚೆ ಇದ್ದಿದ್ದು 13 ಎಲ್ಲಿದೆ? 13th ಪಾಲಿಸಿಯಲ್ಲಿ.
That's annexure B, my lords, page 21. That very clearly says World Dwarf Games.
That one, yes.
And my lords, in fact,
policy has come into place only because anybody from any sport, my lord, I on my instructions is this. What happens is there are a lot of promotional events that happen throughout the world in different categories, in different sports. There are n number of sports. What happens is on an invitation, if at all, I will not compare this with that sports. Tomorrow, if anybody else who has the resources, my lord, he goes, participates on an invitation, comes back and he claims these prices, then it will open a Pandora's box to all such kind of claims in the country. That's the reason why there was a guideline that was framed. So there they have said, ನ್ಯಾಷನಲ್ ಗೇಮ್ಸ್ ಪ್ರತಿ 4 ವರ್ಷಗಳಿಗೊಮ್ಮೆ ನಡೆಯುವ ಕ್ರೀಡೆಗಳು, ಮತ್ತೆ ನ್ಯಾಷನಲ್ ಚಾಂಪಿಯನ್ಶಿಪ್, ಜೂನಿಯರ್ ಒಲಿಂಪಿಕ್ ಚಾಂಪಿಯನ್ಶಿಪ್, ಸಬ್ ಜೂನಿಯರ್ ನ್ಯಾಷನಲ್ಸ್. These are the recognized as per the new guideline.
Lords may also kindly take note of even 2015, for certain sports events, they've enhanced the price. For even in that notification, the World of Games was shown, my lords, too.
Heard reserved. Next.
Great.
Sharath Gaudre, you may have to file your objections.
He did not comply.
So it is dismissed.
Work of non-compliance. My lord, kindly take annexure D2, D3, and D4.
It's all right. Awaiting the appearance of the counsel for the petitioner, list the matter in B group on 11th, sorry, on 9th April. Is next. All right, 15th. Yes.
11.
It's a MSGP matter where, my lord, your lordship directed to hold a fresh inquiry, my lord, along with.
Inspection.
Yes, inspection.
What has happened?
But copies of the report may be ordered to be furnished.
Kodi.
But we
Aru
request,
copy kodangilva?
Lord, even the last report also, my lord, we are told, my lord, sufficient copies are submitted, my lord. That also may be furnished.
Madam, material that is against them. Now, the inspection report has gone against them.
They are not fully in compliance, your lordship, the respondent number.
So copy kodi avarge. Let them respond to it. Mic.
So, my lord, they have been issued, my lord, from time to time, the PCBs issued.
Iga, there is a report now.
Please,
The
I will
report
go
is
through it.
against him. Let him peruse the report.
Yes. We will also go through it and we will
Yes,
file
correct.
objections, my lord.
The
May I request, my lord, the earlier report also may be, my lord, furnished to verify, my lord, what was the.
earlier, what report was there earlier?
Earlier also, there was a report, my lord, inspection
My lord,
report.
that was an ex parte report. Therefore, your lordship.
Now in your presence,
Please.
alvagiradidu.
Earlier also they were present.
No,
Only
that's
thing-
all right. Now the latest
Can't,
report
my
is in
lord,
your presence.
I will look at it, my lord, because after 3 months.
Earlier report is you should have, or if it is in your presence, then copy bande.
ಇಲ್ಲ ಕೊಟ್ಟಿಲ್ಲ copy. ಅದು ಇದೆ. Sufficient copies are
earlier-
furnished, I am told, my lord.
My lord, that was,
Let the copies be furnished.
The
my lord,
petition,
earlier report, my lord, we were not present, we were not informed, my lord. That was pursuant to an ex parte order.
it's all
Therefore, my lord,
Let
your
them file
lord.
objections, copies may be furnished.
is all right. Yes. Pursuant to the order passed by this court, the Karnataka State Pollution Control Board has conducted an inspection in the presence of the parties of the subject property and have drawn up a report. The copy of the report be served upon the counsel for the petitioner and the respondent.
Please.
The learned senior counsel, Sri Arun Sham, submits that it was an earlier report which was in your favor.
My lord, it's a report, my lord. We don't know. whether it's in
There
favor.
was an earlier report, and that report also should be directed to be furnished to him. The learned counsel Vinayak Bhatt submits that that was a report drawn ex parte, in the sense that the respondent was not a party to the inspection. Now the respondent, all the parties are parties to the inspection and would therefore submit that the said report would be of no relevance. Whether it is of relevance or not, the same be placed before this court on the next date.
Lord, they have
Yes.
placed
They
it in
placed
a
it,
pen drive.
copies may be
Already
served.
ಇದೆ. ನಿಮಗೆ ಕಾಪಿ
Copies-
ಕೊಟ್ಟಿಲ್ವಾ ಅದನ್ನ?
ಇಲ್ಲ ಕೊಟ್ಟಿಲ್ಲ. ಅದು copies
ಯಾಕೆ?
ಕೊಟ್ಟರೆ
ಅದೇನಾದ್ರು-
ಯಾವ್ದ್ರಲ್ಲಿ ಪ್ಲೇಸ್ ಮಾಡಿದ್ರಿ ಅದನ್ನ? ಸೀಲ್ಡ್ ಕವರ್ ಅಲ್ಲ?
Pen drive.
Huh?
Pen drive.
It's in the
ಪೆನ್ ಡ್ರೈವ್?
Lord, there is no, actually, my lord, there is no such written report. Pen drive ಅಲ್ಲಿ
How can he say?
ಎಲ್ಲಿದೆ ಇಲ್ಲಿ?
Report submit
ಪೆನ್ ಡ್ರೈವ್ ಇಲ್ಲ ಏನಿಲ್ಲ.
ಇಲ್ಲ even the office note says, my lord, it has.
ಆಫೀಸ್ ನೋಟಿಸ್ ಲೇಟೆಸ್ಟ್ ರಿಪೋರ್ಟ್.
ಅಲ್ಲ ಹಳೇದು.
Kept below ಅಂತಿದೆ.
Kept below ಅಂತಿದೆ. Copies may be.
ವಿಲ್ ಸಿ. ಈಗ ಇದು ಕಾಪಿ ಕೊಟ್ರೆ ನೀನು?
Copy ಕೊಟ್ಟಿದೆ.
I've given.
No.
No, the old
Old
report copy,
report
what is the,
also.
what is the problem? Ultimately, we will go by when if the report is not, after hearing all the parties or all the parties being present, we will not take note of the
Your
report.
lordship, the prayer sought in this petition is a green bench matter, your lordship.
It has to go there, is it?
Yes, your lordship, has to be placed before court hall one. The prayer sought are the matters which
Yes,
are to
sir.
be classified as
Why,
green
why
bench
is it
matters,
here
sir.
then?
My lord, only thing is, my lord, the MSGP plant is, my lord, passing.
ಅಲ್ಲೇ ಹೋಗ್ಲಿ ಹಾಗಾದ್ರೆ.
It has to
Let it
be.
be placed before division
The
bench.
simple mandamus sought, my lord, I don't think, my lord. that is-
ಮ್ಯಾಂಡಮಸ್ ಅಲ್ಲಿ ಇಷ್ಟೊಂದು ರಿಪೋರ್ಟ್ ಎಲ್ಲ ಆಗಿದೆಯಾ ಈಗ?
ಇಲ್ಲ, ಯಾಕೆಂದ್ರೆ ಇಡೀ ಊರಿಗೆ ಡಿಸ್ಟರ್ಬ್ ಆಗ್ತಿದೆ. ನಾಟ್ ಓನ್ಲಿ.
ಹಾಗಾದ್ರೆ let it go before.
Chief, the court hall one, your lordship.
The learned counsel appearing for the Pollution Control Board would submit, notwithstanding the earlier proceedings before this court, the matter has to be placed before Honorable the Chief Justice as matter pertains to a green bench. In the light of the said submission, the matter be placed before Honorable the Chief Justice. Honorable Chief Justice to be placed before the green bench.
Copies may be.
Copies of the copies of the present report be placed, be served upon the counsel for the respondent. Insofar as the earlier report is concerned, it is for the petitioner to seek the same appropriately. Please.
The report submitted today has been served on the.
Today I have told that, yes. Yes, next.
Please.
Well.
Krishna Mohan. ಲೋನ್ ಅಕೌಂಟ್ ಟ್ರಾನ್ಸ್ಫರ್ ಮಾಡಿದ್ರ 12 ಲಕ್ಷ
Please,
ಮಾಡಿದ್ರ
on 21st ಮಾಡ್ತಾರೆ.
ಪರವಾಗಿಲ್ಲ. The learned counsel appearing for the petitioner submits that the interim order has been complied with. In that light, the interim order stands extended.
Not they are requesting for a OTS 3 months time. Dispose ಮಾಡ್ಬೋದು.
4 months. Madla.
With liberty ಮಾಡು.
The petitioner is before this court seeking the following prayer. This court on 19/3/2025 had passed the following order. The learned counsel for the petitioner submits that the interim order has been complied with and they have submitted a representation seeking closure of the account by one-time settlement. The learned counsel for the respondent bank submits that the representation would be considered in accordance with law and appropriate orders would be passed thereon. In that light, I deem it appropriate to dispose the petition, reserving the liberty as aforesaid to submit a representation and also to pass necessary orders. Is ordered accordingly. Next.
13.
3%, 5%. 13, sorry, sir. 13 is different. Yes, sir. Central Bank of India.
Counselor who argues not his father.
Huh?
Counselor on record who argues not his father has been hospitalized.
All right. List the matter on 15th April. Interim order subsisting will continue to the next date of hearing. Idu 3%, 5%.
Date of hearing, I undertook that I am ready to pay 5% itself. My lord, what has
If he is
happened
the highest bidder, but the
He is-
lowest bidder.
No matter what has happened is now, the cabinet has approved the same thing at a higher thing because the value that was fixed for the tender was at 2018 valuation, my lord, for the degradation. What has happened is, my lord,
He will meet the requirement.
what has happened is at that point of time it was lesser. Now it is increased to 36 crores. But here, I am giving
Well, yeah, pass over, yes. Next. Arms license, consider ಮಾಡ್ತೀರಾ?
consider weeks time may be granted, my lord, because we had informed them, weeks time may be granted.
ಇಲ್ಲ, for consideration or what? Or
Consider and will.
shall I pass orders?
No, a week's time may be granted. I'll get the instructions, I'll place it before the court. Then
The learned counsel, learned AGA submits if a week's time is granted, the instructions would be sought or the application may merit consideration. List the matter on 4th April. Yes. In preliminary hearing. Next.
16.
Petitioner.
Yes.
PGS matter, my lord, the last time your lordship directed them to call for some alternate measure. Because thumb
Because
impression.
there's a biometric issue, my lord, where
Yes.
he's not able to operate his fair price depot because of that. He wants it to be transferred in his son's name. However, my lord, the portal provides, my lord, for an assistant to operate the fair price depot. He's in fact using that software itself and operating it as of today.
Why you're disabled? Is it?
Experience.
What's
It's
the
not
problem?
disabled.
Then what is the problem?
Sometimes what happens is your biometrics don't,
Okay, you don't have a proper mechanism there.
no, sometimes it fades away. Your fingers tend to fade
All
away.
right.
My lord, they have one endorsement, my lord, they have said them.
ಈಗೇನ್
But this
ಅದಕ್ಕೆ
method-
ಲೈಸೆನ್ಸ್ ಟ್ರಾನ್ಸ್ಫರ್ ಮಾಡಕ್ ಕೊಡಲ್ಲ.
ಕೊಡಕ್ಕಾಗಲ್ಲ.
ಅಲ್ಲ, ಏನಾದ್ರು
In
alternate
fact,
method,
it's already
highest
been done on
method-
a
Alternate,
compassionate
take
ground.
assistance and do it.
ಹೌದು.
Then
The
your son
portal
will
provides-
claim
ಹೌದು.
his son should be granted.
Basically requiring an extension of time.
Yes.
But some assistant, my lord, if lordship directed.
Yes.
He's operating it that.
Then
As of
leave
today,
it.
he's operating it.
ಇಲ್ಲ
I will not direct transfer of license or authorization to your son.
ಬೇಡ. Some alternate method, my lord, let them.
Alternate method, if
Operating
you're doing it, then do it.
ಅದೇ, that,
The portal provides for it.
The petitioner is before this court seeking the following prayer. The heard words. The petitioner is granted authorization to run a fair price shop on account of transfer from the mother of the petitioner was granted authorization to run a fair price shop in the year 1995. The mother of the first petitioner dies on 28/1/2022 and the license is transferred on compassionate grounds to the first petitioner. The issue in the list is that the first petitioner is not able to operate the biometric as it every time declines and is causing a problem for distribution of the essential commodities by the fair price shop. Therefore, the petitioner is at the doors of this court seeking transfer of authorization license in the name of his son, of the first petitioner's son, the prior on that said, the said prior on the face of it is not entertainable, as the authorization cannot be transferred for the asking when there is a solution to the problem. The learned HCGP would submit that the petitioner is already operating with the assistance of another person,
Son,
assistance of the son,
who's
and
opened, sorry, my lord, who's opened another account, a parallel account.
the petitioner is operating
Called
with
an
the
assistant
assistance of the
account.
son on opening of a parallel account. Therefore, there is no need to even consider the prayer, as a solution is already found by the petitioner himself. In that light, the petition stands disposed without answering the prayers. However, the state shall see to that there should be no problem with the biometrics, so that the public are not put to jeopardy. With the aforesaid observation, petition stands disposed. Next.
Shiva, appearing for respond number 2. My lord, this was the order passed by the learned RERA, the Real Estate Regulatory Authority.
Stay kottidinala.
No, my lord, they said they'll take instructions saying that they will consider the matter, because page number 29, my lords, had recall that through an automatic email, the registry is rejecting complaints on the basis that.
My lord, there was no, it was not placed before the chairman, my lord, our authority. But since it was a prayer for injunction, my lord, it was not maintainable.
Registry itself said it is not maintainable.
But if the act and rules are seen, it should be placed.
What is this? I just want to bring also to my lord's attention, because I'm told this anecdotally by the authorities at the RERA, that this has happened in several cases which run into the tens or hundreds. So there may be some indication as to how these may be dealt with, at least by the authority.
Then we'll take it tomorrow. List tomorrow in the fresh matters list. So that every time petitions need not, or somebody should not be put to problems.
Personally, I have at least one other matter where this has happened, but my learned friend may be able to take instructions.
No,
whether-
see, Gautam is fair. He says it should be placed.
Yes.
No,
absolutely.
fighting. Tomorrow we'll pass detailed order so that it should not repeat.
One submission,
Even
respond
then-
number 2, your lordship. The complaint per se, your lordship, is not maintainable.
Adalli. Who should decide? Registry should say it's not maintainable, or the members there?
My lordship.
Yes,
I'm obliged.
tomorrow, yes.
18.
Parole. Yes, Rahul.
There's a body warrant and
ಎಷ್ಟು ವರ್ಷ ಆಗಿದೆ?
4 years and 3 months.
Offense ಏನು?
ಇದು
Pokso.
Sorry.
Pokso.
Pokso. It's a Pokso.
20 years connection. 20 years is.
ಏನು offense?
Offense is under section 6, my lord, of POCSO Act. Of 6, my lord.
Of?
POCSO Act.
Yes.
Your lordship, there's a direction to keep him present. That is
Where?
on 16/4/2025. There's a body warrant and this is under the Arms Act. He has ventured into entering the Kudremukh National Park for hunting.
ಈಗ ನಿಮ್ಮನ್ನ ಬಿಟ್ಬಿಟ್ರೆ ಪೊಲೀಸ್ ವಿಲ್ ಹ್ಯಾವ್ ಟು ಹಂಟ್ ಯು ನಾವು. ಸಿಗದೇ ಇಲ್ಲ ನೀವು. ಎಸ್. ಸ್ವಲ್ಪ ದಿನ ಇರಿ.
Don't let him move the matter after.
ಅರ್ಜೆನ್ಸಿ ಏನಿದೆ?
He's the only son for their parents, my lord. And
Correct.
And now the estate work is going on, my lord.
Estate work?
Yes, my lord. Coffee estate work is going on, my lord. Reason, my lord. There's an urgency, my lord. At least for 30 days, I request, my lord.
That body warrant is there and you indulge in hunting.
My lord. And there is no much any allegation against them.
You're accused number 3.
Accused number 3, my lord. The more allegation is against the accused number 1 and 2, my lord.
Because they've threatened the forest
That is
guard.
allegation against the accused number 1, my lord.
The 17th after that hearing date. Because
ಏನ್ ಹಿಯರಿಂಗ್?
ಅಲ್ಲಿ charges frame ಮಾಡ್ಬೇಕಂತ.
That doesn't come in the way of.
Trial which is going
That
on.
will not come in the way of considering parole. Anyway, we'll post it on 17th. List on 17th April. Avat koduva. Yes.
Trial
Because
is
of
in
your
a-
offense and.
Trial is in the end of the stage, my lord.
So what? No problem. Yes.
On top of the fresh matter.
Top. Yes, it will come. Don't worry.
My lordship, complaints already order, my lordship. The correction of name, my lordship.
ಏನ್ complaints?
Birth certificate, my lordship.
ಮಾಡಿದ್ರಾ?
Yes, my lordship.
ಸರ್ಟಿಫಿಕೇಟ್ ಇಶ್ಯೂ ಮಾಡಿಲ್ಲ ಸ್ವಾಮಿ.
ಮತ್ತೆ?
Already,
ಮ್ಯಾನ್ಯುಯಲಿ ಏನೋ ಮಾಡಿ.
that is our old.
ಯಾವಾಗ ಕೊಡ್ತೀರಾ ಸರ್ಟಿಫಿಕೇಟ್?
Today itself they got, if you, already the client has gone their own, my lordship.
3 ದಿವಸದಿಂದ ಇದ್ದಾರೆ ಸ್ವಾಮಿ, ಫ್ರೈಡೆ,
No, no,
ಥರ್ಸ್ಡೇ,
today they-
ಕೊಡ್ತೀರಾ ಇಲ್ವೋ ಇವತ್ತು?
Yes, my
ಅವ್ರ
lordship.
ಕಾಸ್ಟ್
No, no, my lord, already change entire. name
ಪಾಸ್
change
ಓವರ್
correct,
ಐ
my
ಟೇಕ್
lord.
ಎಟ್ ದ ಎಂಡ್ ಆಫ್ ದ ಡೇ.
My
ಅಷ್ಟ್ರಲ್ಲಿ
lordship.
ಬಂದಿದೆಯಾ ನೋಡಿ.
My lordship, tomorrow.
ಅದೇ ಟುಮಾರೋ
What is that?
ಆಯ್ತು, ಟುಮಾರೋ ಇನ್ ದಿ ಫ್ರೆಶ್ ಮ್ಯಾಟರ್ಸ್ ಲಿಸ್ಟ್.
That copy already me, my lordship.
ನಾಳೆ ಕೊಡಿ ಅದು.
My lordship.
ಎಸ್ ತಗೊಳ್ಳಿ. ನಾಳೆ ಬೆಳಗ್ಗೆ ಇವತ್ತು ಸಾಯಂಕಾಲದೊಳಗೆ ಬಂದಿಲ್ಲ ಅಂದ್ರೆ ಕಾಸ್ಟ್.
They already did, my lordship.
ಕೊಟ್ಟಿದ್ದು ಕರೆಕ್ಟ್ ಆಗಿ ಇದ್ರೂ ಬೇಕಂತ ತಪ್ಪು ಮಾಡ್ತೀರಾ.
Already they did, my lordship.
ಎಸ್ ಈ ಅವಾಗೊಂದು ರಿಟ್ ಪೆಟಿಷನ್ ಹಾಕಿ ಇಲ್ಲಿ ಬಂದು ಅದರಿಂದ ಎಷ್ಟು ತೊಂದರೆ.
No, today they have applied, my lordship.
ಹ್ಮ್
The copy is
ಆಯ್ತು,
applied.
ಸರಿ.
So.
ಸಾಯಂಕಾಲದೊಳಗೆ ಕೊಡ್ತಾ ಇದ್ರೆ ಹೇಳಿ.
Or maybe one or 2 days, my lordship.
Huh?
1 or 2 days they will get, my lordship.
No,
Today they
sir.
applied copy. my
Today evening copy should be with him.
lordship. Already they applied, today.
No
itself they
problem.
applied.
Mistake is yours. Copy should be with him today evening. Otherwise
Day after
tomorrow.
my lordship.
Otherwise tomorrow will impose costs.
My lordship, day after tomorrow.
Well, day after tomorrow fresh matters list. Yes. Next.
20.
My lord, I appear for the petitioner in this matter.
Hmm.
This petition is challenging the order of the district commission, my lord.
FPF steps.
My lord, I have been reached out by the respondent, my lord, saying that the notice was served, but a full copy was not served. Subsequently, I have served them by email also, my.
ಅದು ಬರ್ಲಿ ತಾಳಿ. Again, problem ಏನಾಗ್ತಾ ಇದೆ?
The issue is, my lord, after
Issue may
the
be
emergency-
anything. What is the stage with which their amendment application is rejected?
Rejected, stating that the wrong provision was.
We
taken.
awaiting the appearance of the respondent. List the matter on
My lord,
16th
there is
April. Till such
subsequent-
time further proceedings before the concerned court shall remain stayed.
Much obliged.
Yes. Next.
21.
Today I have been called for negotiation.
ಕೂತ್ಕೊಳ್ಳಿ.
No, I have. is there.
List
Can I
the
have it on
matter.
Wednesday or
Friday,
Thursday?
my lord, will.
List the matter on Friday, 28th. Yes. Next.
What is it?
Yes, next.
For the petitioner in this case, my lord. Petitioner purchased the property on 9/6/2014.
Yes.
9/6/2014, a sale deed is executed in my favor. Consideration is passed, stamp duty is paid, registration fee is paid. Till today, the sale deed has not been released in my favor. I give a representation annexure A. They say that due to the technical reasons of Kaveri 2, we are not able to release it. But Kaveri online.
ನೀವಲ್ಲ ಪ್ರಸನ್ನ ಕುಮಾರ್. ನೀವಲ್ಲ. ಎಸ್. ಯಾವಾಗ ರಿಲೀಸ್ ಮಾಡ್ತೀರಿ?
What is the issue is, this document is presented before the implementation of the software. Now, any document.
Is this citizen responsible for your follies, sir? Then Kaveri 2 ಸರಿ ಇಲ್ಲ, Kaveri 1 ಸರಿ ಇಲ್ಲ ಅಂದ್ರೆ what is citizen's problem? It is for you, set the software right so that it is given. What will secure instruction? We will begin to impose costs. ಹೇಳ್ತಾನೆ ಇದೀನಿ, I will start imposing costs like this. Kaveri 2 ಸರಿ ಇಲ್ಲ ಅಂದ್ರೆ ಅವ್ರ ತಪ್ಪ. They have given everything. Have you indicated anything that is dearth? ಹೇಳಿದ್ದೀರಾ? ಎಷ್ಟು ದಿನ ಆಗಿದೆ?
2014 is the sale deed, my lord. Kaveri.
ನೀವು ಪ್ರೆಸೆಂಟ್ ಮಾಡಿದ್ದು ಯಾವತ್ತು?
9/6/2014. Kaveri online came into picture on 5/8/2018, my lord, after 4 years.
2014 ಇದು?
14. Kaveri online ಬಂದಿದೆ 2018 ಅಲ್ಲಿ.
Where is the endorsement?
Endorsement is at annexure B, my lord, page number 21.
21. ಯಾವಾಗ ಕೊಡ್ತಾ ಇರೋದು? 31/12/2024 ಈಗ. ಏನ್ ರೀಸನ್?
Kaveri 2 ನಲ್ಲಿ ತಾಂತ್ರಿಕ ಬಿಡುಗಡೆ ಮಾಡಲು ಅವಕಾಶವಿಲ್ಲ.
First of all, we'll have to verify as to why the document has been kept pending. I will secure the instructions and submit.
The petitioner is before this court seeking a direction by issuance of a writ in the nature of mandamus to release the sale deed executed in favor of the petitioner on 9/6/2014. Years pass by, representations galore. The sale deed is not released by ಯಾವ sub registrar ಇದು? By the sub registrar Hebbald. On the latest representation comes an endorsement on 30th December 2024. The endorsement indicates that Kaveri 2 software does not permit release of the sale deed except electronically. The learned counsel for the petitioner submits that the sale deed was presented on 5/8/2014 and all necessities for
2014.
9/6/2014 and all that is necessary for the release of the sale deed was already complied with, as there is no indication of anything falling in dearth. The endorsement as observed herein above indicates that Kaveri 2 is not, Kaveri 2 would not be, the learned counsel would further submit Kaveri 2 software comes into effect in the year 2018. Therefore, it is ununderstandable as to how the sub-registrar was in deep slumber for about 4 years from 9/6/2014 till 2018 without releasing the property. And now after 10 years comes up with a plea that Kaveri 2 software is not cooperating. If the sale deed would not be released by Friday this week, exemplary costs would be imposed upon the sub-registrar who has not acted on the sale deed, release of sale deed for over 4 years and now for 10 years. 10 years. And the sub-registrar Hebbald, your higher officer yaru? The district registrar shall be present before the court at 2:30 PM on Friday. You play with the citizens, we will not permit, sir. ಯಾವ pending registration? Whatever, ಕೊಡಿ. Yes. 10 ವರ್ಷ ಏನ್ ಮಾಡ್ತಾ ಇದ್ರಿ? For 10 years you don't act? Yes, next.
My lord, the petitioner restricting the prayer, who is concerned, my lord, it is.
Sir, I asked you minority union, majority.
This is majority union only, my lord. But
ಮತ್ತೆ?
this is a rift between the members. Not for anything, my lord, because that general body meeting has already taken place on 24th February.
ಆಗೋಗಿದ್ಯಾ?
ಆಗೋಗಿದೆ.
ಸರಿ.
ಈಗ ಏನು ಮಾಡ್ಲಿಕ್ಕೆ ಇದು?
My lord, anyhow, the
Anyhow.
The petitioners, all India executive members of the association, you are not invited to vote in the association, my lord. Representing the 18,000 members, you are not invited, my lord. Only noted how to participate in the meeting.
Labor court. Yes.
Then, my lord, the
Or
prayer
approach
is-
the labor commissioner. He will pass an order. This I will not interfere. It involves questions of fact. Now that the general body is over,
The true fact, madam.
correct?
Not to give any effect to this.
No, no, sir, we will not approach the competent.
Can you see, my lord, page number 31, my lord?
ಏನು?
Annex D. The same incident took place, my lord. This court passed the order. Page
ಎಲ್ಲಿದೆ?
number 32, my lord, it is.
Page?
32, my lord, it is. Annex D. 32.
That is interim order.
Please, interim
That
order.
was the ex parte order and they withdrawn that petition.
1 minute, 1 minute. May go on. However, subject to the result of the resolution will not be given effect to. ಈಗೇನ್ ಆಗೋಗಿದೆ resolution ಆಗೋಗಿದೆ. That was prior to the resolution.
Now, my lord, because of this incident, my lord, is not to give any effect to, my lord, because.
The rift between two unions in an organization, writ petition is not the remedy.
My lord, we are the majority holders, my lord.
Whoever, sir, it is rift between two unions.
My lord, on the government 22nd to 25, 22, my lord, going to show the mismanaging, my lord, the second respondent. The second respondent is going to show the taking the entire, the control of.
You
the
file your
association.
objections, sir. The learned counsel TP Muttanna seeks 2 weeks' time to file statement of objections. List the matter on 15th April.
In the meanwhile, my lord.
No, meanwhile, yes, next. PH.
My lords, counsel for the petitioner, my lords.
Hmm.
My lords, here I am a resident of a village that is
ಆಯ್ತು,
Ramadeva.
illegal construction ಗೆ,
How's
yeah,
that?
how are you maintaining
My
this?
lords, now what happens is, my lords.
File a
kindly-
suit, sir.
No, my lords, this is illegal construction as in,
Hmm.
my lords, there is a notification which comes to be issued where respondent number 3, which my lordship will find it an annexure D, my
See, you take notice.
which notifies
Learned AGA is directed to accept notice for all the respondents. List on 4th April.
oblige.
Yes.
25.
Discuss for the respondent number 3, my lordship.
R3 ga?
R3 morning itself, I got an instruction, sir, filed.
Wakalat hakidira?
Morning, so I have not yet received the entire instructions, so.
All right. Learned counsel so and so undertakes to enter appearance for the third respondent. Registry to print the name of so and so is appearing for the third respondent. List the matter on 3rd April. Yes.
26.
Next. 3rd Allah. 15th. Yes.
No, I appear for the respondent.
15th. Oh, correct. 16th. Yes.
Manoj, I appeal for the
Covered
respondent. There was a direction to list this matter with WP 8493.
I don't worry about that, sir. It straight away covers what I've already held.
My lord, it's a question of law. We have engaged senior counsel.
The question of law.
Lords, we have to address it on merits. Request that
fine.
both the matters be
Heard.
taken up together.
All right. Learned counsel submits that the Agle Itala order.
Order ittu, my lords. They were supposed to comply. They had not complied.
Oh, ado FR number ಆಗಿದೆಯಾ? WP ಆಗಿದೆಯಾ?
WP ಆಗಿದೆ.
Registry to print, tag the petition along with
WP 8493 of 25.
8493 of 2025. List them both on, you sought an interim order?
No,
Nothing.
no interim order.
List them both on 3rd April.
No, it's 3rd, I'm in Dharwad, my lord.
4th April, yes. Next.
I appear for the respondents in this matter.
6 meter road.
6-meter road. Then I have advised my clients,
Hudson.
I have advised my clients to reconsider. And I have told them also if probably about 10 days or 2 weeks time is granted.
They want one
they-
more representation. Price I have already given part of it.
ಏನಿಗ?
Let the matter be.
Matter will not dispose. We will keep the matter pending. ನೀವು ಏನ್ ಬೇಕಾದ್ರೆ representation ಕೊಡಿ. Dispose ಮಾಡಿದ್ರೆ ಇನ್ನೊಂದು ರಿಟ್ ಆಗುತ್ತೆ ಆಮೇಲೆ ಅದಕ್ಕೆ.
ಇಲ್ಲ
Yes.
ಬೇಡ, dispose
Less-
ಬೇಡ. So
ಅಲ್ಲ,
they will.
Harish sir will not say otherwise, yes. The learned counsel Harish Narsimurthy representing the respondent submits that if 10 days time is granted, they submit that if a fresh representation is submitted to the respondents and 10 days time is granted, the same would be considered and an order would be passed, probably redeeming the grievance of the petitioner. We list the matter on 17th April. ಇವತ್ತು ನಾಳೆನೆ ಕೊಡಿ. Yes. Yes, government salary. ಹೋಗಿ. ಸ್ಯಾಲ್ರಿ ಬೇಡವಾ?
ಇವತ್ತು ಬೆಳಿಗ್ಗೆವರೆಗೂ ನಮ್ಗೆ
ಈಗ
ಕನ್ಫರ್ಮೇಶನ್
ಹೇಳ್ತಾ ಇದೆ AGA is saying the learned AGA, learned AGA on instructions would submit that the salary is ready to be handed over, but the petitioner has to go and take it. The petitioner go and take it, list the matter day after tomorrow, the fresh matters list. ಹೋಗಿ ಇವತ್ತು. Yes, next. Masking.
There are few other matters, minutes.
ಕೊಡಿ ಎಲ್ಲ ಕೊಟ್ಬಿಡಿ. All masking will do. Tag this petition along with so and so on 4th April.
But after 10th minutes, 10th or 15th minutes.
Long vacation ಅಂತ ಯಾರು ಇಲ್ಲ, ಎಲ್ಲ 15th ಮೇಲೆ ಕೇಳ್ತಾ ಇದ್ದಾರೆ.
10th in the 15th or
List
16th.
on.
My lords, a short submission. My lords, we just seek an interim relief.
That I will grant, yes. The list the matter on 16th April at the request of the council, TP Vivekanand, appearing for the second respondent who on the score that there are several other matters pending on the same issue. In that light, list the matter on 16th. There shall be an interim order as spread for to be in subsistence till the next date of hearing.
Much obliged.
30.
Post immediately after service of notice upon the respondent. Interim order there.
Commissioner, my lord. We have complied with the interim order, my lord.
Assistant Commissioner. 10,000.
For second, yes.
Pay ಮಾಡಿದ್ದೀರಾ?
Pay ಮಾಡಿದೀನಿ, madam.
The learned counsel for the petitioner submits that the interim order has been complied with and would be continued to be paid during the subsistence of the petition. In that light, post the matter in B group. Interim order subsisting will continue subject to the aforesaid.
My lord, A date may kindly be fixed. They have filed a civil suit against us for injunction for, and against the tenants, my lord.
Let's, 16th April. Yes.
Much obliged.
31.
Yes.
Petitioner.
FIR register ಮಾಡಿದ್ದೀರಾ?
Let them, they've not gone with the investigation officer.
ಕಂಪ್ಲೇಂಟ್ ಕೊಡಿ. ನಾಳೆ ಕಂಪ್ಲೇಂಟ್ ಕೊಡಿ, FIR ಆಗುತ್ತೆ.
They'll make me sit there.
Done prior, and then their complaint is.
That's all right. List the matter day after tomorrow in the fresh matters list.
There'll be a tax that they.
The learned counsel for the learned AGA on instructions would submit that the petitioner, if the petitioner would appear before the investigating officer / station house officer, the need for the grievance of the petitioner would be redeemed. Therefore, before tomorrow evening, the petitioner shall appear before the investigating officer. List the matter on Friday in the fresh matters list.
Lordship, that is not an issue. They'll make me sit till the evening, your lordship. They'll make
ಆ
me
ತರ
sit the whole
ಕಂಪ್ಲೇಂಟ್
day.
ಬಂದ್ರೆ ಆಮೇಲೆ appear before the investigating officer. 1 minute. If at 3 PM tomorrow.
Much obliged.
Yes. Yes. Next.
32.
Filing the affidavit, my lord.
ಏನದು?
Lordship directed to file an affidavit.
ಸಪ್ಲೈ ಮಾಡಿಲ್ಲ ಅಂತ ಕಾಪಿ
Supply ಮಾಡಿಲ್ಲ.
ಏನ್ ಬೇಡ ಅವ್ರಲ್ಲ ನೋಡ್ಬಿಟ್ಟು ಹೇಳಿ. Tomorrow fresh matters. Next.
33.
Sir, my lord, sale taken place.
For a passover.
Wait, sir.
Engaged services.
Wait, sir.
Sale taken place. My lord, in fact, my lord, mortgagee, my lord, approached this honorable court. This honorable court rejected the, my lord, writ petition and relegated the matter to DRT. Now, my lord, the company filed the present writ petition stating that, my lord, there are certain, my lord, violation, as well as, my lord, last occasion they made a submission before this honorable court. We are ready to pay 33 crore as per the Hong Kong order.
Correct.
My lord, in fact, my lord, as on today, the outstanding, my lord, 45 crore 56 lakh 2.
ಅದು ಬಿಯಾಂಡ್ ದಿ ಡಿಗ್ರಿ ಎಲ್ಲ ಬರುತ್ತೆ.
ಅಲ್ಲ ಬರುತ್ತೆ ಅಲ್ಲ ನಾನು ಹೇಳೋದು ಅಲ್ಲ ಒಂದ್ ನಿಮಿಷ. My lord, here I sold a property for 27 crore rupees. Now there before this honorable court, my lord, some OTS, my lord, we may be able to consider. However, my lord, let them pay. I'm so sorry.
We're willing to pay the 39 crores.
If I can request for a passover.
Hong Kong.
Hong Kong. 39 crores if they pay. I think there could be a,
39 crores.
yes, there must be an additional 39.
ಆಯ್ತು ಬರ್ಲಿ ಪಾಸ್ವರ್ಡ್ ಬೇಕಂತ.
Passover. Or tomorrow you may have.
ಆಯ್ತು ನಾಳೆ.
Tomorrow.
Tomorrow. Yes.
In the fresh matter.
Let's tomorrow. Yes. Great. Intermodal subsist. Intermodal ಇಲ್ಲ ಅಲ್ಲ ಏನು?
Intermodal.
ಇದೆಯಾ?
There is an intermodal.
ಇದ್ರೆ ಕಂಟಿನ್ಯೂ.
There is an.
My lord, interim order granted by this honorable court, taken instruction from the client, my lord, that time sale confirmation already taken place. On 12th.
ಆಯ್ತು senior counsel ಇದ್ದಾರೆ. You for the auction purchaser?
No, I'm for the bank.
Bank. Sir, wait. Yes.
I'm saying, last time he was just telling you Lordship what happened, because I was not there then. That's true.
Oh, that's all right. We'll take it tomorrow.
Right.
Intermodal.
Intermodal.
Please.
For respond number 4, in this matter,
Springfield Welfare Association.
please kindly grant 10
Covered,
days
sir.
time. Meantime,
In
I'm going to
meantime.
file objection, my lord. 2 days back, I received a petition. copy.
Learned Chandrasekhar K seeks 2 weeks' time to file statement of objections. List the matter on 17th. Interim order subsisting will continue till the next date of hearing.
Much obliged.
Next. Ado, B group. Next.
35.
We have filed the affidavit.
Recreation.
Please.
Since there was a, on the last date of hearing, there was a.
Yes.
Your lordship had directed them to file an affidavit.
ಹಾಕಿದ್ದಾರೆ ಅಂತಲ್ಲ.
Undertaking. ಇಲ್ಲ ಅದರಲ್ಲಿ ಇದೆ.
ವೇಗ್ ಅಫಿಡವಿಟ್ ಏನ್ ಹೇಳ್ತಿ ಎಲ್ಲಿದೆ ಅಫಿಡವಿಟ್?
No, I just received the copy now. ಅದ್ರಲ್ಲಿ
20th.
ಲಿಸ್ಟ್ 20th ಬೇಕಾ?
20th I have filed.
20th you filed.
Because
ಏನಿದು ಐ ಹ್ಯಾವ್ ನಾಟ್ ಡನ್ ಎನಿಥಿಂಗ್, ಐ ವಿಲ್ ನಾಟ್ ಡೂ ಅಲೋ ಇಲ್ಲಿಗಲ್ ಆಕ್ಟಿವಿಟೀಸ್. ವೇಗ ಹಿಂಗೆಲ್ಲ ಹಾಕಿದ್ರೆ ಕೊಡಲ್ಲ.
because
ಮತ್ತೆ
they are creating
ಇದು
nuisance to
ಕೊಟ್ಟು
the.
ಬೀಗ ಓಪನ್ ಮಾಡಿದ ತಕ್ಷಣ ಅಂದರ್ ಬಾಹರ್.
My humble submission, my lord. Chief, due to election, they were asked me to close the association.
I have to look into it and tell.
3
No,
months.
your lordship, the allegation is, they are
Gambling.
creating nuisance to the neighbors, littering.
ಅದ್ರ
I
ಬಗ್ಗೆ
produced the
ಏನು
photos also.
ಅದ್ರ ಬಗ್ಗೆ ಏನು ಹೇಳಿಲ್ಲ ಇಲ್ಲಿ.
ಅದೇ.
ಅದೆಲ್ಲ ಡೀಟೇಲ್ ಆಗಿ ಬರ್ಲಿ ಇಲ್ಲಿ.
But submission, my lordship, there is a CCTV footage is there, lordship.
Let everything be there. Your affidavit also should say so.
No, let them give an undertaking that they will not litter or create nuisance to the neighbors.
Give the undertaking. ಈ ತರ affidavit ಹಾಕಿದ್ರೆ ಏನಿಲ್ಲ petition dismiss
But
ಮಾಡ್ತಾರೆ.
produce the photograph also to show
Don't be
that.
very smart in filing affidavits. Yes. List the matter on Thursday. Fresh matters. We'll close it. Correct ಆಗಿ ಹಾಕಿ ಒಂದು.
36. In this case, challenge sale notice, my lord, 2 weeks time may be granted.
For what?
Tenant?
Tenant?
No, my lord,
ಮತ್ತೆ?
I am a borrower. I've complied the order granted by tribunal and I've deposited full amount, my lord, for pertain to one loan account. I've sought for a release of one property. For that, last date of order, I wanted to go to the
Consider
bank.
ಮಾಡಿ.
ಅವ್ರು ಬಂದೇ ಇಲ್ಲ ಸ್ವಾಮಿ. Because my lord, in this case, if he is ready to pay 2 crores 25 lakhs, we are plus.
Sit across.
We are ready. They released one property, my lord, I'll clear entire loan amount.
One
my
minute.
lord.
That song we'll listen later.
Whatever the outstanding amount is there, if they release this property.
I told you sit with the bank. I will not enter into your problems with the bank.
No, my lord, petitioner has undergone.
See, I've already said, approach the bank.
Petitioner
This
had
court
gone-
on 14/3/2025 had passed the following order. Counsel for the respondent bank submits that the petitioner has not approached
My
the
lord,
bank
15th
as was directed.
One submission, my lord, on 15th, petitioner had undergone heart surgery.
1 minute,
my lord.
madam. Therefore, finally, and the learned counsel for the petitioner submits that the petitioner has undergone surgery and could not go before the bank. And if 2 weeks' time is granted, he would sit with the bank and close the matter. The learned counsel appearing for the respondent bank submits that if 2.25 crores is submitted, the entire account would be closed, which in that light, list the matter on 17th. By then, the petitioner shall approach the bank as directed on 14/3/2025. In the event he would not approach, the interim order would stand vacated. Yes, next.
37.
Parole, my lord. The offense is under section 3.
Parole. ಏನು offense ಏನು?
302, my lord.
ಎಷ್ಟು ವರ್ಷ ಆಗಿದೆ?
2 ವರ್ಷ 2 ತಿಂಗಳಾಗಿದೆ.
2 ವರ್ಷ 2 ತಿಂಗಳಾಗಿದೆ.
ಅಲ್ಲ, there is a medical emergency, my lord.
Huh?
There is a medical emergency.
ಏನ್ ಮೇಡಮ್ ಅದು?
He is in the end stage of kidney disease.
Dialysis ಆ?
ಹೌದು, end stage of kidney disease. I have produced the medical certificate, my lord.
Your lordship.
ಅವ್ರಿಗೆ thrice a week.
ಯಾರಿಗೆ?
Convict ಗೆ.
ಹಾ.
ಆ,
ಯಾಕೆ
thrice a week.
ಅಲ್ಲಿ ರಿಪೋರ್ಟ್ ಇಲ್ವಾ?
Page number 10, it is.
Madam, lordship, he's been, they have to amend the cost title.
ಅಯ್ಯೋ, ಡಯಾಲಿಸಿಸ್ ಪೇಷಂಟ್ ಅಂದ್ರೆ ಅಮೆಂಡ್ ದ ಕಾಸ್ಟ್ ಟೈಟ್ಲ್ ಅಂದ್ರೆ ಏನು? ಹಾ.
He's actually been, he's in Shimoga prison.
All right.
Bangalore prison.
All right.
That is amended.
What I got to know, I asked for the report.
ಎಷ್ಟು ವರ್ಷ ಆಗಿದೆ? 2 years and?
2 ವರ್ಷ 2 ತಿಂಗಳಾಗಿದೆ. I have amended, my lord. ಅದು ಪರಪ್ಪನಗ್ರಹಾರ ಅಂತ ಆಗಿತ್ತು. I have amended.
ಹಾ, ಶಿವಮೊಗ್ಗ ಅಂತ ಮಾಡಿದ್ದಾರೆ.
The lordship may have this matter.
Tomorrow I am granting if there is no information. Yes, tomorrow in the fresh matters list. Next.
38. 10/3 ಆರ್ಡರ್ ಮಾಡಿದ್ರೆ
ಏನು ಮಾಡಿದ್ 10/3
ರೆಗ್ಯುಲರೈಸೇಷನ್ ಗೆ ತಗೊಂಡು ನಾವು 19 lakhs what was required for regularization was paid. Last ಅದೇನ ಅವ್ರು GST ಕಟ್ಟಿಲ್ಲ ಅಂತ.
ಅದು ಕಟ್ಟಿದ್ರಾ?
ಅದು ಕಟ್ಟಿದ್ದೇವೆ. ಮೊನ್ನೆ ಡಾಕ್ಯುಮೆಂಟ್ಸ್ ಕೊಟ್ಟಿದ್ದೆ.
Yes, petitioner is not approached to the branch, my lord, to regularize the account. He has to give the letter.
We have given out.
ಎಲ್ಲಿದೆ?
ಮೊನ್ನೆ ಅವ್ರು ಸಿಕ್ಕಿದಾಗ ಹೇಳಿದ್ರು ಅಂತ ಮೊನ್ನೆ ಶನಿವಾರನೂ ಕೊಟ್ಟಿದ್ದೇವೆ.
ಎಲ್ಲಿದೆ ಲೆಟ್ರು? Day after tomorrow. Yes.
ಎಂಟ್ರಿ ಮಾಡಬೇಕು.
Entry order subsisting will ನಾಡಿದ್ದು ಮಾಡಿಲ್ಲ ಅಂದ್ರೆ ವೆಕೆಟ್ ಮಾಡ್ಬಿಡ್ತೀನಿ.
ಲೆಟರ್ ಸಮೇತ ಮೆಮೊ.
ಆಯ್ತು. Less the matter day after tomorrow.
39.
Short issue.
Entry order short issue ಇರೋದೇ ಇಲ್ಲ ಇದ್ರಲ್ಲಿ.
Short issue is more than 2 minutes, my lord, I will not take. There is a clause, my lord, in
1 minute.
KERC regulation. At page 60, your lordships will find.
1 minute, Shri Bose. Yes, Sumana madam.
They take my lord to file wakalat for respondent.
I'm
One
praying for interim order, my lord.
1 minute, sir.
Aye.
1 minute.
So,
For respondent 1 and 2, my lord, I've received copy on Thursday evening.
Hmm.
My lords permit me the shortest accommodation to file a response only with regard to the engine prayer.
Then don't precipitate till then.
It's not,
Precipitation,
my
Allah.
lord.
Huh?
It is not precipitation, not something else. I'll
May I-
just, that's
may
why,
I
my lord, 2 minutes I'll
clarify?
take.
Ah,
2 minutes I'll take.
1 minute. Yes, yes.
Page 60, my lord, is a condition
Hmm.
that in case of layouts and buildings, suppose, my
Hmm.
lord, the layouts and buildings are in one cluster
Hmm.
and the aggregate demand exceeds 7,500, I have to construct a substation.
Hmm.
This is, my lord, the condition, page 60, my lord.
Hmm.
Last 3.2.4, your lordships will find. ಅದು ರೈಟ್ ಸೈಡ್ ಅಂದ್ರೆ ಅದು ಮೊದಲು ಅನ್ಅಮೆಂಡೆಡ್ ಇದು
ಆಯ್ತು ಆಯ್ತು ಹೇಳಿ.
ಈಗ ಲಾರ್ಡ್ಶಿಪ್ಸ್ ಮೇ ಸಿ ದ ಕಂಡೀಷನ್ ಇಂಪೋಸ್ಡ್ ದಟ್ಸ್ ಆಲ್ ಐ ಆಮ್ ಶೋಯಿಂಗ್ ಟು ಯರ್ ಲಾರ್ಡ್ಶಿಪ್ಸ್ ದಿಸ್ ಕಂಡೀಷನ್ ಐ ಆಮ್ ಸೀಕಿಂಗ್ ಫಾರ್ ಅ ಸ್ಟೇಮ್ ಲಾಟ್ ಪೇಜ್ 42 that highlighted portion 42 ಲಾಟ್ ಸದರಿ ಬಡಾವಣೆ ಸೋ ಅಂಡ್ ಸೋ
ಹಾ ಏನ್ ಹೇಳಿ.
ಇದರಲ್ಲಿ 5,285 ಆಗಿದೆ, ಸೊ 6,000 ಆಗಿದೆ. That phase 4 and phase 2 ಲಾಟ್. They say in future if you construct something and if that exceeds you will pay 7,500. That can't be done
I
because
file your objections.
Permit me to
that's
file
all I am
objection.
saying. Let this condition be, my lord, not insisted upon till then. Because in
Learned
future
counsel.
ಏನಾಗುತ್ತೆ?
Learned counsel Sumana Naganan seeks 2 weeks time.
Any shortest accommodation.
6 weeks time to file statement of objections. The learned counsel Sridhar Prabhu takes this court through.
Sorry, my lord. To
Otherwise, don't precipitate till the next one.
precipitate action, my lord. The facts are this, my lord. This is one contiguous land which they've broken up into 5 separate
Quincy
areas.
will hear you.
5 layouts.
File your
My lord,
objection.
please kindly accommodate.
Let this
1 minute,
condition
my
be
lord.
not imposed is
No,
what I
no,
am.
Right, sir.
this condition is not imposed for the 2 layouts where he's made an application, my lord. For
Correct.
layout 3 and 4, he has himself admitted in his petition, my lord, that it is less than 7,500
Correct.
kW. There is no restriction insofar as these 2 layouts
Correct.
are concerned at all.
7,500 ಕಿಂತ ಜಾಸ್ತಿ ಇರೋದಿದೆಯಾ?
ಹಾ, ಬೇರೆ ಯಾವ್ದೆಲ್ಲ ಇದಕ್ಕೆ ಸೇರಿಸ್ತಾ ಇದ್ದಾರೆ.
My lord, for layout 1, 2 and 5, he has
Ah.
not even made an application
I
for
have made.
electrification. If such an application is made and if it exceeds that, then that would be a breach that.
I'll take it on
Petition
Friday. You file your objection only on the interim
That
prayer.
petition number also I'll give it right now.
My lord, kindly accommodate me till
Friday, yes. At the request of counsel Sumna Naganan, list the matter on Friday in the fresh matters list for filing of objections on the interim prayer.
Please.
And that other writ petition number, my lord,
ಕೊಡಿ.
ನಾನು
Tag the petition ಎಲ್ಲ ಅದ್ರಲ್ಲಿ ನೀವಿದ್ದೀರಾ ಮೇಡಮ್?
No, we don't have copy, my lord.
ಕೊಡ್ತೀನಿ, ಕಾಪಿ ಕೊಡ್ತೀನಿ.
ಅದು ಬಂದಿದೆಯಾ ಒಂದ್ಸರಿ ಅದ್ರ ಕೊಟ್ಟು
ಒಂದ್ ಸರ್ತಿನೂ ಬಂದು.
ಬರ್ಲಿ ಅವತ್ತು. ನಾಳೆ ಅದು ಪೋಸ್ಟ್ ಮಾಡ್ಸೋಣ, ಆಮೇಲೆ ನೋಟಿಸ್ ಮಾಡಿ.
Great.
ಎಸ್ ನೆಕ್ಸ್ಟ್.
But name may be shown in the list.
Registry to print the name of Sumana Nagaran is appearing for
1 and
respondents 1 and 2. Yes, next.
3, my lord, respondent 3 is the commission, my lord. N. Prakash perhaps.
BN Prakash appear ಆಗ್ತಾರೆ ಅದಕ್ಕೆ?
ನೋಟಿಸ್ ಮಾಡ್ಬಿಟ್ಟು ಸಾಕು
My
ಅವ್ರಿಗೆ.
lords are
ಏನ್ ಪ್ರಕಾಶ್
directed
ಹೆಸರು ತೋರ್ಸು.
notice to me for all 3. I only appear for 1 and 2.
1 and 2 ಇದನ್ ಸುಮನ್ ನಾಗರಾಜ್ ಅಂತಿದೆ.
ಹೌದಾ?
ತಪ್ಪ.
typography.
1 and 2 Sumana Naganand and 3 BN Prakash. Yes.
I'll serve a copy.
Yes, next.
Kindly pass over moments.
ART.
Senior is engaged in something.
Respondent, my lord.
Which respondent, madam?
R1, R2, my lord. Kindly pass over. Senior is held up with another court hall.
ನಿಮಗೂ pass over. Passed over to tomorrow. List tomorrow in fresh matters. Next. Yes, freezing.
51.
ಕಾರಣ. Yes, Jafar.
Yes, well.
First time. ಇಲ್ಲ, secure instructions ಆಗಿದೆ.
Kindly pass it over.
ಇದು ನಾಳೆ. Fresh matters. Yes.
May be taken up with one more petition minutes.
ಇನ್ನೊಂದಿದೆಯಾ?
ಇನ್ನೊಂದಿದೆ, ಬೇರೆ ಅವ್ರದ್ದು.
Like the petition so and post it in preliminary hearing. Yes, next tomorrow.
42.
I was directed to serve copy to council.
ಮಾಡಿದ್ದೀರಾ?
My lord, I could not find out. Therefore, I have sent by registered postman.
Learned counsel submits needful has been done. Office to verify. Interim order there.
Interim order may be extended.
Interim order subsisting will continue to the next date of hearing.
Much.
43.
For the petitioner in this case, my lord.
43.
Yes, my lord.
Saravana.
Yes, my lord. Here,
Where
the
is
superintendent of police.
Sir one
office-
Prasanna Kumar ಇಲ್ಲೇ ಇದ್ರಲ್ಲ? ನೇಮ್ ಇದೆ, ಕಾಪಿ ಕೊಟ್ಟಿದ್ದೀರಾ?
Yes, my lord.
My lord, what happened in this case is Superintendent of Police ACB of North Wing of Belgavi registered a crime under section, crime number 6 of 2020.
Now this is enforcement, right?
Yes, my lord.
ಇವ್ರೇನ್ ಮಾಡಿದ್ದಾರೆ?
Later on, they have summoned and they have filed on 11/2/2025, they are summoned.
Summons under section 50.
Yes, my lord.
ಏನ್
After that,
ತಪ್ಪು?
they have been, after that in 25/2/2025, interim order has been granted against the first crime, my lord.
Entry order ಇದ್ರು ಸಮನ್ ಮಾಡಿದ್ದಾರೆ ಅಂತ. List the matter on 4th April.
Interim.
The respondent shall not precipitate the matter till the next date.
Please.
Yes. Next.
44.
ಅದು ಹರ್ಡ್ so and so ಅಂತ ಹಾಕಿ ಅವ್ರ ಹೆಸರೇ.
This under the Senior Citizen Act, the respondent has changed the order to change the kata of the property. Page number 19, my lord, operation reports of the order, page 19.
ಈಗ ಎಷ್ಟು ಕೊಡ್ತಾ ಇದ್ದೀರಾ?
ಅಲ್ಲ sir,
ಮೇಂಟೆನೆನ್ಸ್.
maintenance ಅಲ್ಲ.
ಅದ್ ನನಗೆ ಗೊತ್ತು ಏನು ಅಂತ. ಈಗ ನೀವು
ಅಲ್ಲ, ಇದ್ರ-
ರೆಸ್ಪಾಂಡೆಂಟ್
May request, may submit.
ಒಂದ್ ನಿಮಿಷ ಸರ್. ಈಗ ರೆಸ್ಪಾಂಡೆಂಟ್ 3ಗೆ ದಟ್ಸ್ ಯುವರ್ ಮದರ್.
Mother-in-law, she has got some more properties. I have also stated at page number 31.
who are her children?
They are,
Mother-in-law ಅಂದ್ರಲ್ಲ.
or the mother-in-law,
Ah.
it's the second son.
ಯಾರು?
You know, the second son, wife, my lord,
Oh, he is no more?
no more,
Hmm.
no more. And she has got other property, more than 120 coconut trees are there. She is there and also she is residing with the third son.
All right, file your objections.
Page
Yes,
number
respondent.
57.
File your objections.
Please, my lord, I file objection.
List on 17th objections, if any, by then interim order subsisting will continue to the next date.
Please. And my,
Huh?
Daughter-in-law is not there.
Stay ಕೊಟ್ಟಿದ್ದೀನಲ್ಲ ಈಗ ನೋಡೋಣ.
and my name has to be, my senior's name has to be correctly shown.
ವಿದ್ಯಾ ನಾರಾಯಣ ಶರ್ಮಾ ಅಲ್ವಾ?
YK.
YK Narayan.
YK Narayan Sharma.
YK, okay.
Registry to print the name of YK Narayan Sharma
In both the cases.
appropriately as third respondent, appearing for third respondent in both the cases.
In both the cases.
44 and 45.
Acha.
Interim order subsisting 17th April. Next. Electric line compensation. ಕೊಡಿ.
My lord, without notice, not a notification has been issued, my lord, under section 67 of the Act.
ಏನು ಇಲ್ಲ. DC ಮುಂದೆ ಹೋಗಿರ್ತೀರಾ, ಎಲ್ಲ ಪ್ರೊಸೀಡಿಂಗ್ ಅಲ್ಲೂ ಪಾರ್ಟಿಸಿಪೇಟ್ ಮಾಡಿರ್ತೀರಾ. ಕಾಂಪನ್ಸೇಷನ್ ಸಾಕಾಗಿರಲ್ಲ, ಇದಕ್ಕೊಂದು ರಿಟ್.
Economically, kindly see, my lord, annexure G.
ಎಲ್ಲ ಲೆಟ್ ಹಿಮ್.
Annexure G, my lord, ink page 63.
What is your ground? Deputy Commissioner ಹತ್ರ you did not appear?
ಅಲ್ಲಿ ಹೋಗಿಲ್ಲ.
ಮತ್ತೆ?
ನಮಗೆ, they have to seek the approval of the government as per section 67.
I will see.
ನಮಗೆ
ಕಾಂಪನ್ಸೇಷನ್ ಈಗ ಎಷ್ಟು ಫಿಕ್ಸ್ ಮಾಡಿದ್ದಾರೆ?
compensation,
Your ground is fixing of compensation is unlawful.
ಅಲ್ಲ.
ಮತ್ತೆ ಬನ್ನಿ,
We have challenged-
grounds on interim prayer ಬನ್ನಿ ಇಲ್ಲಿ.
ಅದಾಯ್ತು, ಬಟ್ ನಾವು ಒಳ್ಳೆ ಸಾರಿ grounds for interim relief.
Yes, government.
Secure instructions in this matter.
KPTCL ಇವರಲ್ಲ.
KPTCL, ಇವರು ಗೌರ್ಮೆಂಟ್ 1 and 4 ಈಗ ಅವ್ರು.
1 and 4 AGA, 2 and 3 ಅಲ್ಲ 1, 3 and 4 AGA. 2 ಮಾತ್ರ.
ನೋಡ 3, 2 and 3 ಹೌದು 1, 3 and.
Yes. 2 ಮಾತ್ರ. Learned counsel for the petitioner to serve requisite set of papers upon ಯಾರಿದ್ದಾರೆ ಮೇಡಮ್? KPTCL. ಅದಲ್ಲ, ಇದಕ್ಕಲ್ಲ, KV ಅಲ್ಲ, ಡಿಸ್ಕನೆಕ್ಷನ್ ಅಲ್ಲ. ಡಿಸ್ಕನೆಕ್ಷನ್ ಗಾದ್ರೆ this is a different. Devraj, HV Devraj is directed to accept notice for the second respondent petitioner to serve set of papers upon the said counsel. ಈಗೇನು ಅರ್ಜೆನ್ಸಿ ಏನು?
Urgency ಅಂದ್ರೆ my lord, they may draw the line, my lord. There are thick forest, my lord. They are.
Status quo, the property be maintained till the next date of hearing, list the matter on 3rd April in the fresh matters. Yes. Next, the heard senior counselor.
Please.
47.
Parole. First time, huh?
First time.
Learned AGA is directed to accept notice for the respondent, secure instructions and make submissions. 366-4. Offense is 366-2. List on 1st April. Yes.
48.
As per the direction of the son of report, I have served the copy to the respondent.
ಏನಾಯ್ತು? ಇದು ನಾವು Sir, ಮಾಡಿದ್ದೀರಾ?
Yes, sir. 20
Counsel for the petitioner submits needful has been done, office to verify list after 2 weeks, IO. Next. ಎಷ್ಟು 3 ಲಕ್ಷದ ಇದು?
Sir?
3 ಲಕ್ಷದ ಲೋನ್ ಅಲ್ವಾ?
Loan, but entry ಮಾಡ್ರೆ maybe.
ಅದು ಗೊತ್ತು. ಎಷ್ಟು ಲಕ್ಷದ ಲೋನ್?
2 crore change ಇದೆ.
ಮತ್ತೆ?
But we are not a borrower. That is my
So?
intention.
Who are you?
So I am the absolute owner of the property. So that why only I have produced the Kata extract
I
and
will see.
how
Yes.
I got the everything.
List on 17th ಮಾಡಿ. Next.
Entry ಮಾಡೋ maybe.
49.
I appear for the respondent bank.
ಏನಿದು? What are these connected matters?
All are regarding the same scheduled property.
ಹಾ.
49 and 49.2 challenge the sale notices. Sale did not happen on the day on which it was slated.
ಆಯ್ತು.
Therefore, 49 and 49.2 would become infructuous. Therefore, those two writ petitions can be disposed of. my
What is
full
49?
submission. 49 and 49.2.
ಆಯ್ತು.
49.1
ಹಾ.
is the possession notice which is challenged. I'm sorry, the possession order, the magistrate.
ಅದೆರಡು ಕ್ಲೋಸ್ ಮಾಡೋದಾ? Should we close the other two?
49 can be closed, Your Honor.
49 point, those two can be closed.
49 because in that one.
49 and 49.2.
In 49.2, an ad interim order of stay was granted by this honorable court, asking the petitioners to deposit 1 crore 8 lakhs, not a rupee was paid.
No.
I will
One submission, Your
take it
Honor.
at 2:30.
Please.
Yes. Continue ಮಾಡಿ. ಅಲ್ಲ ಒಂದು ನಿಮಿಷ. ನಿಮಗೆ ಎಷ್ಟಾಗುತ್ತೆ ನೋಡ್ತಾ. ಇನ್ನೊಂದು 3 minutes. Yes.
Interim order complaint.
Prakash Hegde.
Paying for the respondent bank, my lord. My lord, the sale did not materialize on the scheduled date.
Interim order is complied?
Is complaint.
ಎಷ್ಟು ಡೆಪಾಸಿಟ್ ಮಾಡಿದ್ರಿ?
34 lakhs 60,000.
ಎಷ್ಟು?
34 lakhs 62.
So we'll
2.38 ಅಂತ ಹೇಳಿದ್ರು. crores.
we'll ask them to take note of that in the event another sale notice is issued.
Immediately they will issue model.
Sorry. Learned counsel with the petitioner.
34 lakh again.
Petitioner submits that the,
What yes, you are.
one ನಿಮಿಷ. Counsel with the petitioner submits the interim order has been complied with, which is acknowledged by the respondent. The learned counsel with the respondent further submits that the sale has not taken place on the said date. Therefore, the date of auction has spent itself. The learned spent itself, and therefore the petition is rendered infructuous. The learned counsel for the petitioner submits that if it is closed as having become infructuous, they would issue a second sale immediately. In the event the bank would issue a second sale immediately, the amount the bank could want to issue the second sale immediately, the amount that is deposited by the petitioners shall be taken note of, which would inure to the benefit of the petitioner in the event he would approach this court yet again. With the aforesaid observation, petition stands disposed.
Grateful.
Yes, next. Next time sell ಮಾಡಿದ್ರೆ no deposit. We'll state without deposit. Yes.
My lord, I am for the respondent.
Pertaining to freezing of the account, my lord.
Yes, Francis.
My lord, in this case, my lord, we received 2 intimation.
From where, sir?
From one intimation from Prananagar Police Station, Rajkot.
Rajkot.
Rajkot, to
ಎಷ್ಟು?
hold the fund of rupees 25 lakh, 25,000.
ಎಷ್ಟು?
25,000.
25,000.
Accordingly, we marked to hold the fund of 25,000. The
Clean
first,
mark ಮಾಡಿದ್ದೀರಾ ಏನು?
the freezing.
Use ಮಾಡು.
ಆಮೇಲೆ the secondly, my lord, the another intimation was received from the Tirupati police stations, my lord. In that, my lord, the amount has not been specified. In the second intimation.
Okay.
Put office. My lord, under these circumstances, my lord, as far as the first intimation is concerned, 25,000 rupees have been freezed. As far as the second intimation, my lord, there is no, the amount
So,
has not
we'll
been specified.
permit defreezing. The petitioner.
ಎರಡು no reference.
Ah,
There are 2 references.
2:30 dictate ಮಾಡ್ತೀನಿ. Yes. 2:30 ಅಲ್ಲ, ಒಂದು 2:30 ಪಾರ್ಟೆಡ್ ಮ್ಯಾಟರ್, 3:30 ಬನ್ನಿ. Yes. ಸಾಕು, ಕರೀರಿ. Police protection, 10:30, yes.
My lord, I moved a memo morning, my lord. Memo has not been come.
Why?
But it's a surface matter, my lord, for
Girls,
2:30 I
wait, ಎಲ್ಲದಕ್ಕೂ urgency, wait, yes.
My lord, pardon my lord. My lord. The surface matter.
25th ನಾಳೆ ಅಲ್ವಾ? ಅಲ್ಲ 25th ನಾಳೆ ಅಲ್ವಾ? ನಾಳೆ ಡೇಟ್ ಇದ್ರೆ ಬರುತ್ತೆ.
My lord, surface matter. My lord, morning I moved the memo.
Stop this habit of moving at 1:30. At any time memo will be taken, and if you begin to move, then I will not take any memos. Don't misuse.
Tomorrow there is an auction.
ಮತ್ ಬೆಳಗ್ಗೆ ಏನ್ ಮಾಡ್ತಾ ಇದ್ರಿ?
ಬೆಳಗ್ಗೆ ನಾನು ಮೂವ್ ಮಾಡಿದೆ
ಅದು ಬರುತ್ತೆ ಬಿಡಿ.
ಮೆಮೊ ಬಂದಿಲ್ಲ.
ಬರುತ್ತೆ. ಬೇಕಾದ್ರೆಲ್ಲ ಬೆಳಗ್ಗೆ ಮೂವ್ ಮಾಡಿ. ಹೌದಾ? ಆಯ್ತು. It will come, sir, tomorrow, don't worry. ಸ್ಕ್ರೂಟಿನಿಗೆ ಹೋಗಿರುತ್ತೆ ಮೆಮೋ ಸ್ಕ್ರೂಟಿನಿ ಆಗಿದ್ರೆ ಬರುತ್ತೆ.
No, my lord, they are not allotted it.
ಅದ್ ನೋಡಿ ಮೇಡಮ್, ನಾಳೆ ಸೇಲ್ ಇದ್ರೆ ತಗೊಳ್ಳಿ. At 2:30 ಮ್ಯಾಟರ್ ತಗೊಳ್ಳಿ. ಎಸ್.
The association. To reserve one school for, to create one more code for the joint secretary for women.
ಜಾಯಿಂಟ್
Joint secretary.
ಹಾ.
Joint secretary For women, to create one more post. And as on today, my lord, one seat for reserved for women.
That is governing council.
Governing council.
Bylaw
owns the
number,
reservation.
bylaw number 7.
Yes, madam. Then we create two more executive members.
ಯಾವಾಗ?
ಅಲ್ಲಿ ಈ ಎಲೆಕ್ಷನ್ ಮಾಡಿಸ್ತೀವಿ ಅಂತ. ಒಂದು ಅಡಿಷನಲ್ ಜಾಯಿಂಟ್ ಸೆಕ್ರೆಟರಿ ಫಾರ್ ವಿಮೆನ್. Two more executive members. Then we will go for amendment of the bylaw after the election.
ಈಗ after the election, whatever you want,
ಅದೇನೆ.
proportionate ಆಗಿ. This
Yes,
is
madam.
okay.
Please, my lord. My
But
lord,
we will
let-
pass a detailed order and record your submission.
Yes, madam.
Yes.
Lord, they may submit a report what is,
ಅಲ್ಲ, my submission
This
can be
submission
taken.
I will record, that will be a part of the order. We will
Please,
pass an order disposing the petition.
please, my lord.
Yes.
My lord, because same situation arose before Supreme Court where Delhi Association made the same submission, but that meeting failed for want of majority,
But
two-thirds majority.
matter was still pending, matter is still pending before the
Please,
apex court.
it's still pending.
Now I am disposing it. If there is anything, you can come back.
Please, my lord, I'll be
Yes.
obliged.
And ತಗೊಂಬಿಡಿ. The petitioners are advocates practicing in the Tumkur Bar Association. They are at the doors of this court in the subject petition, seeking a direction by issuance of a writ in the nature of mandamus to the sixth respondent association to implement 33% reservation for women in the upcoming elections scheduled to commence on 5/4/2025 in tune with the judgment of the apex court in SLP 1404 of 2025. Heard the learned counsel Srimati Vidyashri appearing for the petitioner along with other counsels, and the learned senior counsel R.S. Ravi representing the sixth respondent, Tumkur Bar Association, and the learned AGA for the state. The facts in brief, germane, are as follows. The petitioners, as observed herein above, are members of the Tumkur Bar Association. Tumkur Bar Association today has 1,850 members. Out of 1,850 members who are eligible to vote, and out of them, 350 members are said to be women, which would amount to more than 20% of the representation of the Tumkur Bar Association being women. On the strength of the judgment of on the strength of the order passed by the apex court, the petitioners herein submit a representation to the returning officer, who was by then appointed. Returning officer ಕೊಟ್ರೆ ಯಾರು ಕೊಟ್ರಿ?
ಇಲ್ಲ, secretary ಕೊಟ್ಟಿದ್ದಾರೆ.
To the secretary of the association on 5/3/2025, seeking certain posts to be reserved for women. That comes to be rejected on 17/3/2025, and challenging the same, the petitioners are before this court. The learned counsel Srimati Vidyashri appearing for the petitioner would vehemently contend, taking cue from the judgment of the apex court in the case of Dakshana, Amritesh, Diksha Amritesh versus so and so, to contend that the petitioners in the case at hand, the association in the case at hand, should also be directed to provide such reservation for women in terms of for women to the tune of 33% being the demand. The learned counsel submits that the elections should not be permitted to be held without the reservation adequately provided now and in future to become a part of the bylaw. The learned counsel would seek the direction as is sought in the petition. The learned senior counsel, per contra, the learned senior counsel R.S. Ravi representing the respondent. Sixth respondent would on instructions and would on instructions submit inter-alia.
We will create one joint secretary post for women.
Would submit that one post of joint secretary
Would be created now for women.
The learned senior counsel would submit that certain posts would be created for women in the ensuing elections, and it would appropriately amend the consider amending the bylaw at a later point in time, looking at who would form the office bearers of the association. In that light, the learned counsel submits that the petition be disposed. Therefore narrated facts are not in dispute. I've given my anxious consideration made by the respective learned counsel. The membership of the Tumkur Bar Association being at 1,850 who are eligible to vote is not.
ಅಲ್ಲಿ ಏನಾಗಿದೆ ಅಂದ್ರೆ ಒಟ್ಟು ಮೆಂಬರ್ಸ್ ಎಲಿಜಿಬಲ್ 1,220 ಔಟ್ ಆಫ್ ವಿಚ್ ಮೇಲೆ ಪುರುಷರು 990 ಅಂಡ್ ಲೇಡಿ 230.
ನೀವು ಪೆಟಿಷನ್ ಏನೋ ಹೇಳಿದ್ದೀರಾ ಮತ್ತೆ ಬೇರೆ ಏನಾದ್ರು
ಎಲಿಜಿಬಿಲಿಟಿ ಲಿಸ್ಟ್.
The learned the afore narrated facts are not in dispute. As on today, in terms of the voters list drawn, 990 are men and 230 are women, forming a total of 1,290. 1,220 to be the eligible voters in the ensuing election. The apex court, a coordinate bench of this court, on a similar demand made by the association, by the Bangalore Bar Association, declined to accede to the request on the score that it was too late in the day for any reservation to be prescribed. This was taken to the apex court to the apex court, wherein the apex court, exercising its jurisdiction under Article 142 of the Constitution of India, passed the following order. Quote, madam, from page 1921. The learned following order. The apex court directed that a post of treasurer be exclusively earmarked for women candidates, as also the post of vice president to be created and earmarked. The two were directed or permitted to be interchangeable. It so happened that the post of treasurer is now held by a woman in the Bangalore Bar Association. Therefore, the said application was rendered infructuous and the matter was directed to be listed at a later date by the apex court. The same is with the case of Delhi Bar Association, Gujarat Bar Association, all of which matters are pending before the apex court. The issue now would be consideration of earmarking certain posts by way of reservation to women in the Tumkur Bar Association. The learned counsel R.S. Ravi, senior counsel R.S. Ravi, would submit that the post of joint secretary would be created and be reserved for women,
and two more executive members.
And two additional executive members apart from the reservation that is already provided under the bylaw would be notified prior to the commencement of the elections. This would amount to some solace for the present to the women lawyers who are now agitating for 33% reservation. But this cannot be a temporary solution. The Bar Association, the Bangalore Bar Association, which is the direction of the apex court, Bangalore Bar Association should be implemented by Tumkur Bar Association, or the bar associations should be implemented by the bar associations of the benches at Dharwad and Kalburgi, or every other bar association that is now wanting to conduct elections to the office bearers The petitioners herein are projecting their right under Article 14 and 15 of the Constitution, which is elucidated in elaboration by the apex court in the case of Indira Swani. The Article 14, which directs equality to be maintained, and Article 15, which prohibits any gender discrimination, would completely become applicable to the facts of the case at hand, as the petitioner women advocates cannot be discriminated on the score that they are women and cannot be held that they are not entitled to certain reservation in the bar association, in the elections of every bar association, in fact. Therefore, with the submission of the learned senior counsel, the present petition may have met its the present petition may have led to redemption of the grievance of the petitioner, but that would be temporary. I therefore direct that it is not only morally compelling, but legally expedient for all the bar associations to generate that equal right, generate equal right to women, their representation in every such bar association, which will result in dismantling or taking away the associations hitherto being bastions of the male or the old men's club, as it is generally called. As otherwise, no woman in the nation or in the associations should ever lament that in a nation governed by the vibrant constitution, they should not feel that they are, notwithstanding the fact that they are half the world, do not have even half the chance. In the light of the aforesaid circumstance, I deem it appropriate to pass the following order. So and so, mandamus issues anta ಮಾಡಿ ಅವ್ರು ಯಾವ್ಯಾವ ಪೋಸ್ಟ್ ಕ್ರಿಯೇಟ್ ಮಾಡಕ್ಕೆ ಹೇಳಿದಲ್ಲ ಮೇಲೆ ಮಾಡಿ ಅದನ್ನ ಕೋಟ್ ಮಾಡ್ಬಿಡಿ.
And we can, Lakshmi kindly direct us to hold election.
ಆಮೇಲೆ this in the light of the aforesaid submission of the learned senior counsel, the Tumkur Bar Association, the returning officer shall redraw the calendar of events accordingly, and continue the process of election thereon. Yes.
My lord,
Election may kindly be completed within 1 month from today.
Well, that can be done, yes.
please.
The elections that were set into motion be completed within 1 month from the date, from today, yes. We'll release it tomorrow morning.
Please, my lord. The petitioner's only clarification is that joint secretary is exclusively reserved for women.
ಅದೇ ಹೇಳಿದ್ದವ್ರು.
My lord, my instructions were in joint secretary, they will reserve 1 post for men and 1 post for women.
ಎಷ್ಟು ಜಾಯಿಂಟ್ ಸೆಕ್ರೆಟರಿ ಪೋಸ್ಟ್ ಇದೆ?
ಒಂದೇ ಇರೋದು.
ಅದೇ ಎರಡು ಜನರಲ್ ಸೆಕ್ರೆಟರಿ ಎಕ್ಸಿಸ್ಟಿಂಗ್ ಇದೆ. We are creating joint secretary.
Joint secretary already ಇದೆ post.
ಇದ್ರೆ ಎಕ್ಸ್ಕ್ಲೂಸಿವ್ ಇಯರ್ ಮಾರ್ಕೆಟ್ ಫಾರ್ ವಿಮೆನ್.
Please, that is the clarification that they want.
All right, yes.
Please, my lord. Additional.
Joint secretary ಇದೆ. My lord, at present, my lord, president, vice president, general secretary, joint secretary.
Sir, for the present, ನೀವು ಏನು ಕೊಡಬೇಕು ಕೊಡಿ.
ಅದೇ ಜಾಯಿಂಟ್ ಸೆಕ್ರೆಟರಿ ಒಂದಿದೆ, ಪ್ಲಸ್ ಒಂದು ಜಾಯಿಂಟ್ ಸೆಕ್ರೆಟರಿನ ಕ್ರಿಯೇಟ್ ಮಾಡಿ ಕೊಡ್ತಾ ಇದೀವಿ ಅಂತ ಹೇಳ್ತಾ ಇದ್ದೀನಿ.
ಜಾಯಿಂಟ್ ಸೆಕ್ರೆಟರಿ ಒಂದಿದೆ.
ಹೌದು.
ಇನ್ನೊಂದು ಕ್ರಿಯೇಟ್ ಮಾಡ್ತಾ ಇದ್ದೀವಿ. ಕ್ರಿಯೇಟ್ ಮಾಡಿ ಇನ್ನೊಂದು ಕೊಡ್ತಾರೆ. There will be 2 joint secretaries.
Please.
One for a man, one for the woman.
Please.
Yes.
The only concern for the petitioners is for the same position, if there are 2 posts, then ultimately it will lead to more clashes and.
That is a different.
That can't be
We cannot foresee all that. We'll see if something happens that way. No.
Again, it is subject to the amendment. We are going to amend the bylaws.
No, now you provide that.
ಅಲ್ಲ, we'll provide.
ಈಗ ಮಾಡಿ
election
election
ಕೊಡ್ತಾ
ಮಾಡಿ ಆಮೇಲೆ ಬೈಲೋ ಆಮೇಲೆ ಮಾಡ್ಲೇಬೇಕು. That was what I have said.
Please, my lord. I am grateful, my lord.
ತಗೊಂಡ್ಬಿಡಿ.
Continue 52.
Lordship, I directed, my lord, the deputy commissioner to be present and call them.
52 ನಾ?
2:30 ಅಲ್ಲಿ.
ಯಾವ್ದದು? Forest Department.
Forest.
Why?
It's a matter where, my lord, the land was granted because, my lord, the petitioner's great granduncle, my lord, participated in the war. Subsequently, my lord,
ಅದೇ ಐಡೆಂಟಿಫಿಕೇಶನ್ ಆಫ್ 4 ತಾನೆ.
2 acres.
ಈಗ ಏನ್ ಪ್ರಾಬ್ಲಮ್ ಆಗಿದೆ?
4 acres ಕೊಟ್ಟಿದ್ರು, ಅದರಲ್ಲಿ 2 ಎಕರೆ ಫಾರೆಸ್ಟ್ ಅಂತ ಹೇಳಿ ಫಾರೆಸ್ಟ್ ಡಿಪಾರ್ಟ್ಮೆಂಟ್ ವಾಂಟೆಡ್ ದೇರ್ ಥಿಂಗ್. ಆಲ್ಸೋ ಪ್ಲೀಸ್ ಟು ಪಾಸ್ ದಿ ಆರ್ಡರ್ಸ್ ಆನ್ 5/25.
1 minute. To be reported not by respondent member, but by the deputy commissioner. Yes, he comply madilva.
ಇಲ್ಲ ಮಾಡಕ್ ಆಗ್ಲಿಲ್ಲ. I'm stating the reason. I've kept
Why?
my officer also.
Your lordship kindly see, my lord, what they're trying to say, impliedly trying to say is, there is a violation in 1969 because the great granduncle had sold it to the nephew. Now, my lord, your lordships are aware, my lord, if the action has to be taken for any violation, it has to be taken in a reasonable time. Now, my lord, instead of
That-
complying it,
That is the only reason?
No, my lord, we have indicated, that is one of the things we have produced to say that in violation of the grant condition where the non-alienation clause was there, a sale was done. My lords, I'm sorry, I could not paginate, my lords. After the sale deed, handwritten sale deed. my lords,
ಆಯ್ತಾ ನಾನ್ ಎಲಿನೇಷನ್ ಏನ್ ಆಕ್ಷನ್ ತಗೊಂಡ್ರಿ?
ಇಲ್ಲ, ಏನು ತಗೊಂಡಿಲ್ಲ. That's the
ಮತ್ತೆ?
reason I'm not even pressing on that. We only wanted to bring it to my lord's notice as to there was a sale in violation. We have not taken any action. It's a fact, my lords, but we have stated that there is no land available, my lords. I have stated in my communication, dated 15/11/24, where the Tahsildar on 15/11/24 itself indicates, my lords. My lords should permit me to read the next page. The last portion, my lords.
ಸರ್ಕಾರವು ಈ ಹಿಂದೆ
Sorry, my lords.
ಸರ್ಕಾರವು ಈ ಹಿಂದೆ ಅಂತಿರದ?
ಅಲ್ಲ, ಘನ ನ್ಯಾಯಾಲಯ ಅಂತಿದೆ.
ದಿನಾಂಕ 4/1/24.
4/1/24 ಸೋನ್ಸೋರವರು ಹೆಸರಿನಲ್ಲಿ 4 ಎಕರೆ ಜಮೀನು ಪೈಕಿ 2 ಎಕರೆ ಜಮೀನು ಅರಣ್ಯ ಇಲಾಖೆ ವ್ಯಾಪ್ತಿಯಲ್ಲಿರುವುದರಿಂದ ಸದರಿಯವರ ಪರ್ಯಾಯವಾಗಿ ಬದಲಿ 2 ಎಕರೆ ಜಮೀನು ನೀಡಿದ ನಂತರ ಅರಣ್ಯ ಇಲಾಖೆ ವ್ಯಾಪ್ತಿಯಲ್ಲಿರುವ ಒತ್ತುವರಿಯನ್ನು ತೆರವುಗೊಳಿಸಲು ಆದೇಶವಾಗಿರುತ್ತದೆ. ಇದೇ ಪ್ರಕರಣವು ದಿನಾಂಕ 6/11/24 ಮಾನ್ಯ ನ್ಯಾಯಾಲಯದ ವಿಚಾರಣೆಗೆ ಬಂದಿದ್ದು ದಿನಾಂಕ 4/1/24 ಆದೇಶದಂತೆ ಕ್ರಮ ವಹಿಸಲು ಆದೇಶವಾಗಿರುತ್ತದೆ. ಈ ಸೋನ್ಸೋರ್ ಅವರು ಪರ್ಯಾಯವಾಗಿ ಬದಲಿ ಲಭ್ಯವಿಲ್ಲದಿರುವುದರಿಂದ ಬಗ್ಗೆ ಉಲ್ಲೇಖ 2ರಲ್ಲಿ ತಹಶೀಲ್ದಾರ್ ಹೊಸಕೋಟೆ ಸಲ್ಲಿಸಿರುತ್ತಾರೆ. ಹೀಗಿರುವಾಗ ಮಾನ್ಯ ಉಚ್ಚ ನ್ಯಾಯಾಲಯ ದಿನಾಂಕದ 4/1/24 ಮಧ್ಯಾಂತ ಆದೇಶ ಹೊರಡಿಸಿರುವ ವಾದಿಯವರಿಗೆ ಪರ್ಯಾಯ ಭೂಮಿ ನೀಡಲು ಸರ್ಕಾರಿ ಲಭ್ಯವಿಲ್ಲದಿರುವುದರಿಂದ ಹಾಗೂ ಇದೇ ಸರ್ವೆ ನಂಬರ್ನಲ್ಲಿ ಅರಣ್ಯ ಇಲಾಖೆಯವರು ಅಧಿಸೂಚನೆ ಆಗಿರುವ 32 ಎಕರೆ ಜಮೀನಿನ ಪೈಕಿ 10 ಎಕರೆ 37 ಗುಂಟೆ ಇತರರ 19 ಜನಕ್ಕೆ ಮಂಜೂರಿಯಾಗಿದ್ದು ಸದರಿ 19 ಜನರಿಗೆ ಮಂಜೂರಿಯಾಗಿರುವ ಜಮೀನನ್ನು ಅರಣ್ಯ ಇಲಾಖೆಯವರು ತೆರವು ಮಾಡಿದ್ದು ಸದರಿ ಕ್ರಮವನ್ನು ಪ್ರಶ್ನಿಸಿ ಮಾನ್ಯ ಉಚ್ಚ ನ್ಯಾಯಾಲಯದಲ್ಲಿ WP ನಂಬರ್ ಸೋನ್ಸೋ ಪ್ರಕರಣವನ್ನು 19 ಜನ ಮಂಜೂರುದಾರರು ದಾಖಲಿಸಿದ್ದು ಸದರಿ ಪ್ರಕರಣ ವಿಚಾರಣೆ ಹಂತದಲ್ಲಿ ಸರ್ಕಾರವು ಇಲ್ಲಿಂದ ಹಲವಾರು ಸರ್ಕಾರಿ ಸರ್ವೆ ನಂಬರ್ ಜಮೀನುಗಳನ್ನು ಅರಣ್ಯ ಎಂದು ಅಧಿಸೂಚಿಸಿದ್ದು ಅರಣ್ಯ ಇಲಾಖೆ ಹೆಸರಿನಲ್ಲಿ ಖಾತೆ ಆಗಿದೆ.
ಅದ್ಯಾವುದು? ವಿಚ್ ಇಸ್ ದಟ್ ರಿಟ್ ಪಿಟಿಷನ್?
ಯಾರೋ ಬೇರೆಯವರು ಹಾಕಿದಂತ ಅವ್ರದ್ದು, that is this.
19% claim.
ಯಾವ ಅದರ್ 19%? ಯಾವ್ದದು? ಅದಕ್ಕೂ ಇದಕ್ಕೆ ಏನ್ ಸಂಬಂಧ?
We are only saying that in so far as the lands were not scheme.
Now, what is the reason projected by you? ಜಾಗ ಇಲ್ಲ ಅಂತ.
Yes, Lord.
ಇವ್ರಿಗೆ ಅಲಾಟ್ ಆಗಿತ್ತಲ್ಲ ಮುಂಚೆನೆ? ಅಲಾಟ್ ಆಗಿತ್ತಾ ಇಲ್ವಾ ಮುಂಚೆನೆ?
4 acres.
Was it allotted or not? Then what happened to that place? ಈಗ ಜಾಗ ಇಲ್ಲ ಅನ್ನಕ್ಕೆ what happened to that 4 acres?
Given. Out of which 2 acres was our land, as in the revenue department given.
All right.
Another 2 acres was the forest department. The forest department has now claimed their land back to their thing. ಇವಾಗ ಇನ್ನು ಆ ಉಳಿಕೆ
ಆಯ್ತು, ಈಗ ಫಾರೆಸ್ಟ್ ಡಿಪಾರ್ಟ್ಮೆಂಟ್ has claimed there is an allotment in somebody's favor for a particular reason. Where is the alternate land?
alternative land ಇಲ್ಲ. That is what the
Alternate land ಇಲ್ಲ ಅಂದ್ರೆ then you will have to part with whatever you have taken back. Are you playing with it?
officer
Then-
wants to make some sufficient notes.
My lord, before my officer, I'll just show my lord the same order, same letter.
No, as simple as this, officer. If you have taken away, first it is allotted, 4 acres are allotted.
Yes.
All right, other 2 acres you claim to forest or whatever. You have allotted it not for free, for some purpose on that day in 1960. ಯಾವತ್ತಾಗಿದ್ದು? In 1960s. Now you can't saying that there are no lands to be given. What happened to that allotment? And he was in possession of the properties from when to when?
Till today also, my lord, we are in possession. We have in fact, my lord, built a farmhouse. We said, my lord, we will leave the farmhouse. Now, since, my lord, in 2015, the forest department came. It is their mistake. Now, your lordship has passed the interim order in January, my lord, 2024. Your lordship kindly see this letter, my lord, which the DC writes. My lord, it is on 15/11/24. Your lordship's order is on 4/1/24. Till 11 months, they keep quiet. Then now, my lord, keeping quiet for 10 months. Then they pass this order.
No,
They are not, my lord, here to protect the interest of
you
the
appear
public.
to be in the habit of keeping quiet. Not for years, for months, but years together you keep quiet. Wake up from slumber, and because it is a forest land, you say forest land can be redeemed at any point in time. Even after 100 years, you want to redeem it now. There should be some semblance of fairness in whatever you do. Here, what is granted is 4 acres of land. For what? Participating in the war, right? Howda? So that vanishes now. The reason for grant vanishes? What fairness is this? After 50, 60 years, you come and say, no, you have taken away forest land, you've taken away that land, you give me back the land. 50 ವರ್ಷ ಏನ್ ಮಾಡ್ತಾ ಇದ್ರಿ? ಯಾರು ಕೊಟ್ಟಿದ್ grant? It's not a private grant. It's a government grant. Then what is this government against government?
In fact,
Just
my
because
lord,
you've woken up now, you take away everybody's land like this, saying that there was some problem in 1969, there was some problem in 1965.
I mean,
Is it not unfair on the face of it?
in fact, my lord, behind my land, my lord, there is a government land.
No,
The
if,
photograph. He says, my
no,
lord, there
if-
is no land.
if the persons who you are now wanting to pass this order, step into the shoes of the person who's here and see if it is, if you are at the receiving end like this. Is it correct? There should be some fairness, officer. ನೀವು ಮುಂಚೆನೆ ಆಯ್ತು ಅವಾಗ 1965 ಅಲ್ಲಿ ತೊಂದರೆ ಆಗಿದೆ, you have encroached government land or we have granted you forest land, there was some fairness. ಆವಾಗಲೇ if you have taken it, he would have settled somewhere else. ಈಗ ಎಲ್ಲ ವಾಪಸ್ ತಗೊಂಡ್ಬಿಟ್ಟು ಲ್ಯಾಂಡ್ ಕೊಡಕ್ಕೆ ಇಲ್ಲ ಅಂದ್ರೆ he's still in possession of the land. What happens to the rights that has got crystallized over a period of time? 50, 60 years ಆದ್ಮೇಲೆ you knock at the doors of someone, go out ಅಂದ್ರೆ ಅದು ನೀವೇ ಕೊಟ್ಟಿರೋದು. ಅವರು unauthorized occupants ಆದ್ರೆ ಡೆಫಿನೆಟ್ಲಿ I would not have shown any indulgence. They are not unauthorized occupants. They are authorized by the government themselves. How is it possible?
Now, my lord, DC says there is no land. Behind my land, my lord, they have put a board saying that it is a revenue department's land. The photographs, my lord, which I have taken.
Different survey.
My lord, we are.
That's all right. See, you should give alternate land or permit him to stay. Alternate land illa andre I will permit him to stay here by judicial order. I will record all the folly of the forest department and permit him to stay.
So the land where it was in under unauthorized occupation, which we have now vacated and taken into our possession.
ಯಾವುದು?
This land which is
ಅದಾಯ್ತು.
behind us.
That's all right. I'm not on that. His land I'm saying. That is not an unauthorized occupation.
ಇಲ್ಲ.
It was a granted land, granted by the government.
Code is done in 1967.
Now, my lords, there are.
ಅಲ್ಲ 1967, 33-25.
67 code.
58 ವರ್ಷ ಆದ್ಮೇಲೆ you want to evict someone.
He's saying that.
He may be anybody, sir. Then a poor man, now a rich man. I'm not on that. It is the state's action. There should be fairness in action. Yes, officer.
My officer says is it's the secretary of the revenue department who has directed him to make the submission.
No, that's all right. I'm not blaming anyone here. The state itself, whether secretary has directed, who has directed, minister has directed, it's not the issue. No, today it may be Deputy Commissioner.
And since you say that higher officer has directed him to.
No, of course, that is there. That may be a strand of defense.
My lord, for them, my lord, this court's order is not higher. For them, my lord, principal secretary's of order is higher. That is what he's trying to say. This is, my lord, total, my lord, contempt. Knowing very well that this court has ordered them. He says principal secretary has said, therefore I am not doing.
No, we will answer all that.
I think that because the law to indicate that there is a difficulty, because there is no land available in that circular number is what we are indicating.
Alternate land? Not in Chikballapura.
This is in.
ಅಲ್ಲ alternate land ಚಿಕ್ಕಬಳ್ಳಾಪುರದಲ್ಲಿ ಹೇಳ್ಬೇಡಿ ಆಮೇಲೆ ಅಂತ.
ಇಲ್ಲ, ಇಟ್ ಇಸ್ ವೆರಿ ಡಿಫಿಕಲ್ಟ್. ಸ್ಪೀಕರ್ ಲ್ಯಾಂಡ್ ನಮ್ದು ಯಾವುದೂ ಇಲ್ಲ, ಗೋಮಾಳ ಕೊಡಬಾರ್ದು ಅಂತ ಆದೇಶನೇ ಆಗಿದೆ.
No, you want to take some time, you take some time. Otherwise, what order is to be passed, I will pass. Straight away pass, telling the government it's folly.
ಏನು ಡೈರೆಕ್ಷನ್ ಕೊಡ್ತಾರೆ ಸರ್ಕಾರಕ್ಕೆ ಒಂದು ಸೆಕೆಂಡ್ ವಿಲ್ ಸಬ್ಮಿಟೆಡ್. ಟೈಮ್
You want me to pass over? I'll pass over.
Taken up next week, Manoj, so ಒಂದು ವಾರ ಸಾಕಾ? One week, so that we'll come back.
The next Wednesday?
Please.
Yes, list the matter on Wednesday, the next, that is, pick a madam.
Thank you. Grateful.
Next week, 3rd April, madam.
Please.
3rd April, yes.
Same say 2:30, man.
2:30, yes. Continue the list.
Continue.
Serial number 51, my lord.
ಏನು?
It was for a dictation of the order, my lord.
Huh?
Dictation of the order, my lord.
ಯಾವುದು sir?
51.
Defreezing of the account.
ಆಯ್ತು, ಬಂದಿಲ್ಲ ತಾನೇ ಅಲ್ಲಿ ಇನ್ನು
52 ಬಂದಿದೆ. 51 ಇದೆ.
51 ಏನಾಯ್ತು? ವೇಟ್ ಎಸ್. Fifty?
52, my lordship, that is
Pawan
disconnection
Kumar.
of powers. Lordship, there is confirmation and demolition order is passed, my lordship, in this matter.
Confirmation and?
Demolition order is
That's by the chief commissioner?
by the zonal commissioner. Chief
Hello, zonal commissioner. Is it appealed before the chief commissioner?
No, my lordship, as if no appeals.
Just check and get back. Yes, list the matter on 1st April in the fresh matters list. Both 52 and 53.
Obliged, please.
54.
ಅಜಯ್ ಈ ಕಡೆ ಕೊಡಿ ಮೇಡಮ್. ಇಲ್ವಾ? No representation. We have the petitioner list after 2 weeks. Yes, Rajendra.
For the second respondent.
DRT ಹೋಗಿದಿರಲ್ವಾ? ಏನಾಯ್ತು DRT?
ERTಲಿ is got dismissed. Page number annexure A, page number 14. The only one ground which I have taken is an agriculture land under section.
That is a matter of evidence.
31I is hit by.
That's a matter of evidence.
Yes, my lord.
Agricultural land ಅಂತ ಹೇಳಿದ ತಕ್ಷಣ agricultural land ಆಗಲ್ಲ. It is matter of evidence.
Yes, my lord. Am I permitted, my lord? Bank has produced the valuation report, which is in page number annexure D, page number 32, 33, 34. These are the documents bank has submitted to the.
Floriculture ಇದು?
ಇಲ್ಲ, ವಾಟರ್ ಪ್ಯೂರಿಫೈ ಪ್ಲಾಂಟ್ ಮಾಡಕ್ಕೆ ತಗೊಂಡಿದ್ರು.
ಅದು ಅಗ್ರಿಕಲ್ಚರ್
ಅಲ್ಲ, ಅದರಲ್ಲಿ ಒಂದು ಪೋರ್ಷನ್ ಮಾತ್ರ, ಮಿಕ್ಕಿದೆಲ್ಲ ಯಾವ್ದು ಮಲ್ಬರಿ ಬೇರೆ ಬೇರೆ ಪ್ಲಾಂಟೇಶನ್ ಇದೆ. ಬಟ್ ಫೋಟೋಗ್ರಾಫ್ಸ್ ಇದೆ ಪೇಜ್ ನಂಬರ್ 41.
ಎಸ್ ವಿಘ್ನೇಶ್,
ಪೇಜ್ ನಂಬರ್ 41.
ಅಗ್ರಿಕಲ್ಚರ್ ಲ್ಯಾಂಡ್
There is a conversion plan.
ಕನ್ವರ್ಷನ್ ಯಾವಾಗ ಎಲ್ಲಿದೆ? ಆರ್ಡರ್ ಆಫ್ ಕನ್ವರ್ಷನ್ ಪೇಜ್.
Kindly come to
My objection.
page number 23, objection filed by my lord.
Second
Arjun has filed objections.
Page number 23. Page number 24, my lord. it
1
says
minute, 1 minute.
23 ne shuru agate.
20?
23, annexure R4. 24, my lord, first para. ಸದರಿ ಭೂ ಪರಿವರ್ತಿತ ಜಮೀನನ್ನು ಕೈಗಾರಿಕಾ ಉದ್ದೇಶಕ್ಕಾಗಿ ಮಾತ್ರ ಉಪಯೋಗಿಸಿಕೊಳ್ಳತಕ್ಕದ್ದು. ಈ ಜಮೀನನ್ನು
ಎಲ್ಲಿ ಓದ್ತಾ ಇದ್ದೀರಾ?
24 ಫಸ್ಟ್ ಪ್ಯಾರಾಮಿಲರ್.
ಸದರಿ ಭೂ ಪರಿವರ್ತಿತ ಜಮೀನನ್ನು ಪರಿವರ್ತನೆ ಆಗಿದ್ದೆಲ್ಲಿದೆ?
In fact, next documents also, my lord, before the DRT, my lord, they admitted the subject property, my lord, is converted.
Show me that.
No,
1 minute, sir.
Yes, my lord.
1 minute.
That I'll just.
Paragraph.
Page 50, my lord. Petition.
50.
50. Para 3.
Para 3. The first applicant partner who is
Absolute ownership was in agricultural land.
owner of the scheduled property, which is segregated status at the time of purchasing the era, though the competent authority converted portion of the land for industrial purpose on account of lapses committed by the official who are getting lands converted into non-agricultural purpose by oversight. My lord, the conversion plan, and my lord, there are other two, my lord, endorsement, that is at my lord page number 26 and my lord page number 27. ಅದರಲ್ಲೂ ಹೇಳ್ತಾರೆ ಪೇಜ್ ನಂಬರ್ 26 ಆಫ್ ಸ್ಟೇಟ್ಮೆಂಟ್ ಆಫ್ ಅಬ್ಜೆಕ್ಷನ್ ಅಲ್ಲಿ ಪ್ಯಾರಾ 2 ಅರ್ಜಿದಾರರ ಕೋರಿ ಜಮೀನು ಸೋ ಅಂಡ್ ಸೋ ವಿಸ್ತೀರ್ಣ ಸೋ ಅಂಡ್ ಸೋ ಕೃಷಿಯೇತರ ಜಮೀನಾಗಿದ್ದು ಪೇಜ್ ನಂಬರ್ 26. ಲೆಟ್ ಕೈಂಡ್ಲಿ ಕಮ್ ಟು ಪೇಜ್ ನಂಬರ್ 27 ಆಲ್ಸೋ. ದ ಸೆಕೆಂಡ್ ಪ್ಯಾರಾ ಸಮ್ ಎಂಡೋರ್ಸ್ಮೆಂಟ್ ಫ್ರಮ್ ದಿ ಗವರ್ನಮೆಂಟ್ ಉಲ್ಲೇಖ ಮೇರೆಗೆ ರಾಜೇಶ್ ಸೋ ಅಂಡ್ ಸೋ ಪ್ಯಾರಾ 3 ಸೋ ಅಂಡ್ ಸೋ ಸಮೀನ್ ಭೂ ಹಿಡುವಳಿ ಜಮೀನು ಹಾಲಿ ಕೃಷಿಯೇತರ ಜಮೀನಾಗಿರೋದ್ರಿಂದ ಕರ್ನಾಟಕ ಸೋ ಅಂಡ್ ಸೋ. My lord, based on this document, they approached me in the year of 2017.
What's the amount in due?
4.7 crores.
Sale is over, sale certificate is issued.
Certificate issued for 4.06 crores. Reserve price, my lord, was 2.65. There was competitive bidding at 4.03.
DRDT.
No, Your Lordship, one submission, ma'am.
Yes,
Page
sir.
number 26, 27.
Yes, sir.
Kindly see the alteration. Krushi Etara.
Hmm.
Etara alter ಮಾಡಿದ್ದಾರೆ.
ಎಲ್ಲಿದೆ ಪೇಜ್ 26 ಎಲ್ಲಿದೆ?
ಅವ್ರ objection ಅಲ್ಲಿ ಈಗ just now
ಯಾರು ಆಲ್ಟರ್ ಮಾಡಿದ್ದಾರೆ?
connection R5.
ಹಾ.
Respondent auction purchase has submitted these documents, whereas the bank has failed to these documents before DRT. Even in original application also, the bank has not filed these documents. These documents are submitted by the auction purchaser.
ಈ ತಹಸೀಲ್ದಾರ್ದಲ್ವಾ ಇದು?
ಇಲ್ಲ ಇಲ್ಲಿಗೆ ಕೃಷಿ ಏ ತರ ಕೃಷಿ ಬಿಟ್ಟು ಟೈಪಿಂಗ್ ಆಗಿದೆ, ಏ ತರ ಆಡ್ ಮಾಡಿದ್ದಾರೆ ಕೃಷಿ ಜಮೀನು. ದೆನ್ ಪೇಜ್ ನಂಬರ್ 27
ಇದೇನೋ ಆಡ್ ಮಾಡಿದ್ದಾರೆ.
ಏ ತರ
ಒಂದ್ ನಿಮಿಷ, ಇದು ಆಡ್ ಮಾಡಿದ್ದಾರೆ, ಬಟ್ ಪೇಜ್ 22 23 ಏನಂತೀರಾ?
23 ಮೇಲ್ಗಡೆ ಇದೆಯಲ್ಲ ರೆಫರೆನ್ಸ್ ನಂಬರ್
ಏನಿದೆ?
that does not pertains to this land. Then I may permitted to take your lordship my submission, my lord, page number 114. Page number 114 and 115, endorsement given by the DC, Deputy Commissioner. Kindly see, my lord.
Yes, sir.
114 Himbara, page number 115. It's in English. Wherein the Deputy Commissioner confirms that this land has not been converted to industrial purpose.
Where is that? Industrial ಅಲ್ಲ sir.
Allah,
Non-agricultural purpose ಅಷ್ಟೇ.
Endorsement 115.
What agricultural activity are you doing there?
Yes, my lord. Kindly see the photograph submitted by the bank, page number 41, page number 50, 58. Kindly see the RTC. Kindly, lordship, kindly see the page number 40.
DRT has considered all these submissions.
ಇಲ್ಲ
ಹೇಳಿ.
ಅಲ್ಲಿ annexure daily valuation report bank submit ಮಾಡಿದಾರಲ್ಲ, there is no whisper about the conversion of land. He himself has stated this is agricultural land. Valuation report made by the bank. Agriculture status ಅಂತಾನೆ ಇದೆ. Nowhere about the conversion land ಇಲ್ಲ. Then I may permit to release lordship what DRT has observed in their order. Page number 22. Page number 22, my lord.
ಹೇಳಿ, ಅಲ್ಲೇ ಇದ್ದೀನಿ.
Even otherwise, a mere narration of the property by the valuer as fit to be agriculture is a valuation made by the bank. In the valuation report, it is not sufficient to hold that the nature of the property is agricultural one. When there is no whisper about the conversion of land or DC order, when he narrated valuer is an agricultural status, agricultural land, then this is observation. The applicant had also produced the non-conversion of land certificate in respect of the land, which according to the applicant is issued by the competent authority. It is settled that the description of property in the revenue records or attending documents as agriculture or commercial land is totally irrelevant as to decide as to whether the measures are rightly taken under section 31 of the act. Then what 31 of the act says is agricultural land. They should, I may permit to read section 31.
Yes.
31.
ಏನು ಓದ್ಬೇಕಾಗಿಲ್ಲ ಬಿಡಿ, ಗೊತ್ತದು.
Yes, my lord. When such being the case, creation of security, what is the prohibited under section 31(1) of the act is the measures taken against the security interest created on agricultural property. Hence, in order to substantiate the contention as to the measures are hit by section 31 of the act, the applicant should prove with tangible evidence that at the time of creation of security, the property was put for agricultural purpose. And these are the photographs submitted by their own valuer, establishes the other portion of the land is being cultivated. And RTC.
Yes.
All RTC records and the confirmation given by Gram Panchayat 117, page number 116 and 117. It is in Kannada. And confirmation certificate are grown that of mulberry for
ಈಗ
cultivation.
ಸೇಲ್ ಯಾವತ್ತಾಗಿದ್ದು?
Sale is held on. ಅಲ್ಲಿದೆ our objection.
27th November.
27/11/24.
Yes.
Sale certificate issued on?
On 25th February 2025.
21 to 2025. 11th March. DRT ಹೋಗಿದ್ದು?
DRT. Before auction.
What did you challenge? 14 order?
ಇಲ್ಲ ಇಲ್ಲ.
ಮತ್ತೆ?
ಇದು
Sale notice.
Auction.
Thank you.
Auction. Earlier, when I challenged before the DRT with regard to section 14 order, which was got dismissed.
That's all right.
That is the.
Now auction challenge ಮಾಡಿದಿರಲ್ವಾ?
Yes, ಮಾಡಿ.
All right, ತೊಗೊಳ್ಳಿ ಮಾಡಿ. The petitioner, the borrower, is at the doors of this court calling in question the order passed by the Debt Recovery Tribunal 1 in SA 265 of 2024 dated 24 to 2025, by which the challenge to the auction notification of the bank by the petitioner comes to be turned down. Heard so and so. The petitioner is, facts in brief, germane are as follows. The petitioner avails a loan from Canara Bank of the mortgaged scheduled properties. The averment in the petition is that they are all agricultural lands. The account slips into becoming an NPA as the loan became sticky
On 29/10/2018.
on 29/10/2018 on account of default of the petitioner in repayment of the amount. On 3/11/2018, the bank issues a demand notice invoking subsection 2 of section 13 of the SURFACE Act. Thus begins the proceedings under the SURFACE Act by the respondent bank against the petitioner. The proceedings were taken forward and the learned magistrate under section 14 permits taking of physical possession of the property on 18/9/2019. This comes to be challenged by the petitioners before the DRT in SA 238 of 2020, which comes to be dismissed on 26/10/2020. The bank then issues a auction notification on 24/10/2024, seeking to sell the property of the petitioner mortgaged with the bank on 27/11/2024. The petitioners then approach the DRT in SA 265 of 2024 for seeking setting aside of the auction notification. The bank then bank proceeds with the sale, issues a sale certificate also in favor of the successful auction purchaser on 21/2/2025 during the pendency of the proceedings before the Debt Recovery Tribunal.
After, my lord, sir.
After the order.
After the.
What date is the order? 24/2/25.
Order is 24/2/2025.
Then
They have issued the sales on 25/2.
I'm sorry.
25. So and so. ಏನಿದೆ madam? Issued sale certificate on 25/2/2025, the day after the DRT rejected the rejected SA 265 of 2024. The subject petition is preferred on 11th March 2025, long after the issuance of the sale certificate by the respondent bank in favor of the successful auction purchaser. The learned counsel appearing for the petitioner projects a solitary circumstance. The circumstance is statutory. It is violation of section 31I. The learned counsel for the petitioner submits that the land that was mortgaged was an agricultural land and would not come within the ambit of the SURFACE Act for the bank to bring the property to sale. He would submit that the DRT did not consider this crucial aspect that it was an agricultural land, and therefore the petition in the form that it is presented is entertainable at the hands of this court. Per contra, the learned counsel representing the respondent bank, Shri Vignesh Shetty, takes this court through the objections filed by the successful auction purchaser to demonstrate prima facie that the land was already converted in the year 2018 itself.
13.
2013 itself. And the averment in the SA 265 of 2024 by the petitioners themselves was that the land was converted. There is a dispute with regard to conversion. There is a dispute with regard to conversion is what is projected by the respondents. Nonetheless, the learned counsel for the respondent bank, Vignesh Shetty, and Arjun Rao, the counsel for the successful auction purchaser, would in unison contend that the writ petition is not entertainable, as the remedy available to the petitioner is filing an appeal under Section 18 of the SARFAESI Act 2002. As the redemption, the right to redemption is already over the date on which the hammer has fallen on the sale certificate. Therefore, they would seek dismissal of the petition. I have given my anxious consideration to the submissions made by the respective learned counsel and have perused the material on record. The aforenarrated facts are not in dispute. The dates and the link in the chain of events are all a matter of record. It would suffice if the narration would commence from the date of issuance of the sale notice by the petitioner, by the respondent bank against the petitioner. The respondent bank against the petitioner. The sale notice is issued on 24/10/2024, seeking to auction the property on 27/11/2024. The petitioner approaches the DRT in SA 265 of 2024, challenging the said notice. The DRT, in terms of its order, rejects the petition. While so rejecting, considers this very submission of the petitioner by framing the following issue. MPK Madam, page 22 to 24. Considering the fact that there is no evidence produced by the petitioner to show that agricultural activities continue to take place despite the conversion of the land, the DRT rejected the petition. It is not a rejection either for want of principles of natural justice or rejection ignoring consideration of any statutory aberration. The rejection is on merits. If the rejection is on merits, rejection is on merits, and the submissions addressed across the bar are shrouded with seriously disputed questions of fact with regard to whether the property is agriculture or otherwise, this court, in exercise of its jurisdiction under Article 226 of the Constitution of India, would not lend its hands to the borrower to decipher the evidence as to whether it is agricultural land, non-agricultural land, agricultural activities taking place there or otherwise. Even otherwise, the apex court in the case of Bafna, 2024 2 SCC page 1, has held once the sale certificate is issued, the right to redeem the said property by the borrower is lost unless
issue of sale notice,
13, if sale notice itself, correct. Issue of sale notice, once the sale notice is issued, to redeem the property by the borrower is lost. The apex court has held as follows, para 97 to 101. The apex court in a later judgment in the case of so-and-so 2024 6 SCC page 579, quote paragraph 22 to 30, has held as follows. Both these judgments in unison would observe that once the sale notice is issued or the hammer on the sale certificate would fall, the right to redeem the property by the borrower is lost unless there is statutory aberration clearly pointed at with adequate evidence. The evidence in the case at hand that the petitioner is wanting to project is hazy and is on a slippery slope, as no adequate material is produced which is palpable and demonstrable that the land still remains agriculture. Nonetheless, the apex court in the case of NR Bhaskar versus so-and-so has held that the issue whether the agricultural land is the subject matter of mortgage or subject matter of SARFAESI proceedings or otherwise is always a matter of evidence, and writ And the writ petition under Article 226 of the Constitution would not be maintainable, would not be entertainable in those circumstances. Therefore, leaving open the remedy of the petitioner to leaving the petitioner open to the remedy of filing an appeal before the Debt Recovery Appellate Tribunal, the petition stands rejected. The period spent in this court after March 11, 2025 shall not be taken as period spent, shall not be taken for the purpose of computation of limitation by the DRAT.
Highly obeyed.
So great.
Ordered accordingly.
Submission, RTC ಎಲ್ಲ ಹಾಕಿದ್ವಿ.
ಎಲ್ಲ ಅಲ್ಲಿ.
With your lordship's kind leave, my lord, may I make one submission, my lord?
You are there in this?
No, my lord, I am there. I just want to bring it to your lordship's notice, the order passed by the Supreme Court in AAB, which is
ಏನಾಯ್ತು?
10 minutes back. Supreme Court has held that the order dated 28/1/2023 would apply mutatis mutandis to all the district.
I have already made it applicable.
Please, my lord. The same order, my lord.
I have already dictated, disposed.
Please, my lord. I thought it's my, as an officer of the court, my
No,
duty to.
correct. I'm not pointing at any mistake
No,
of
my lord.
yours.
Not mistake, because it got
No,
over.
I am only saying I have not done anything contrary to what the apex court has
No,
said.
my lord, your
Yes.
lordships, I have followed what the apex court has just now dictated. That, but the post of treasurer will be reserved is what the Supreme Court has said.
No, that is in the in every association.
In every association, my lord. In every, that is one correction your lordships may have to make, my lord.
Matter and that it was facing stiff resistance. Then their lordship vessel said, why would it face stiff resistance? And said now that it's being followed everywhere. And in fact, in some other associations, women stood even for president.
And I have also given a general direction. Henceforth, all associations should follow it.
Please. But also there's a direction to the.
I have said, madam, bastion of the male should be broken. Yes.
Be welcome. And your lordship, they have also stated that the registrar of the Honorable High Court would be given a copy, which would be circulated to all the other districts, so that the very same treasurer post and the 30% would be maintained by all of them.
Then should I post it tomorrow again then? Or you get the, no, ask RS Ravi sir to come. Senior Counsel RS Ravi, tell him the Supreme Court's order and ask him to come. We'll tell him and then modify, that's all. I have already disposed it. Yes.
We may place the order.
I have directed that every association should follow this.
Please.
Exactly that, I guess the only modification. would
Post
be-
of treasurer. Fine.
Your lordship, one submission, madam.
Yes, sir.
Your lordship order, you should not have the keeping open all the contents. You should not have
all,
lyrics.
yes.
Because
All,
they may,
I'll-
it may give some advice. Please, my lord.
ಅದರಲ್ಲಿ ಅವ್ರದ್ರಲ್ಲಿ all other contentions except the one considered in the case of the order, in the course of the order shall remain open. ಯಾವ್ದು ಹೇಳಿ ಮುಂಚೆ ಕೊಟ್ಟಾನ ಡೀಟೇಲ್ ಆರ್ಡರ್ ಈಗ ಕೊಟ್ಟಾನ 50? 55 ಅಲ್ಲಿ ಲಾಸ್ಟ್ ಅಲ್ಲಿ.
ಇಲ್ಲ ತಮ್ಮ ಆರ್ಡರ್ ಕಟ್ ಅಂಡ್ ಪೇಸ್ಟ್ ಆರ್ಡರ್ ಮಾಡೋ ನಮ್ಗೇನು ಸಿಗೋದಿಲ್ಲ ಇವೆಲ್ಲ. ಅದಕ್ಕೆ ಮೈ ಹಂಬಲ್ ಸಬ್ಮಿಷನ್.
ಆಲ್ ರೈಟ್, ಗೊತ್ತಾಯ್ತಲ್ಲ.
Oblige.
56.
Yeah, my lord. Already stayed in it. Another expedition, WP number 750.
Take this petition along with so on. Stay ಆಗಿದೆಯಾ?
As far as the stay is concerned, please, my lord, by virtue of the dishonour court's coordinates bench direction, please, my lord, the authorities were concerned, directed to proceed with the bidding process is concerned. My lord, may I produce copy of the judgment, please, my lord?
ನಿಮ್ಗೆ ಗೊತ್ತಿಲ್ವಾ?
ಗೊತ್ತಿಲ್ಲ. My stay order is subsequent to this order.
Subsequent, but my lord, may I read the relevant portion, please, my lord, from para 2.
Dispose ಮಾಡಿದ್ದಾರೆ?
Dispose ಮಾಡಿದ್ದಾರೆ. My lord, here their grievance would be, please, my lord, that the tender process. is
Identical
not-
grievance?
Please, my lord.
Identical grievance?
Not identical, please, my lord, here there was.
ವೆಂಕಟರಾಮ್
Condition.
ನೋಡಿ ಇದನ್ನ ನಾಳೆ ಬೆಳಗ್ಗೆ ತಗೊಂತೀನಿ.
ನಾಳೆ.
I'll file my statement of objections also, please, my lord, that is.
ಸರಿ ಮಾಡಿ.
Why? Because work order has been issued. Now,
being issued.
work order is issued, please, my lord, for the month of March, please, my lord, I've already supplied the, my lord, the required food materials.
ಅಲ್ಲ ವರ್ಕ್ ಆರ್ಡರ್ ಇಶ್ಯೂ ಆದ್ಮೇಲೆ ಮತ್ತೆ ಪೆಟಿಷನ್ ಹೆಂಗ್ ಮೇಂಟೈನಬಲ್?
The tender, my lord,
The work order has been
is a
stayed.
stranger.
ಸ್ಟೇಡಾ?
Stayed by your lordships in writ petition number 7505. 7505.
ಇದರಲ್ಲಿ ನೀವು ಸಪ್ಲೈ ಮಾಡ್ತಾ ಇದ್ದೀರಾ?
Supply ಮಾಡ್ತಾ
ಮಾಡಿ.
ಇದ್ದೀನಿ ನಾನು.
No, after the.
Take this petition along with so and so.
7505.
The learned counsel for the petitioner submits that the tender process has been stayed, subject tender process has been stayed in writ petition
7505
of
2025.
7505 of 2025. Counsel for the respondent who is now supplying food grains,
Yes, please.
food grains,
For the
submits
tribal
that
family.
he has been, work order has been issued in his favor and he is supplying. In the light of the said submission, there can be no interim order of stay of supply of food grains.
Work order stay agide.
ಗೊತ್ತಿಲ್ಲ. In the light of the said submission, the work order being issued to the, ಇವರೇ respondent ಅದರಲ್ಲಿ.
ಅವರೇ respondent.
I have been
That work-
supplying, I'll produce. No, I'm not.
Interim
my lord,
order,
I'm not-
interim order work order stay agide.
ಯಾರ್ದು
But I
interim order?
Still, my lord, I am producing, I can produce the photographs, please, my lord. Work order for the supply for the month of March has been
ಎಂಪಿಕೆ
issued.
ಮೇಡಮ್ ಒಂದ್ ನಿಮಿಷ ಬೇಡ ತಳಿ.
Month of March, please, my lord.
I'll wait. List day after tomorrow in the fresh matters list.
Along with 7505.
Along with, tag this petition along with
7505.
750525.
I request a copies, my lord.
Copy ಕೊಡಿ. Yes. Next.
This is a case, my lords, where
Complaint.
complainant has been made as a party and everything. my lord. An inquiry against the builder, my lords, who's not a part of the society, has been initiated, has no role to play in the society activities. Number one. Number two, my lords, the
One. Yes, AGA, 2 emergent notice, returnable by the 21st of April. There shall be an interim order of stay as prayed for till the next date of hearing. ಕೇಳಿಲ್ವಾ? Stay ಕೇಳಿಲ್ಲ.
lords dictating, so I don't know what to disturb.
This is the matter where my lord is seeking for regularization of the loan, my lord, and
KV ಲೋಕೇಶ್
copy so ಮಾಡಿದೆ ಮೊನ್ನೆ open
ಮಾಡಿದ್ದೀರಾ?
ಮೊನ್ನೆನೆ ಮಾಡಿದೆ.
ಮೊನ್ನೆನೆ ಮಾಡಿದ್ದೀರಾ?
1,05,00,000 total outstanding ಇತ್ತು sir. DRT director.
ಆಯ್ತು ಬರ್ಲಿ correct. List on 1st April in the fresh matters list, interim order subsisting will continue to the next date of hearing. ಬೇಡವಾ?
31st ಒಳಗಡೆ regularize ಆಗ್ತಿತ್ತು sir.
ಏನ್ ಬರಲ್ಲ ಏನ್ ಮಾಡೋದು? ಎಸ್ ಇಂಟರ್ಮ್ ಆರ್ಡರ್ ಇದೆಯಲ್ಲ ಬಿಡಿ.
Then
ನೋಟಿಸ್ ಆಗಿಲ್ಲ. notice ಆಗಿಲ್ವಾ?
ಕಾಪಿ ಕೊಟ್ಟಿದೆ sir.
ಹೌದು. Counsel KV Lokesh is directed to accept notice for the respondent. Registry to print the name of KV Lokesh as appearing for the respondent. Petitioner to serve set of papers if not already served. List the matter on Friday in the fresh matters list.
So ಮಾಡಿದ ಕಾಪಿ ಇದೆ sir.
ಆಯ್ತು 28ಕ್ಕೆ ಹಾಕಿದ್ದೀನಿ, ಕ್ಲೋಸ್ ಆದ್ರೆ ಆಗ್ಲಿ ಬಿಡಿ. Next.
59.
Viral,
Premature, my lords,
premature release.
20 years. my lords.
Fresh matter, but I.
20 years, my lords, he is already undergone. 3, there are 5 accused, 2 has been died.
अब क्या parole या release?
Premature release. Interim prayer with parole, my lords.
No, I've sought instructions, ಅದು ಬಂದಿದೆ.
Lords, ಇದ್ರಲ್ಲಿ
The board has recommended, it's pending before the committee.
So, well, till the committee decides, we'll
committee
grant him
provides
parole. All right. The petitioner is before this court seeking the following prayer. Heard so and so. Facts in brief germane are as follows. The petitioner is a convict who is convicted for offences punishable under ಏನಪ್ಪಾ?
302.
On 302 of the IPC. As on today, the petitioner has spent more than 20 years in prison owing to the conduct of the,
without remission.
without remission. Owing to the conduct of the petitioner in the prison, the committee of persons who consider the applications of those convicts for premature release is said to have recommended the case of the petitioner for premature release.
No, the board has recommended.
board, advisory board.
Committee ಬದಲು board ಅಂತ ಹಾಕಿ. Advisory board. The recommendation of the advisory board is now placed before the state for its consideration.
No, it's before the life convict committee.
ಅದು state ತಾನೆ.
ಹೌದು.
It is before the state hyphen the life convict, the committee to consider the applications of life convicts for premature release. In the light of the said recommendation, the petitioner becomes entitled to grant of parole for a period of 90 days. Or for a period of 90 days. In the event the committee would not decide the application by then, the petitioner would become entitled to extended parole thereon. In that light, I deem it appropriate to pass the following order. The petitioner shall be released on parole to become operational from day after tomorrow. day after tomorrow morning.
Your lordship, last year when it was recommended, it was rejected, stating that he had two pending cases.
No pending cases.
So
That's
now
all right,
we
yes.
will find out and then
So and so,
the
in the light,
coordinate
in the, the writ petition is allowed. The petitioner is directed to be released on grant of parole for a period of 90 days to become operational from day after tomorrow. Date hakpudi, madam, day after tomorrow. Day after tomorrow, the petitioner is reserved liberty to seek extension of the subject parole in the event the committee would not decide on the recommendation for premature release of the petitioner.
period, time may be fixed.
ಏನ್ ಟೈಮ್
For recommendation.
ಅದು ಕನ್ಸಿಡರ್ ಮಾಡಕ್
Consider madam.
ಇಲ್ದ ನಿಮ್ ಪರವಾಲೆ ಇರ್ತಿರಲ್ಲ ಬಿಡಿ, ಮಾಡ್ಲಿ ಅವರು. ಎಸ್,
Fine.
ಈಗ ಸದ್ಯಕ್ಕೆ 90 days ತಗೊಳ್ಳಿ.
Yes. The observation may be made. Other accused has been released. Madam. They have been recommended.
no, other here
Let's-
because he had two
Where-
cases.
Sirajuddin, you are in parole. If your application is not considered, you move for extension, I'll grant extension.
Of like.
Yes. ಕೈಗೆ ಏನಾಯ್ತು? ಫ್ರಾಕ್ಚರ್. ನೀವು ಪರೋಲ್ ಕೇಸ್ ಮಾಡಿ ಫ್ರಾಕ್ಚರ್ ಮಾಡ್ಕೊಂಡ್ರೆ. ಆಲ್ ರೈಟ್, ಎಸ್.
13-4 notice.
84
lakhs due.
ಯಾವುದು? Serial number?
Page number 60, my lord.
60, yes, Vignesh.
Page number 13, my lord, I said before this final court, my lord, 13-4 notice.
13-4, ಎಷ್ಟಿದೆ?
87,30,350.
ಒಂದು 10%, 3 weeks.
Month end, my lord, year end, my lord.
Year end. Year end ಅಲ್ಲಿ ಏನು ಸಿಗಲ್ಲ. 10-10-3-3.
10 lakhs within weeks, my lord. 31st of March, let them please. 31st of within 10 lakhs.
ಒಂದ್ ವಾರದಲ್ಲಿ ಏನ್ ಮಾಡ್ತಾರೆ? ಕಟ್ತೀರಾ ಮಾರ್ಚ್ 31st ಒಳಗೆ?
ಅಲ್ಲ 10 lakhs within week ಕಟ್ತೀವಿ. ಅದಾದ್ಮೇಲೆ 4 weeks ಕೊಟ್ರೆ 30 lakhs ಕಟ್ತೀವಿ.
ಆಯ್ತು, ರೆಕಾರ್ಡ್ ಮಾಡ್ತೀನಿ. The petitioner is before this court calling in question a notice issued under subsection 4 of section 13 of the Surface Act 2002. The petitioner is before this court calling in question a notice issued under subsection 4 of section 13 of the Surface Act 2002. The learned counsel Vignesh Shetty submits that the due as on today is 87 lakhs. Ashtana? 87 lakhs.
87,30,350.
30,000 and odd. The learned counsel for the petitioner submits that within 1 week, 10 lakhs would be paid, and within 4 weeks thereafter, 30 lakhs, 30 lakhs would be paid. Ba, ಏನು ಇಷ್ಟೊಂದು?
Balance.
ನೀವೇನು ಕೇಳಲೇಬೇಕಾಗಿಲ್ಲ.
Balance 6 months.
ಗೊತ್ತಾಯ್ತು. In 4 weeks, 30 lakhs would be paid. There, in the light of the said submission, I deem it appropriate to stay all further proceedings with the subject to the condition that the petitioner would pay 10 lakhs within 31st of March 2025, and 4 weeks within
Another 4 weeks.
another 4 weeks from 1st April 2025 for payment of 30 lakhs. In the event the petitioner would deviate even in the first instance, the petition would be dismissed without hearing the plea of the petitioner.
After 8 weeks.
4 weeks, 8 weeks, 4 weeks ಆದ್ಮೇಲೆ list the matter on 28th April.
Dismiss ಅಂತ ಬೇಡ. Dismiss ಅಂತ ಬೇಡ.
ಮತ್ತೆ ನೀವು ಕಟ್ಟೋದೇ ಇಲ್ವಲ್ಲ?
ಅಲ್ಲ ಕಟ್ತೀವಿ, ಸ್ವಲ್ಪ ಒಂದು ವಾರ ಆ ಕಡೆ ಈ ಕಡೆ ಯಾಕಂದ್ರೆ ಅವರು ಜಾಸ್ತಿ ಲೋನ್ ಇದೆ.
ಆಯ್ತಾಯ್ತು, ನೋಡಿ, ಎಸ್, ವಿಲ್ ಕರೆಕ್ಟ್ ಇಟ್, ನೋಡಿ.
Please.
ಎಸ್, ನೆಕ್ಸ್ಟ್.
Here for the petitioner in this case, my lord. Annexure A is issued.
61 ದಿನೇಶ್ ರಾವ್.
61.
ನಿಮ್ ನೆಕ್ಸ್ಟ್ ಮಂಜುನಾಥ್ ಪ್ರಸಾದ್.
No, sir, the petitioner, the writ petition mentioned in annexure B is listed for tomorrow. This may be tagged along with this.
No, that is regarding property mark and this is regarding controversies.
The
Now, your lordship,
prayer in the
last year they have paid the
ಇದಕ್ಕೂ ಅದಕ್ಕೂ ಸಂಬಂಧನೇ ಇಲ್ಲ, ಅದಕ್ಕೆ ಅಷ್ಟೇ ಕೊಡ್ಲಿಲ್ಲ.
ಇಲ್ಲ, main prayer is the same, my lords. Due to a subsequent development,
No, your lordship.
amendment was made and then the order was passed on this IA. It is the same subject matter, my lords. It may be listed.
Your lordship, here, last year they have paid the fees and we have not increased the fees for controversies. April now they'll have to renew.
ಆಯ್ತು, ನಾಳೆ ಹೇಳಿ. ಲಿಸ್ಟ್ ಟುಮಾರೋ, ಫ್ರೆಶ್ ಮ್ಯಾಟರ್ಸ್. ಎಸ್, ನೆಕ್ಸ್ಟ್.
It may be tagged along.
ನಾಳೆ ನೋಡೋಣ. ಎಸ್.
62.
ಮಂಜುನಾಥ್ ಪ್ರಸಾದ್, ಇದು
This case, The annexure A is issued without issuing even a notice in violation of principles of natural justice. Matter has been heard by your lordship.
My order is
My
confirmed.
order has
Division
been
bench.
confirmed by the division bench. We are paying the money.
You
We are
serve
paying-
on, you serve on Rupa Rao. Rupa Rao, or Rupa Rond.
We are paying the money.
You serve on her and get her.
Who?
ರೂಪಾ ರೋಣ್ ಅಂತ ಬೇರೆ ಅದ್ರಲ್ಲಿ ಅಪಿಯರ್ ಆದ್ರಲ್ಲ.
ಅಲ್ಲ ಅವ್ರಿಗೆ ಇದ್ರೊಳಗೆ ನನಗೆ ನೋಟಿಸು ಇಲ್ಲ ಏನೂ ಇಲ್ಲ.
ಪರವಾಗಿಲ್ಲ, ನೀವು ಅವ್ರಿಗೆ ಕೊಡಿ.
Annexure A ನೋಡಿ ದಯವಿಟ್ಟು.
ನೀವು ಪರವಾಗಿಲ್ಲ, ಅವ್ರಿಗೆ ಸರ್ವ್ ಮಾಡಿ, ನಾಡಿದ್ದು ತಗೊಂತೀನಿ.
Annexure A.
No worries.
And section 24 has no application.
No worries, we'll see, sir.
Section 24
Counsel for the petitioner is directed to serve on counsel Srimati Rupa Rond, who has represented the respondents throughout with by service of requisite set of writ petition papers. Forthwith, list matter, registry to print the name of Rupa Rond as appearing for the respondent. ಯಾರು ಮಾಡಿಲ್ಲ ಪಾರ್ಟಿ?
ಅವರು
ಮಾಡಿ ಪಾರ್ಟಿ ಮಾಡಿ.
ಒಂದು ಅಲ್ಲ ಪಾರ್ಟಿ ಅಂತ ಹೇಳಿದ್ರೆ ಸ್ವಲ್ಪ ದಯವಿಟ್ಟು ಕೈಂಡ್ಲಿ ಸಿ ಸೆಕ್ಷನ್ 24
whatever it is, ಅವ್ರನ್ನ ಪಾರ್ಟಿ ಮಾಡಿ. I will hear them and pass orders.
ಈಗ ನಮ್ಗೇನು ನೋಟಿಸ್ ಕೊಟ್ಟಿಲ್ಲ.
ಪರವಾಗಿಲ್ಲ, ಅವ್ರಿಗೆ ನೋಟಿಸ್ ಕೊಡದೆ ನಾನು ಮಾಡಲ್ಲ.
In utter violation of
No
principles
problem.
of natural justice.
No problem, sir. You, sir, implead.
I will implead.
Implead, the counsel for the petitioner to implead those respondents as party respondents who were
Before this court in writ petition and writ
who were before this court in writ petition and
Writ appeal.
writ petition number page 40, writ appeal page 56. Forthwith, counsel Srimati Rupa Rond is directed to accept notice for the private respondents. Learned AGA for the first respondent. List the matter on Friday in the fresh matters list.
My lord, appear for the
Rephrasing.
petitioner in this case. Humble submission, this honorable, my lord, permission to speak, my lord. Serial number 77 and then 78.
We'll take it together.
Yes, my lord. First, we will take it to 70.
First we will take 70.
Yes, my lord.
After that, come along with that. Yes, next.
My lord, I appear for
All
the
three are
second
related,
respondent, my lord.
Serial number?
64, my lord.
Yes, madam.
Passport, my lord. Charge sheet is
The petition
filed.
was one of the accused, my lord. Accused.
Charge sheet ಆಗಿದೆಯಾ?
Charge sheet ಆಗಿತ್ತು.
ಆಗಿದೆ ಸ್ವಾಮಿ.
Yes, Reshma madam.
ಚಾರ್ಜ್ ಶೀಟ್ ಆಗಿದೆ ಸ್ವಾಮಿ.
ಆಗಿದ್ರೆ ಏನ್ ಮಾಡಬೇಕು?
My lords, we will consider as per in lines with GSR 570, my lords.
Chandrabhushan.
ಸಂತೋಷ್ ಶ್ರೀನಿವಾಸ್.
Huh?
ಸಂತೋಷ್ ಶ್ರೀನಿವಾಸ್.
Correct. Close on that. ನೀವಿದ್ದೀರಾ, ರೇಷ್ಮಾ ಇದ್ದಾರಾ?
ಅಲ್ಲಲ್ಲ ಅವರೇ ಇದ್ದಾರೆ.
ಅವರೇ ಇದ್ದಾರೆ. ಸರಿ.
Since I was here, therefore.
No problem.
But there's a CC number, my lord, it's.
The
CC number.
petitioner is before this court seeking the following prayer. Heard so and so. The petitioner is a holder of an Indian passport. The passport is said to be, the application is said to be submitted for renewal of the said passport. In the interregnum, the petitioner gets embroiled in a crime number 46 of 2019 for several offences. The police, after investigation, have filed a charge sheet in the said matter. The petitioner is arraigned therein as accused.
Accused number 6, my lord.
Accused number 6. In the light of the charge sheet being filed by the police, the reissuance or renewal of the passport can happen only in terms of the Passports Act 1963, 1967, with particular reference to section 6(2)(f) of the Act. In identical circumstances, this court in the case of so and so has held as follows. MP madam, chamber
My lord,
24269 of 2023, madam.
my lord, there's one submission. We have filed separate petition in the sessions for criminal miscellaneous, and we also, the matter got disposed, and the said court has granted bail.
Correct.
Accused number 6, my lord.
No problem.
Kindly.
No problem at all. Bail ನಿಮಗೆ ಏನ್ ಕಂಡೀಷನ್ ಇಲ್ಲ ಅಂದ್ರೆ this condition is under the statute.
Make one submission. If your lordship may kindly turn to page 14. That KPID Act is there, my lord. Let them be implemented, my lord. The reason is this, my lord.
ಯಾರು?
So far as the crime and competent authority.
ಅಲ್ಲ,
Viresh
SVP
Budhi,
ತಾನೆ.
Lord, otherwise what happens, my lord? We don't know what is the proceedings as of now there, my lord.
So therefore, my lord,
ಬಡ್ಸ್ ಆಕ್ಟ್ ಬೇರೆ ಇದೆ.
KPDFU also is there.
ಆಯ್ತು, ಇಂಪ್ಲೀಟ್ ದಿ ಇದು ಹಿಂಗೆ ಇರಲಿ ಮೇಡಮ್, MPK ಮೇಡಮ್, ಇದು ಹಿಂಗೆ ಇರಲಿ ಮಾಡಿರಿ, ಡಿಸ್ಪೋಸಲ್ ಅಂತ ತೋರಿಸ್ಬೇಡಿ, ಹೇಳ್ತೀನಿ. Yes. The ವೀರೇಶ್ ಬೂದಿಹಾಳ್ಗೆ ಸರ್ವ್ ಮಾಡಿ. Counsel Viresh Budihal, the petitioner is directed to implead the competent authority as a party respondent. Counsel to Viresh Budihal is directed to accept notice for the said competent authority. Petitioner to serve set of papers. List the matter on 1st April in the fresh matters. Ivat serve ಮಾಡಿ ಅವತ್ತು ಮಾಡಿ. Bail condition may be anything. ಅದು ಎಲ್ಲ ರೆಡಿ ಮಾಡಿರಿ, ಸೇಮ್ ಆರ್ಡರ್ ಆಗಿ.
My lord, petitioner approached respondent for renewal of passport. Here the petitioner's stepmother has given complaint.
Yes,
as 490.
My lords, the same thing, my lords, this was heard the last time, charge sheet is filed in this also, my lords.
Same short validity passport.
Yes.
ಇದು ಬರ್ಕೊಳ್ಳಿ ಮೇಡಮ್. The petitioner is before this court seeking the following prayer. The petitioner heard so and so, facts in brief germane are as follows. The petitioner is the holder of an Indian passport which is set to expire on 26/4/2025. The petitioner submits an application seeking renewal or reissue/renewal of the passport. In the interregnum, the petitioner appears to have been embroiled in a crime crime number 53 of 2022, and the police, after investigation, have filed a charge sheet against the subject petitioner as well. In the light of the filing of the charge sheet, the petitioner does not become entitled to a regular validity passport, but is entitled to a short validity passport in terms of GSR 570 of 1993 issued by the Government of India in the Ministry of External Affairs. In identical circumstances, this court in the writ petition, Aditya, 24269 of 2023 has held as follows. I'll same order, madam. Yes, Ali Reshma Keti and respondent.
66.
For 2 days accommodation.
Katilwa?
There is no interim order, my lord.
It has not been granted, my lord.
2nd April.
Recovery certificate has been issued.
List the matter on April the 2nd, 2025. Next.
67.
So I appear for petition, my lord. The respondent, my lord, has issued a notice, my lord, of shifting the premises, my lord.
Stop business.
Stop business, my lord, which is contrary to his own report, page 49, my lord, may kindly see.
Yen business so?
ಏನಿಲ್ಲ ವರ್ಕ್ಶಾಪ್ ಮೇಲೆ
ಏನಿಲ್ವಾ?
ವುಡನ್ ವರ್ಕ್ಶಾಪ್ photographs was produced at the instance of the respondent number 3 Milord, who has built the house subsequent to
One Mahesh
after building the
Chaudhary.
house.
A Mahesh Chaudhary is directed to accept notice for respondent 1 and 2. Emergent notice to respondent to the remaining respondents. Highway ಮೇಲೆ ಇದೆಯಾ?
Highway ಮೇಲೆ ಇದು state national highway.
Yes.
Photographs I have produced, Your Lordship. There is a clear report in para 49, my lord, may kindly see.
ಏನು?
Encroached 40-meter road, my lord.
You have encroached.
No, third respondent, my lord. Third respondent, mother, who has built the house after.
ಈಗ ಇಂಟ್ರಿ ಮಾಡ್ರಲ್ಲಿ ಸ್ಟಾಪ್ ಮಾಡಕ್ಕಾಗಲ್ಲ ಬಿಸ್ನೆಸ್.
ಅಲ್ಲಲ್ಲ ಅದಕ್ಕೆ.
So and so. ಆಮೇಲೆ emergent notice to the remaining respondents returnable by the 15th of April.
ನೋಟಿಸ್ ಬೇರೆ ಕೊಟ್ಟಿದ್ದಾರೆ ಇವಾಗ ಜಸ್ಟ್ ನಾವು.
ತೊಂದ್ರೆ ಇಲ್ಲ ಅವ್ರು ಮಾಡಿ.
ಅಲ್ಲಲ್ಲ ಇಲ್ಲಿ ಶಿಫ್ಟ್ ಮಾಡ್ಲಿಲ್ಲ ಅಂತ ಹೇಳಿ ನೋಟಿಸ್ ಕೊಟ್ಟಿದ್ದಾರೆ ಇವಾಗ ರೀಸೆಂಟ್.
ಅವ್ರು ಮಾಡ್ತಾರೆ ಬಿಡಿ. ನಿಮ್ಮೇಲೆ ಕೊಟ್ಟಿರೋದು ನೋಟಿಸ್.
ನಮ್ಮೇಲೆ ಕೊಟ್ಟಿರೋದು ನೋಟಿಸು. It is I, my lord.
Third respondent is the complainant, right?
Respondent mother is the who built the house, my lord, residential house, encroaching the property of the national highway, wherein the entire area, my lord, is surrounded by industrial area, my lord, where I am running the show, my lord.
We'll see.
Showcase notice on.
ಇರ್ಲಿ ಅದು ಚಾಲೆಂಜ್ ಮಾಡಿ.
ಅಲ್ಲ ಇದನ್ನ
ಅದು ಚಾಲೆಂಜ್ ಮಾಡಿ ಸ್ಟೇ ಮಾಡಿ.
ಮಾಡ್ಲಿಲ್ಲ ಅಂತ ಹೇಳಿ.
ಚಾಲೆಂಜ್ ಮಾಡಿ ಸ್ಟೇ ಮಾಡಿ. ಎಸ್.
ಇದನ್ನೇ ಚಾಲೆಂಜ್ ಮಾಡಿದೀನಿ ಸರ್.
ಈಗ ಕೊಟ್ಟಿದ್ದಾರೆ ನೋಟಿಸ್ ಅಂದ್ರೆ?
ಅಲ್ಲ ಈ ನೋಟಿಸು ನೀವು ಇನ್ನೂ ಶೂಟ್ ಮಾಡಿಲ್ಲ, ವೈ ಆಕ್ಷನ್ ಶುಡ್ ನಾಟ್ ಬಿ ಟೇಕನ್ ಅಂತ ಹೇಳಿ ಒಂದು ನೋಟಿಸ್ ಕೊಟ್ಟಿದ್ದಾರೆ.
ಗೆಟ್ ದಿ ಪೊಲ್ಯೂಷನ್ ಕಂಟ್ರೋಲ್ ಬೋರ್ಡ್. ಯಾರು ನೋಟಿಸ್ ಕೊಟ್ಟಿರೋದು?
ಇದು ಮಹಿಳಾ ಮಕ್ಕಳು ಮತ್ತು ಮಕ್ಕಳ ಕಲ್ಯಾಣ ಅಭಿವೃದ್ಧಿ ಇಲಾಖೆ ಅವ್ರು ಕೊಟ್ಟಿದ್ದಾರೆ.
ಅವ್ರಿಗೂ ನಿಮಗೂ ಏನ್ ಸಂಬಂಧ?
ಅದೇ ನನಗೂ ಗೊತ್ತಿಲ್ಲ, ಎಲ್ಲರೂ
ಅದು ನೋಡೋಣ ಬಿಡಿ. ಎಸ್ ಲಿಸ್ಟ್ ಆನ್ 4th April ಅಂತ.
4th April, may I request page 49 for a moment, you will.
ಏನ್ ಹೇಳಿ?
Page 49, ಚೌಡೇಶ್ವರಿ ಪ್ಲೈನಿಂಗ್ ವುಡ್ ವರ್ಕ್ಸ್ ಉದ್ದಿಮೆಗೆ ಕೈಗಾರಿಕಾ ಉದ್ದೇಶಕ್ಕೆ ಅನ್ಯಕ್ರಾಂತವಾಗಿ ಸ್ಥಾಪನೆಯಾಗಿರುತ್ತದೆ ಮತ್ತು ಮೊದಲು ಕಟ್ಟಡ ನಿರ್ಮಾಣ ಆಗಿರುತ್ತದೆ. ಚೌಡೇಶ್ವರಿ ಪ್ಲೈನಿಂಗ್ ವುಡ್ ವರ್ಕ್ಸ್ ಉದ್ದಿಮೆ ಕುಶಲಕರ್ಮಿ ಘಟಕ ನಿರ್ಮಾಣ ಆದ ನಂತರ ದೂರುದಾರರಾದ ಶ್ರೀಮತಿ ಆಯಿಷಾ ಬಿ ಹಾಗೂ ಮೊಹಮ್ಮದ್ ಅತೀಕ್ ಶೇಖ್ ರವರು ರಾಷ್ಟ್ರೀಯ ಹೆದ್ದಾರಿಯ 40 ಮೀಟರ್ ರಸ್ತೆ ಮಾರ್ಜಿನ್ ಜಾಗವನ್ನು ಅತಿಕ್ರಮಿಸಿ ನೀರಾವರಿಯ ನಾಲೆಯ ಜಾಗವನ್ನು ಒತ್ತುವರಿ ಮಾಡಿ ನಿಯಮಬಾಹಿರವಾಗಿ ಚೌಡೇಶ್ವರಿ ಪ್ಲೈನ್ ವುಡ್ ವರ್ಕ್ಸ್ ಉದ್ದಿಮೆ ಕುಶಲಕರ್ಮಿ ಘಟಕದ ಕಟ್ಟಡಕ್ಕೆ ತಾಗುವಂತೆ ಒತ್ತಾಗಿ ಮನೆಯನ್ನು ಕಟ್ಟಡ ನಿರ್ಮಿಸುತ್ತಾರೆ. ಮೊದಲು ಚೌಡೇಶ್ವರಿ ಪ್ಲೈನಿಂಗ್ ವುಡ್ ವರ್ಕ್ಸ್ ಉದ್ದಿಮೆ ನಿರ್ಮಾಣವಾಗಿರುತ್ತದೆ. ನಂತರ ದೂರುದಾರರು ಬೇಕಂತಲೇ ಉದ್ದಿಮೆದಾರರನ್ನು ಒಕ್ಕಲೆಬ್ಬಿಸುವ ಸಲುವಾಗಿ ಕೈಗಾರಿಕೆ ಘಟಕದ ಪಕ್ಕದಲ್ಲಿ ನಿಯಮಬಾಹಿರವಾಗಿ ಕಟ್ಟಡ ಕಟ್ಟಿರುತ್ತಾರೆ. ದೇ ಹ್ಯಾವ್ ನಾಟ್ ಒಬ್ಟೈನ್ಡ್ ದಿ ಲೈಸೆನ್ಸ್ ಮೈ ಲಾರ್ಡ್. ಐ ಹ್ಯಾವ್ ಒಬ್ಟೈನ್ಡ್ ಲೈಸೆನ್ಸ್. ಮತ್ತು ಚೌಡೇಶ್ವರಿ ಪ್ಲೈನಿಂಗ್ ವುಡ್ ವರ್ಕ್ಸ್ ಉದ್ದಿಮೆಯ ಬೆಳಿಗ್ಗೆ 10 ಗಂಟೆಯಿಂದ 6 ಗಂಟೆವರೆಗೆ ಮಾತ್ರ ಉದ್ದಿಮೆ ವ್ಯವಹಾರ ಮಾಡಲು ತೆರೆಯಲಾಗಿರುತ್ತದೆ. ಸದರಿ ಉದ್ದಿಮೆಯಿಂದ ಶಬ್ದ ಮಾಲಿನ್ಯವಾಗುತ್ತಿದೆ ಎಂಬುದಕ್ಕೆ ಯಾವುದೇ ರೀತಿಯ ತಾಂತ್ರಿಕ ಮಾನದಂಡ ವರದಿ ಇರುವುದಿಲ್ಲ. ಗ್ರಾಮ ಪಂಚಾಯಿತಿ ವ್ಯಾಪ್ತಿಯಲ್ಲಿ ಹಲವಾರು ಬೃಹತ್ ರೈಸ್ ಮಿಲ್ಗಳು, ಸಾಮಿಲ್ಗಳು, ಕೈಗಾರಿಕಾ ಘಟಕಗಳು ಕಾರ್ಯನಿರ್ವಹಿಸುತ್ತಿದ್ದು ಯಾವುದೇ ರೀತಿಯ ದೂರು ಇರುವುದಿಲ್ಲ ಮತ್ತು ಮಾಲಿನ್ಯವೂ ಇರುವುದಿಲ್ಲ. ದೂರುದಾರರು ಬೇಕಂತಲೇ ಕೈಗಾರಿಕಾ ಘಟಕದ ಕೈಗಾರಿಕಾ ವಲಯದಲ್ಲಿ
Status quo
ಮನೆ
quo,
ಕಟ್ಟಡ
one ನಿಮಿಷ. Status quo quo, the property be maintained to the next date of hearing. Yes,
gratefully
next.
68.
seek for hand delivery of the order. Please.
Yes.
Passport.
For the respondent, Your Lordship.
ಏನು?
Your Lordship, there was a show cause notice which was issued to the applicant and the
For what?
passport has already been issued to him. There was an adverse PVR by the police.
What adverse PDR?
There was a crime which was pending. and
Crime
also
stage or charge sheet?
It was at a crime stage and there was another CC which was filed wherein his name has been dropped. That information he himself has given now.
Then when do you issue the passport?
Before that.
When did you issue, what is that?
Passport was issued on 5th of
Have you
February.
withdrawn that?
No, show cause notice was issued on 7th of February,
Sir,
March 7th, Your Lordship.
withdraw the show cause notice, that's all.
It can be done.
I'll take it on Friday. By then take action. Yes. You know these facts now, so withdraw it. Otherwise, if it matter is at the stage of FIR, there is no problem. In the
Definitely.
other CC, he has been dropped.
Your Lordship, this was also premature. I mean, he could have replied to the show cause notice saying that, categorically saying that my name has been dropped
Anyway,
there.
reply madilvan.
He has not replied at all.
Submit a reply. They will immediately
We'll
pass
consider
orders.
it, definitely.
The petitioner is directed to submit a reply to the show cause notice that is subject matter of challenge in the case at hand. The learned counsel for the petition respondent Aditya Singh submits that the petitioner has got himself embroiled in a crime which is still at the stage of crime. In another case where charge sheet was filed, the name of the petitioner has been dropped. Therefore, it forms a twin circumstance for the grant for the issuance of passport or withdrawal of the show cause notice as the case would be. The petitioner is thus directed to furnish his reply forthwith to the show cause notice and the passport authorities to act forthwith on the said show cause notice. With the aforesaid observations, the petition stands disposed.
In another matter.
ಇನ್ಯಾವುದು?
Next matter.
ಅದರಲ್ಲೇನು?
ಅದರಲ್ಲಿ
Your Lordship, there are 2 CCs which are pending.
Then.
So Your Lordship, it is covered by Your Lordship judgment.
Yes, my lord, all the cases.
ಚಾರ್ಜ್ ಶೀಟ್ ಇದ್ರೆ ಆಗಲ್ಲ.
At least temporary.
ಅದೇ short validity
Short
passport.
validity.
Start.
The petitioner is before this court seeking the following prayer. The learned counsel for the petitioner, the learned counsel for the respondent Aditya Singh submits that there are 2 crimes in which the petitioner is in which charge sheet is filed against the petitioner. Three crimes.
One net crime.
Therefore, the petitioner would not become entitled to a regular passport in the light of the bar under section 62F of the Passports Act 1967. In that light, the petitioner but becomes entitled to issuance of a short validity passport in identical circumstances, so and so.
Your Lordship, WP number 24269 of 23.
Yes.
Your Lordship, may kindly show the name of DSG in this matter. Shanti
ಹೌದಾ?
Bhushan. The
ಶಾಂತಿ
second
ಭೂಷಣ್
matter.
ನೇಮ್ ಹಾಕ್ಬಿಡಿ. Yes.
Much of it.
70.
Lord. Although, my lord, the order, my lord, which is imputed is only a section 14 order. Lord, we are ready to pay. We have brought the check, my lord, 45
What the
lakhs.
check?
We have brought a check. We'll give
ಎಷ್ಟಿದೆ?
45 lakhs.
Sale taken place.
ಎಷ್ಟಿದೆ?
Sale taken place.
ಸರಿ.
Earlier 2 occasions, my lord, this honorable court entered interim order 2 occasions.
Correct.
Both.
ಅವ್ರು ಹೇಳಿ, ವಿಘ್ನೇಶ್ is fair, wait. Yes.
My lord, kindly, my lord, see the order passed by this honorable court. They have not made any attempt to make any money. My lord,
ಅದಕ್ಕೆ ಚೆಕ್ ಡಿ ತಗೊಂಡ್ ಬಂದ್ಬಿಟ್ಟಿದ್ದಾರೆ ಈಗ.
sale ಆಗಿದೆ, sale, my lord.
ಸರ್ಟಿಫಿಕೇಟ್ ಆಗೋಗಿದ್ಯಾ?
Created, no, my lord.
ಸೇಲ್ ಯಾವಾಗ ಆಗಿದೆ?
Sale taken place on, my lord, the one side on, my lord, 28/11/2024. 26/11/2024, my lord.
ಇನ್ನೊಂದು.
ಇನ್ನೊಂದು 16/12/2024.
Lord, this is without notice also to us.
Without notice.
Please, madam.
Without notice.
I'll produce it. That is a case notice. All the
Allah.
cases can't be granted. I'll produce it. In fact,
Ah.
the eviction taken
ಅದೇ
place.
ಎಲ್ಲದರಲ್ಲೂ ಅಷ್ಟೇ
paper
without
publication
notice.
produce ಮಾಡಿದ್ದಾರೆ.
DRT ಹೋಗ್ಲಿಲ್ವಾ?
ಇಲ್ಲ, we have not gone to that.
ಹೋಗ್ಬಿಡಿ.
We'll give, Lord, we will deposit
That is the order.
45 lakhs checks with them, Lord.
My lords,
Immediately.
my lords, 2 occasion pass in order. Some
ಈಗ
amount they would have.
We have produced those
ಎರಡು writ
orders.
petition
ಸೇಲ್
ಹಾಕಿದ್ರು.
ಸರ್ಟಿಫಿಕೇಟ್ ಇಶ್ಯೂ ಆಗಿದೆಯಾ?
ಅದೊಂದು information ತಗೋಬೇಕು.
We have produced those orders, Lord. It's not that
That
we
if my
suppress
lords
it.
have it tomorrow, I can take an instruction.
Your lordship has been in touch.
Confirmation ಆಗಿದೆ.
List day after tomorrow in the fresh matters list. Yes. If the sale certificate is not issued as on today, the same shall not be issued till day after tomorrow. Yes. Other conditions will deposit.
Order ನಾನು point ಮಾಡ್ತೀನಿ ಸ್ವಾಮಿ.
ನಾಡಿದ್ದು ನೋಡೋಣ condition.
4 ಅಲ್ಲಿ my lord only dismiss it.
ನೀವು day after tomorrow ಹೇಳಿ, I will dismiss it again. Fresh matters, yes.
Lord,
Dismiss it
possession
again.
till then maybe.
Position already taken here.
Position ಏನ್
Possession
ಬೇಕು?
is with me, my lord.
No problem. Yes, I have said sale certificate issue ಮಾಡು, ಬೇರೆ ಯಾವ ಆರ್ಡರ್ ಇಲ್ಲ.
Execution also taken.
Next.
71.
One ನಿಮಿಷ Anish, Ravi sir. Supreme Court has directed treasurer's post to every association and
Yes,
that's
madam.
what they said. Even Nalina Mayagoda madam had appeared on that.
ಮಾತಾಡಿದ್ರು ಅವ್ರಿಗೆ.
She had appeared there. So we will direct treasurer's post to be in terms of the direction of the apex court.
What about the other? I consider, I think I need.
ಅದೇನ್ ಬೇಡ ಅನ್ಸುತ್ತೆ.
Very well.
Treasurer's post ಮಾತ್ರ. All right. Next bylaw ನೋಡ್ಕೊಳ್ಳೋಣ ಆಮೇಲೆ.
Yes.
Members, what they've added, that should continue because even in Supreme Court.
Ah.
governing council members-
ಅಲ್ಲ, only joint secretary will not be there.
Yes, madam.
Treasurer and other two executive members.
Very well.
ಬೆಳಗ್ಗೆ ಕಾಪಿ ರಿಲೀಸ್ ಮಾಡ್ತೀನಿ. Yes.
But here the only short grievance is that, my lord,
When do you take the next flight to Jabalpur or Indore or wherever you want to go? ಮಧ್ಯಪ್ರದೇಶ್ಗೆ ಇಲ್ಲಿಂದ ರಿಟ್ ಕೇಳ್ತಾ ಇದ್ದೀರಾ? I will impose with exemplary costs.
my lord, the action has been taken.
ಏನ್
by
action
the-
note, come to the prayer. Come to the prayer. Where is the petitioner?
I mean,
Sadol branch, Madhya Pradesh. File it in Madhya Pradesh High Court. Anything else? The learned counsel of the petitioner seeks leave of this court to withdraw the petition and file the petition before the appropriate jurisdiction. Petition stands disposed as withdrawn, reserving such liberty. Next.
72.
Notes one submission.
Ah.
Notes as heard one matter in
Yes,
Dharwad.
that will come next week.
One submission. Subsequently, my lord, one Supreme Court order has been passed. That also may be.
Give it. We'll take note of that also. Give it.
Paragraph number, it's mentioned.
Yes. Yes, next.
My lords, appear for the petitioner in this matter, my lords.
70?
Two, my lords.
Ah.
I filed a writ of mandamus, my lords, to consider my complaints before the Lokayukta, my lords. It was filed in the.
Who are you, sir?
My lords, I am the ex.
Serve on BB Patil.
Please, my lord.
Counsel BB Patil is directed to accept notice for the first respondent. Notice to the other respondents is not required. List the matter on 1st April in the fresh matters.
Oblige, my lord.
Next. With this, madam. Now Supreme Court has directed treasurer's post ante.
Yes.
Now I will take off the joint secretary's post, retain 2 posts of executive committee members and treasurer.
Please, my lord.
That should be all
Please.
right.
Very grateful.
Yes.
70. 73.
73. Appear for petitioner. Second respondent. is the-
73, yeah.
Please.
ಏನು?
Second respondent is the husband who is the principal borrower from the first respondent, India Bulls company. And the flat was purchased
Joint.
jointly in the name of husband
ಈಗ
and
both
wife.
of your relationship is not all right.
Trained and
Husband is not paying the
paid-
EMI.
paid. Bank
Now
has
you are being
proceeded.
evicted.
We have been evicted yesterday, my lord. During, even in spite of telling that the petition is pending before this honorable court.
That's all
And
right.
DRT has dismissed my petition only on the ground of delay, my lord. And we are before the, in fact,
ಈಗ
respondent one.
ದುಡ್ಡು ಯಾರು ಕಟ್ತಾರೆ?
Please, my lord.
ದುಡ್ಡು ಯಾರು ಕಟ್ತಾರೆ?
We are saying that we are ready to pay that in case it is rescheduled it, my lord. That is what my submission all.
Emergency India Bulls ಯಾರ appear? Francis, huh? Francis. The learned counsel Francis Xavier is directed to accept notice for the first respondent. Copy to the serve so and so.
Will serve.
Facts ಕೇಳ್ಕೊಂಡ್ರಲ್ಲ?
ಕೇಳ್ಕೊಂಡು.
ಮತ್ತೆ.
Transfer petition is before pending before the Supreme Court, my lord.
That's all right, yes.
And
List-
there is a mediation happening.
List
11th
day
is the
after
mediation.
tomorrow, put them back.
Please.
Possession ವಾಪಸ್ ಕೊಟ್ಟಿರಿ. Huh? I'll take it day, I'll take it day after tomorrow.
Mother and
Let,
child.
let not the mother and child go on the streets. I'll pass an order.
No, no. We'll
ನೀವೇ
intimate them.
ಕೊಡ್ತೀರಾ?
ನಾಳೆ ಹಾಕೊಂಡ್ರೆ
ನಾಳೆ
ನಾಳೆ
ಕೊಡ್ತೀರಾ?
ಹಾಕೊಂಡ್ರೆ ಇವತ್ತು ಅವ್ರಿಗೆ ಹೇಳ್ತೀನಿ ಈ ರೀತಿ ಆಗ್ತಿತ್ತು.
ಇಲ್ಲಾಂದ್ರೆ ಆರ್ಡರ್ ಮಾಡ್ತೀನಿ.
Giving shelter in my residence office ಮೇಲೆ. Since they were thrown on the
ಆಯ್ತು,
streets.
ಒಂದ್ ನಿಮಿಷ. The,
ಬೆಳಗ್ಗೆ
ಒಂದ್ ನಿಮಿಷ.
fresh
The petitioner is the wife of one Avarapalli Ranga Rao. An apartment is purchased jointly by the husband and the wife. The relationship between the husband and the wife flounders. On such floundering, the husband is said to have stopped paying EMI. The account becomes sticky. The respondents are at the doors of the petitioners. The petitioner's mother and child are now evicted and the husband appears to have achieved his objective. Therefore, I deem it appropriate to direct the bank to restore possession of the property to the wife and the child forthwith.
ನಾಳೆ ಹಾಕೊಂಡ್ರೆ instruction.
ನಾಳೆ ನೀವು ಫಸ್ಟ್ ಕೊಡಿ, ಆಮೇಲೆ I will direct them payment. Definitely they will pay. First give them possession.
ಟ್ರಯಲ್ ಕೋರ್ಟ್ ನಲ್ಲೂ ಆರ್ಡರ್ ಹಾಕಿಲ್ಲ ಇವ್ರಿಗೆ.
ಆಯ್ತು, ಈಗ ಏನಾರು ಇರ್ಲಿ. The mother and child should not be on the streets. You give them possession tomorrow. Day after tomorrow, I will impose conditions. Yes. Day after tomorrow, ಆಮೇಲೆ possession ಸಿಕ್ಕಿದೆ ಅಂತ you can't move out. And you will have to pay some amount. I will impose conditions. Then first ಮನೆ ಕೊಡಿ. Yes. ನಾಳೆ. Day after tomorrow in the fresh matters list. Next.
24.
The petition is mallards by the members of respond number 3 mallards. Mallards by they are violating.
How can you ask withholding of meetings, sir?
Mallards, they have bylaw says mallards only within for 5 years once they have to take meeting mallards. The thing is mallards they have
ಏನ್ ಪದೇ ಪದೇ ಮೀಟಿಂಗ್ ಕರೆದ್ರೆ ಏನ್ ತೊಂದ್ರೆ?
not meeting for the change in the governing council mallards. It's the 4th time they are changing the governing councils by one.
We'll see, serve on them. ನಿಮ್ಮ ಮಾತು ಕೇಳಿ ಎಂಟ್ರಿ ಮಾಡಿ ಕೊಡಕ್ಕಾಗಲ್ಲ.
Mallards, kindly see, I have produced annexure DEF mallards.
ಅಷ್ಟೇನಾ, ಬೇರೆ ಏನೋ ಹೇಳಿದ್ರಿ? 1 and 2 state, 3 emergent, 3 be served by way of hand summons.
Tomorrow. There
No,
is a
sir.
meeting mallards, that's why mallards.
The meeting that is slated to be held tomorrow shall remain subject to the result of the petition. List the matter on 4th April. Yes.
Only 8 months tenure, that is why mallards. The election.
4th April 8 ದಿನಾನೂ ಇಲ್ಲ. Wait, sir. Yes.
4th, but
No.
Second game, April.
We don't know how many skeletons will come out of the cupboard when the respondents come. We'll see. No.
April 2nd.
No, sir. I'm not going to stay it at all.
April 2nd.
Second ಬೇಕಾಯ್ತು. Second.
25.
Vignesh.
Option purchaser.
ಒಂದು ನಿಮಿಷ. Vignesh.
Sale certificate page number 30, it is registered.
ಏನ್ ಬೇಕು ನಿಮ್ಗೆ?
I have to take the possession. Possession is not given. I have it.
Learned Counsel Vignesh Shetty is directed to accept notice for the respondent. Union Bank of India, Vignesh, taking so and so. 1st April, fresh matters. ಅದ್ರಲ್ಲೇನು ಎಂಟ್ರಿ ಮಾಡಿರಲ್ಲ, ಅವರೇ ಬರ್ಬೇಕು. ಎಸ್. ನೋಟ್ ಮಾಡಿಸ್ಬಂಗೆ ಮೇಡಮ್. ಕರ್ಕೊಂಡು
ಕೊಟ್ಟಿದ್ದೇನೆ.
Eleven.
Fresh matter. Kashyap in night.
In terms of the memo. Oh, for withdrawal, submission 6, leave of this court to withdraw the petition. Next.
Bill number 2, Ramesh KR.
ಏನೋ ಎವಿಕ್ಟ್ ಮಾಡ್ತಾ ಇದಾರೆ ಅಂತ ಮೂವ್ ಮಾಡಿದ್ರು. ಅದೇ ಶಾಪ್ಸ್ ಕೇಳಿದ್ನಲ್ಲ ಬೆಳಗ್ಗೆ, ಯಾವ ಶಾಪ್ ಅಂತ? ಬಾಲ್ಬಾ. ಓ, ಎಷ್ಟೊಂದು ಶಾಪ್ಸ್ ಇದೆ. Subletting. ಆಯ್ತು, anyway, seek instructions. I'll take it on Friday. Learned AGA is directed to accept notice for all respondents. The petitioners shall not be evicted from the shops till the next date of hearing. List on first hakbidla. List on first in the fresh matters list. Yes, next.
3, Sachin BF.
So writ of mandamus, my lord, seeking.
Mandamus kya kerduware urgence kargana?
Karga, my lord. Because priest, my lords, in the temple, karga agta ide, my lords. 28th, there is a meeting to be scheduled, my lords, by the Tahsildar.
I'll seek copy ಕೊಟ್ಟಿಲ್ವಾ?
I have given.
Seek instructions ಅಂದ್ರೆ ಆಗಲ್ಲ, ಇದ್ರಲ್ಲಿ ಏನ್ ಮಾಡೋದು ಹೇಳಿ?
Notice for hearing, the 3 claimants are there.
ಅನೇಕಲ್ಲ ಇದು.
Anikal, my lords, my lords, this is regarding appointment of priest, my lords. That is regarding.
ಆಯ್ತು, look into it. ಯಾವ ಕರ್ಗ ನಡೀತಾ ಇದೆ ಈಗ?
My lords, next week, my lords, is the 28th, my lords, is
List
the.
day
meeting.
after tomorrow in the fresh matters. List day after tomorrow in the fresh matters list, secure instructions, 28th will permit hearing. Yes, next.
Number 4,
ಅದ್ರಲ್ಲಿ learned AGA is direct, ಯಾರಿಗೆ ಇಬ್ರು AGA ನೇ ಹೋಗ್ಲಿ ಬಿಡಿ. Yes, next. Rahul.
Melons are appear for the petitioners. Petitioner Melons is a tenant. There's a commercial shop Melons wherein 12 shops are there and 5
ಈಗ ಏನಾಗ್ಬೇಕು?
ಅದು possession ತಗೊಂಡಿದ್ದಾರೆ ಬ್ಯಾಂಕ್ ಅವರು. I'm running a printing press, ನಾನು press material.
Learned Counsel Vignesh Shetty is directed to accept notice for the respondent petitioner to serve set of papers upon the aforesaid counsel. 1st April or 2nd Akla? 1st April, the petitioners, no precipitative action shall be taken against the petitioners till the next date.
Direction to open the shop.
Close ಮಾಡಿದಾರಾ?
Close ಮಾಡ್ಬಿಟ್ಟಿದ್ದಾರೆ.
ಅದು ಕಷ್ಟ. Then he will have to take instructions. Then we'll post it on Friday. List on 28th in the fresh matters list.
5, PM.
In this case,
Disconnect ಆಗಿದೆಯಾ ಆಗ್ಬೇಕಾ?
disconnect.
ಆಗಿದೆಯಾ? ಯಾಕೆ? BBMP ನಾ?
No, Manada.
ಮತ್ತೆ?
Pertain to Chescom, Manada.
ಅದು ಗೊತ್ತು ಸರ್. BBMP ಕಂಪ್ಲೇಂಟ್ ಇಂದ ಆಗಿರೋದಾ ಏನು?
ಇಲ್ಲ.
ಮತ್ತೆ?
Respect to the revised supplementary bill. ಅದಕ್ಕೆ ನಾನು given the.
ಎಷ್ಟಿದೆ ಡ್ಯೂ?
ಅವ್ರ ಪ್ರಕಾರ ಮಲಡ್ 6,06,000 ಇದೆ.
ಹಾ.
Question is ಮಲಡ್ they are referring to the 2019 in the bill.
Learned Counsel ಲೋಕೇಶ್ ಎಲ್ಲಿದ್ರ? ಲೋಕೇಶ್ ಯಾವ್ದಿದ್ದು?
ಚಾಮುಂಡೇಶ್ವರಿ.
ಚೆಸ್ಕಾಂ ಯಾರಿದ್ದಾರೆ ಲೋಕೇಶ್? HV Devraj is directed to accept notice for all the respondents petitioner to serve set of papers upon the aforesaid counsel. List on 28th. There shall be an interim order of stay spread for till the next date of hearing. Next.
Residential property, my lord. House, madam. Residential house, my lord.
KVT ಸರ್ವ್ ಮಾಡಿದ್ದೀರಾ?
Sir, ಮಾಡಿ.
ಯಾವಾಗ? ಎಲ್ಲಿದೆ ಅಕ್ನಾಲಜ್ಮೆಂಟ್?
Babaleshwar.
ಫಾರ್ MGC. ಹೇಳಿದಿರಾ ಇವತ್ತು 2 ರಿಮೂವ್ ಮಾಡಿದ್ದೀನಿ ಅಂತ?
ಸಿಗ್ಲಿಲ್ಲ.
List day after tomorrow, fresh matters list. Yes.
7, Jayasimha KP.
Petitions, my lordship, these petitions are landlords, they are executed the sale deed. The sale deed is a fraudulent deed, they are, the respondent on is the fraudulent.
Challenge ಮಾಡಿ. Challenge. ಏನ್ what are you asking? Lebanese sketch ಕೊಡಬಾರ್ದು ಅಂತ.
So they are not obtaining, they are not furnishing the 11 sketch, they are.
Learned AGA is directed to accept notice for.
Sale deed, my lordship.
So notice for respondents 2, 3, 4, 5. Emergent notice to the first respondent. List on.
Status quo, my lord.
ಯಾವ status quo, sir?
Status quo, the interim order, the respondent.
For what, sir?
Is not to interfere the shoot scheduled properties.
File a suit, sir. Anything else, sir?
Humble request.
No, humble request ನಲ್ಲಿ jurisdiction entertain ಮಾಡಕ್ಕಾಗುತ್ತಾ? File a suit. If you interfering with the position, file a suit.
Petitions already filed a injunction suit.
Then pursue it, sir.
They are already filed, my.
Pursue it, sir.
The fraudulent deed, my lord.
ಅದು ಅಲ್ಲೇ ಸರ್. Can I say it is fraudulent, sir? Article 226 ಅಲ್ಲಿ. ಹೆಂಗೂ ಸೂಟ್ ಹಾಕಿದ್ದೀರಾ? Yes.
The injunction suit, my lord.
ಯಾವ್ದು? No problem. So fraudulent deed ಅಂತ can I say, sir? ಅದಕ್ಕೆ ಹಾಕಿ ಏನ್ ಬೇಕದು? Yes. List the matter on 15th April. Next.
Oh, bless.
Eight. Dheeraj AK.
Here for the petition.
Yes, Rahul. Unauthorized.
With regard to rule 145(2) of Karnataka press rules. Amendment, my lord.
ಏನ್ ಬೇಕು ನಿಮ್ FDT ನಾ? ಅಲ್ಲ.
ಇದು transit application fee for.
Transit application.
pass. This honorable court, my lords, has already granted an interim order.
ಕೊಡಿ. tag this petition along with so and so. The learned counsel of the petitioner submits that there is an interim order operating in the companion petitions. In that light, there shall be an interim order in the case at hand as well.
Right? Now we are
Representing Maratha community, which has got 60 families in the locality. The respondent number 4 and 5, were the members of the same community, residing under the same roof.
ಈಗ ಏನ್ ಪ್ರಾಬ್ಲಮ್ ಆಗಿದೆ ಹೇಳಿ?
Problem, on 31/1/2025, a resolution was passed appointing the committee of management to the temple. Subsequently, an application was received from the fourth respondent, and he was designated as a trustee. But as a matter of fact, as on the date of resolution, there was no application.
Who are you?
Earlier application.
Who are you?
One of the applicant, I am the one of the applicant, Annexure C, is
ಈಗ now the committee is appointed.
Now the committee is appointed, charge is not handed over by the administrator,
That we don't know.
It is not taken.
Secure instructions. The learned AGA act to accept notice for the respondents to the respondent 1 and 1 to 3. Secure instructions as to whether the administrator has handed over charge to the newly appointed committee or otherwise. Day after tomorrow in the fresh matters list.
Tomorrow, at least.
No, sir. Day after. Handed over as on today. Anta haki.
Please.
Next.
10, Harish Bandari.
Except for the petitioner herein, also, this is a tender matter wherein the petitioner herein is a successful bidder, but respondent number 4, we have ಅವರನ್ನು select ಮಾಡ್ತಾರೆ. We have given objections as per Annexure G, stating that the respondent number 4 has not quoted the GST, which is inclusive of the 3% amount as per the bid terms. We have given objections. They have, without considering our objections, Annexure A has been issued as against us, rejecting our bid.
You are the highest bidder? Oh, sorry, L1.
Yes, Lordship.
Lowest bidder, yes. Learned AGA is directed to accept notice for respondent 1, 2, 3.
4 is a
1, 2, 3, emergent notice to the fourth respondent was served by way of hand summons, 2nd April, status quo till the next date of hearing.
great.
Next.
11, Sangamesh Narvi.
Yes, Sangesh.
This is, I'm only seeking for a mandamus, notes.
For what, sir?
Several matters I have.
Mandamus ಏನಕ್ಕೆ 2:30 move ಮಾಡಿದ್ರಿ?
I have only sought because tomorrow they are opening one more tender.
One more tender?
I mean to say, Lord, there are several tenders that are issued by them, one after the other.
And let him seek
without following
instruction.
the Standard tender document.
That will seek.
I'm only seeking for this, Lords. Any interim order, I'm only seeking for.
Interim order ಏನಕ್ಕೆ?
Let them follow the tender, standard tender document is all that I'm.
General direction by way of direction by way of interim order will not grant.
Lords, may I make one submission? Lords, one memo I am filing along with one tender, Lords. In respect of this, at least, because tomorrow they are opening this tender again.
ಏನು ಮಾಡಕ್ಕ?
Lords, I have filed about 5-6
Yes,
matters.
government, look into it. What is it? ಎಲ್ಲ ಟೆಂಡರ್ಲು problem.
Our
That's why I said, see the petitions, you have become the biggest litigant.
Lords, eligibility criteria, they are fixing below, Lords. 1,200 dia is the one which is required to be executed work in this memo. And they call it for 600 dia. Lords, they want to
Even
create.
50% off.
Kindly see this, Lords.
ಆಯ್ತು ಕೊಡಿ ನೋಡಿ. Let's day after tomorrow, fresh matters.
May I submit this memo? It can be.
ಕೊಡಿ, take it into the file. Yes, next.
It's interim order, let them, Lords, follow the
Interim order.
standard procedure.
ಅದು interim order ಕೊಡಕ್ಕಾಗತ್ತಾ ಹಂಗೆ? By way of interim order, it's directed that they will follow the standard document.
And only again second respondent
No,
because
sir.
about 6 matters I filed.
So what if you file 100 matters also interim order ಕೊಡಕ್ಕಾಗತ್ತಾ ಅದು? See, you don't come, 1 minute, sir. You don't, court ಮಾತು ಸ್ವಲ್ಪ ಕೇಳ್ತೀರಾ ಇಲ್ವಾ? ಹೇಳ್ತಾನೆ ಇದ್ದೀರಾ. ನಾಳೆ ಟೆಂಡರ್ ಓಪನಿಂಗ್ ಅಂತ ಇವತ್ತು ಬಂದ್ಬಿಟ್ಟು ಗಲಾಟೆ ಮಾಡ್ತೀರಾ. ಒಂದು ವಾರ ಮುಂಚೆ ಹಾಕಕ್ಕೆ ಏನಾಗಿತ್ತು? ಅವ್ರು ನಿಮ್ಮ ಹತ್ರ ಬಂದಿದ್ದು ನಿನ್ನೆ ರಾತ್ರಿ. ಮತ್ತೆ
5 days.
ಸುಮ್ಮನೆ ಇರಿ ಸಾಕು. Yes.
Day after tomorrow.
Yes.
Fresh matters I'm speaking.
Yes.
Pleasure.
12,
Challenging the vacate notice, my lordship. Respondent filed, my lordship, under section 14 of Substance Act, my lordship.
ಎಷ್ಟಿದೆ?
80,94,457.
ಯಾವ ಬ್ಯಾಂಕ್ ಇದು?
Bajaj Fine.
ಬಜಾಜ್ ಫೈನಾನ್ಸ್. ಫ್ರಾನ್ಸಿಸ್
ಇಲ್ಲ.
Emergent notice to the respondent 10-10-44. Next.
13,
Lord,
Lords, this is counsel on behalf of the petitioner, my lords. I have filed a writ challenging or setting aside the possession notice dated 7/3/2025. Even though the loan account is regular, I have provided annexures B to D.
Bank of Maharashtra, here, madam.
My lords, till February, we have paid it regularly, my lords.
9,17,000.
10,17,000 was is the
Counsel
outstanding amount.
Srimati Divya Purandar is directed to accept notice for the respondent.
Even
Will you wait, please? For the respondent, petitioner to serve set of papers upon the aforesaid counsel. List the matter on 3rd April in the fresh matters list. There shall be an interim order of stay spread for till the next date of hearing. ಸ್ವಲ್ಪ ತಾಳ್ಮೆ ಇದೆ.
One humble submission.
ಇನ್ನೇನು?
They have also freezed the loan account recently.
ಅದಾದ್ಮೇಲೆ. One by one, yes. Next.
Order for 14.
Raju. Passport. ಏನು?
Adverse report police filed that my lord case is.
ಚಾರ್ಜ್ ಶೀಟ್ ಪೆಂಡಿಂಗ್ ಇದೆಯಾ?
Case is pending, stay ಆಗಿದೆ sir.
ಸ್ಟೇ ಯಾವ ಸ್ಟೇಜ್ ಅಲ್ಲಿ ಸ್ಟೇ ಆಗಿದೆ?
Charge sheet ಆದ್ಮೇಲೆ.
ಚಾರ್ಜ್ ಶೀಟ್ ಆದ್ಮೇಲೆ ಸ್ಟೇ ಆದ್ರೆ ಏನೂ ಇಲ್ಲ. ಓನ್ಲಿ ಶಾರ್ಟ್ ವ್ಯಾಲಿಡಿಟಿ ಪಾಸ್ಪೋರ್ಟ್. ಎನಿಥಿಂಗ್ ಎಲ್ಸ್? ಕಾಪಿ ಸರ್ವ್ ಮಾಡಿದ್ದಾರೆ ರೇಷ್ಮಾ? ಕಾಪಿ ಸರ್ವ್ ಮಾಡಿದ್ದಾರೆ ನಿಮಗೆ?
ಮಾಡಿದೆ sir.
I received, my lords, on WhatsApp today.
ಕಾಪಿ ಫಿಸಿಕಲ್ ಕಾಪಿ ಕೊಡಿ ಒಂದು. ಲಿಸ್ಟ್ ದ ಮ್ಯಾಟರ್ ಡೇ ಆಫ್ ಎಲ್ಲಿಗೆ ಹೋಗ್ಬೇಕು ನೀವು? ಮಸ್ಕೆಟ್ಗ. ಶಾರ್ಟ್ ವ್ಯಾಲಿಡಿಟಿ ಪಾಸ್ಪೋರ್ಟ್ ಓನ್ಲಿ. That is on, we'll take it on Wednesday, fresh matters.
Please, my lords.
Serve a copy. Petitioner to serve set of papers upon Reshma Tammaya appearing, Reshma Tammaya hyphen CGC forthwith. List on day after tomorrow. Yes.
Obliged, my lords.
Next.
Sorry.
Auction notice. 28,07,000 sounds. 10,10,44. Yes, next. Suyog. Pending matter ಯಾಕೆ ಮೂವ್ ಮಾಡಿದ್ರಿ?
This is the matter where your lordship has directed the case to be posted on 18 Saturday. Your lordship's thing was not there. Tomorrow is the
ಅವತ್ತು ಪೋಸ್ಟ್ ಆಗ್ಲಿಲ್ವಾ?
Pardon, my lord.
ಬೇರೆ ಕೋರ್ಟ್ ಬಂದು ಪೋಸ್ಟ್ ಆಗಿಲ್ಲ?
Post ಆಗಿಲ್ಲ.
ಆಗಿಲ್ಲ ಮೇಡಮ್?
Post ಆಗಿಲ್ಲ.
ಮಾಡ್ಲಿಲ್ವಾ?
Post ಆಗಿಲ್ಲ. Tomorrow may pass it on. Tomorrow is the annual festival for 2 days.
ಈಗ ಏನ್ ಮಾಡೋದು?
The thing is, it has to be rotated back in favor of the previous trustee, my lord, which the executive officer has falsely, my lord, given the charge in favor of the other
ಅವೆಲ್ಲ ಆಗಲ್ಲ. Tomorrow will take it. Yes.
My lord, tomorrow is the festival start from 5 AM.
List tomorrow. You should have moved. 1 minute, sir. You should have moved the court on Saturday.
Saturday, my lord, I thought that it will be listed before this court, my lord.
When it is not listed, should not have moved.
My lord, for other court, it is not possible.
ಮೇಡಮ್ ನಾನು ಅಲ್ಲ ಮೇಡಮ್, ಸ್ಯಾಟರ್ಡೇ ಡೇಟ್ ಕೊಟ್ಟಿತ್ತ? ಮತ್ತೆ
ಸಾಟರ್ಡೆ ಬರ್ಲಿಲ್ಲ ಅಂತ ಹೇಳ್ತೀನಿ. ನಾಳೆ
ಡೇಟ್ ಕೊಟ್ಟಿತ್ತ?
ಸಾಟರ್ಡೆ ನನಗೆ ಡೇಟ್ ಕೊಟ್ಟು ನನ್ಗೆ ಗೊತ್ತಾಗಲ್ಲ, ಯಾಕಂದ್ರೆ ಸಿಟ್ಟಿಂಗ್ ಇರಲಿಲ್ವಲ್ಲ, ಹಾಗಾಗಿ
you should have moved it before the other court on Saturday. As simple as that.
My lord, because tomorrow starts, my lord.
No, now I can't pass any order, sir.
Tomorrow fresh matter.
Government is not aware of what is it tomorrow. Yes.
Tomorrow fresh
list
matters.
tomorrow. Yes.
Fresh matter, my lord.
List tomorrow in the fresh matters list.
Grateful.
Because there is a detailed interim order granted. I will not disturb the interim order.
And also, my lord, there is a direction to the executive officer.
I will not disturb the interim order, sir.
No, there is no interim order granted.
Matenadu?
Your lordship directed the executive officer.
It's a coordinate bench. Not my order.
No, there is no interim order. Then, my lord, after hearing me, your lordship directed the government advocate to, my lord, submit the executive officer.
Look into that and tell
Please,
me.
my lord.
Nale seek instruction anbadi. Seek instructions today itself. Yes. Next. ಏನಿದು ಕರ್ಗಾನ?
ಅಲ್ಲ ಸ್ವಾಮಿ, ಮ್ಯಾಟರ್ ರಿಗಾರ್ಡಿಂಗ್ ಟು ದ ಮೈನರ್ ಟ್ರಾನ್ಸ್ಪೋರ್ಟೇಷನ್ ಆಫ್ ದ ಮೈನರ್ ಮಿನರಲ್ಸ್ ಇವರು ಜಜ್ಮೆಂಟ್ ಕೊಟ್ಟಿದ್ದಾರೆ ಸ್ವಾಮಿ. ಒಂದು
ಇನ್ಫ್ರಕ್ಚಸ್ ಆಗಿದೆಯಾ?
ಇಲ್ಲ ಸ್ವಾಮಿ.
ಮತ್ತೆ ಯಾಕೆ ಮೂವ್ ಮಾಡಿದ್ರೆ?
ಗೋಯಿಂಗ್ ಟು ಬಿ ಇನ್ಫ್ಲಕ್ಚಸ್. 20% of the people have been already paid the violation amount ಇವರು only 30.
ಏನೋ ಕವರ್ಡ್ ಅಂತ ಹೇಳಿದ್ದಾರೆ?
ಇಲ್ಲ ಸ್ವಾಮಿ, ಇಟ್ಸ್ ನಾಟ್ ಎ ಸಿಮಿಲರ್ ಜಜ್ಮೆಂಟ್.
List day after tomorrow. Yes. Next. ಸುಮ್ಮನೆ ಮೂವ್ ಮಾಡಬೇಡಿ. Day after tomorrow in preliminary hearing. Any idea, madam? Yes. Continue the list. List ಮುಗಿತಾ? ಇದು ಅದೊಂದು 4 o'clock ಮ್ಯಾಟ್ರ್ ಇತ್ತಲ್ಲ. ನಾಯಕ್ ಅವ್ರೆ 5 ನಿಮಿಷ ಮುಗಿಸ್ಬಿಡ್ತೀನಿ ಲಿಸ್ಟ್. ಎಸ್.
Order 76.
Sanat Kumar, post immediately after service of notice upon the 4th respondent.
This is Tantri's matter, my lords, the other day matter.
Fourth respondent yaru?
Managing committee, my lord.
It is already represented in the other connected matter.
Which is that connected matter? Keshav Bhatra.
How
Here.
they are already aware of this. Yatra is starting from today, my lords. My duty will be starting from 26.
There is an interim order, my lord, in my favor on the last occasion that has.
For the
My
only
lord, they have
for
not
that
filed any
particular year,
application.
My order.
been given.
Yes.
Yes, my lords.
Ah.
As I had come 40 days late to the court, interim order, though there was a status quo order. given to
25/3/24 my order.
Howದು.
Yes.
Though there was a status quo order in my
But
favor.
ಈಗ ಅವ್ರಿಗೇನ್ ಕೊಡಲ್ವಾ ಪೂಜೆಗೆ?
Allah, I am been appointed. I am doing the respondent number 5. I have been
ನಿಮ್ದು
appointed by
ಯಾವಾಗ
the managing committee.
26th.
ಇಲ್ಲ ಇದಕ್ಕೆ.
Today it has already started. The entire process has begun last.
ಇಂದ start.
List the matter on 26 in the fresh matters list.
My
We'll
duty
see.
will start on 26th, my lord.
We'll see.
Can it be?
The order also will be passed on 26th.
Please.
Next,
77.
in terms of the land counsel of the petitions moved. Withdrawal
It is
memo
for the
ಹಾಕಿದ್ದೀರಾ?
withdrawal, my lordship.
All right, withdrawn. In terms of the memo, yes, 78 and
My lord, it is also same, my lord.
same withdrawn.
My lord.
What is
permission
the other
to
one,
make a
60?
Permission to make a submission, my
Yes,
lord.
sir.
In previous matter, serial number 77, I served the hand summons to the respondent number 1, 2, and 3. Based on interim order, my WP got, my prayer got fulfilled, my lord.
All right.
Based on the interim order. My lord, same has been applied for the 78 also, my lord. This, my humble submission to your lordship is, this submission should make on the record and then withdraw the petition, my lord.
Which that, correct, we'll do it. The learned counsel for the petitioner submits that pursuant to the interim order granted, the grievance of the petitioner has been redressed by defreezing the account. In the light of the said defreezement of the account on the interim order so granted, the learned counsel for the petitioner seeks leave of this court to withdraw the petition. The petition is thus disposed as withdrawn.
I have served the hand summons to the state of.
All right, don't worry. ಅದನ್ನೇನು ರೆಕಾರ್ಡ್ ಮಾಡ್ಬೇಕು?
Yes, my lordship,
Don't
because
worry.
this is the, my lordship, next petition is for the information.
Don't worry, yes. Next ಅಲ್ಲಿ ಒಂದು add ಮಾಡಿ. The learned counsel for the petitioner has served the respondent by way of hands. Oh, Gujarat.
Yes, my lordship.
Oh, by way of hand
My lord,
summons.
Ahmedabad and then Surat I have served for the.
That's all, that's all. Yes. so
Yes,
and
my
so.
lord.
I have not ordered notice to all these.
No, previous occasion we
yes,
have
yes.
taken. Same thing similar to the serial number
64.
78. 77
same
and
order.
78 I have served.
Same orders.
Yes, my lord.
Yes. Sir.
Yes, my lord. Serial number 63 is next.
ಅದರಲ್ಲೂ ಸೇಮ್ ಎಂಟ್ರಿ ಮಾಡರ್ ಕೊಟ್ಬೇಡ. Francis, ಎಷ್ಟಿದೆ?
50,000 ರೂಪಾಯಿ disputed.
Will permit defreezing. The petitioner is before this court seeking the following prayer. The heard so and so. The petitioner holds an account in the respondent's bank idu? In the respondent HDFC bank. It transpires that the state of Punjab communicates to the bank to freeze the account of the petitioner on account of a transaction of rupees 50,000 being suspicious. Therefore, following the dictate of the state of Punjab, the bank has freezed the account of the petitioner. It is therefore the petitioner is before this court in the subject petition. The learned counsel for the petitioner submits that the entire account cannot be frozen for a suspicious transaction of rupees 50,000. The learned counsel for the respondent bank submits that the amount that is involved in the suspected transaction is only 50,000. Therefore, I deem it appropriate to direct marking of a lien of rupees 50,000 upon the account of the petitioner and permit the regular operation of the account of the petitioner as it was being operated prior to the order directing freezing. The aforesaid observations, the petition stands dismissed.
My lordship, my humble submission. My lordship, I made the party of this state. I've been presented the amendment petition also, my lord.
No problem.
My lord, my lord, 1 minute, my humble submission, my lordship. My lordship, this is the matter with, in state of Karnataka, we will not get our account being freezed. The reason is, my lord, the learned commissioner of the Bangalore City Police
We
has
will
given the.
answer larger questions in a different.
Lordship, this is the remedy I'm seeking, being a court officer. My
1
lordship.
minute, sir. ಈಗ 50,000 ಲೀನ್ ಮಾರ್ಕ್ ಮಾಡಿ permitted operation of the account. You don't want that order?
My lordship, that is the, my humble submission, my lord. I am bringing the one document to
Don't
the
bring any,
lordship.
there is no time to consider other
This is
things
100
here.
writ petitions going to be saved to file before this honorable court, my lord. This is the only one document, my lord.
Yes. Hmm.
My lord, the learned Bangalore City Commissioner of Police has clearly instructed to freezing of the accounts, how the accounts has to be freezed. My lord, if it should apply across Karnataka, my lord, across India, minimum 100 WPs is going to be not to filed.
Sir, I am only interested in Karnataka High Courts.
Yes, my lordship, that is what I'm.
Across India, 100 petitions, I am not interested.
My lordship, in this case, then across Karnataka, minimum 451, 457 application, minimum 1,000 will not going to be filed.
We'll see.
East,
Yes.
west, south, north, northeast,
Rahul,
there are
what is
10
this?
police stations. This is the
Now
certified
you permit
circular.
operating this account. I will take this on Friday. Secure instructions with regard to this. We'll pass some order. Friday, fresh
Much
matters.
obliged.
Yes. ಅದೇನ್ ಕೊಡಿ ರಾಹುಲ್ ಕೊಡಿದ್ ಮೇಡಮ್ ಕಾಪಿ ಸರ್ವ್ ಮಾಡಿ ಅವ್ರಿಗೆ
We have already served. We already served. This one
ನಿಮಗೆ ಅಲ್ಲ ಸರ್ ಅವ್ರಿಗೇನ್ ಅವ್ರು
I will serve it, my
ಕಮಿಷನರ್
lord.
ಇಶ್ಯೂ ಮಾಡಿದ್ವು ಝೇವಿಯರ್ ತಗೊಂಡು ಏನ್
Sir,
ಮಾಡ್ತಾರೆ
my- That is certified copy. I will-
ಎಸ್ ಎಸ್ ನೆಕ್ಸ್ಟ್
Much obliged.
ಇಲ್ಲ ಫ್ರೈಡೆ ಲಿಸ್ಟ್ ಅದು ಡೈರೆಕ್ಷನ್ ಹಂಗೆ ಇರಲಿ ಲಿಸ್ಟ್ ದ ಮ್ಯಾಟರ್ ಆನ್ ಫ್ರೈಡೆ
39.
My lord, I appeal for the petition.
ಎಫ್ ಪಿ ಎಫ್ ಒಂದ್ ವಾರ 2 ವಾರ 3 ವಾರ ಎಷ್ಟು ಇರಬೇಕು ನೋ ಮೆರಿಟ್ಸ್ ಎಸ್
So
Next.
far as PF to them, my lord, my grief is only against the state.
ಮೇ ಬಿ ಎಸ್
So
ಎಫ್ ಪಿ ಎಫ್ 25912 ಪಾರ್ಟಿ ಯಾಕೆ ಮಾಡಿದ್ರಿ
ಪಾರ್ಟಿ ಮಾಡಿದ್ದೇವೆ.
ಡಿಲೀಟ್ ಮಾಡಿ
Intention,
ಡಿಲೀಟ್ ಮಾಡಿ ಮೆಮೊ ಹಾಕಿ
day after tomorrow.
ಫೈಲ್ ಮೆಮೊ ಲಿಸ್ಟ್ ಡೇ ಆಫ್ಟರ್ ಟುಮಾರೋ
Please.
in preliminary hearing. Next.
80.
Post immediately after service of notice upon response 2 and 3. Interim order subsisting will continue to the next state of hearing. Next. That will continue. Yes, next.
Lordship, parole, my lordship, my mother, my lordship.
All right, sir. Don't worry. The petitioner is before this court seeking, who is the petitioner? Yaru mother?
Petitioner is a prisoner accused.
The petitioner
Represented father.
convict is before this court seeking his release on parole on account of illness of the mother. The petitioner has appended the prison certificate which depicts that the petitioner has now been in prison for 9 years.
Yes.
8 years and 8 months in an offense an offense punishable under section 302 of the IPC. The learned counsel for the petitioner submits that it is the first time he is seeking parole in the last 9.5 years of his imprisonment. The learned AGA on instructions would submit that there is nothing adverse against this petitioner in the prison. Therefore, in that light, I deem it appropriate to grant the petitioner parole for a period of 60 days from
90. Lying condition, my lordship, some paralysis.
60 days first, yes. 60 days to become operational from day after tomorrow.
Please.
Yes, next.
Problem.
Next.
82.
Sections are ready.
Learned Haki. Counsel for the respondent seeks 2 days time to file statement of objections. List on 3rd April.
May one, last case lordship has said, the order on 6/3 law, it shall remain subject to result, stay ಅಂತ ಆಗ್ಬಿಟ್ಟಿದೆ. So lordship declined to extend the stay.
ಅದ್ ನೋಡ್ಬಿಟ್ಟು ಮಾಡ್ತಾರೆ ಯಾರು ಮೇಡಮ್ NVG.
Declined to extend the interim order because of earlier clarification.
Submissions.
Hostel.
Oh, this court on 6/3/2025 had passed the following order. There is certain incongruity with the reason rendered and the last line of the order. Therefore, whatever is, therefore, the order, the aforesaid order, in the aforesaid order, the words, however, the work order so issued shall remain stayed, shall be read as the work order so issued shall remain subject to the result of the petition. Yes. List after 2 weeks ಅಂತ ಮಾಡಿ ಡೇಟ್ ಕೊಡ್ಬೇಡಿ. Next.
83.
Please, for the petitioner, my lords, the office objection is in respect of 2 pages of my agreement to sell that is not legible.
What is the urgency? There is no urgency 1st April.
My lords may list it in the issue notice and list it. I filed it in the end of Jan, my lords. The
Wait, madam.
order of the RERAs passed in my favor November of 2023.
RERA order. Why are you here against the RERA order?
Certificate is issued in June of
Why are you
2024.
here against the RERA order?
Please, I'm here seeking that they be directed to enforce their order and execute their own order, despite the revenue recovery certificate
We'll
in
see
June
there, please.
24.
Learned HCGP is directed to accept notice for the respondent office objections overruled. 1 and 2. Office objections overruled. List the matter on 15th April. Yes,
Please.
next.
84th,
Non-compliant.
BC.
Huh?
Beneficiary capital contribution.
BCC. BWS is covered, closed, yes.
85,
Madhu and Rao.
I appear for the petition.
Yes, Madhu. What is this?
Office objection pertains to.
ಆಯ್ತು ಏನ್ ಅರ್ಜೆನ್ಸಿ ಇದೆಯಾ?
Urgency ಇದೆ.
ಏನಿದೆ?
ಏನಾಗಿದೆ annexure C ಅಲ್ಲಿ.
Wait, ನಿಮಗೆ ಇರೋದೇ ಇಲ್ಲ ಅರ್ಜೆನ್ಸಿ ಅವ್ರಿಗೆ ಹೇಳಿ wait, yes.
Annexure C, my lords, they placed me under denied entity list. Without,
Wait, sir, is it saying something?
my lords, contrary to the guidelines that has been issued by.
What are you challenging, sir?
I'm challenging annexure A and annexure C. Annexure A is with respect to order and original passed by the respondents, my lords.
All right.
Annexure C is where they have put me in denied entity list, where they have stopped my import and export. As my lords, if my lords may peruse annexure C at page 26. They just
No notice was issued to you?
No, my lords.
How can you put him in denied entity list without notice?
For the shoot, he is.
My
Where,
lords,
where are they?
show cause notice is issued after the denied entity list.
What is the date of the list?
My
Date of the
lords,
name?
It is 15 July 2021. At
Where is
page
the notice?
26. Notice, my lords, is at page 22. The date is 9th September 2021, which is subsequent to putting me in denied entity list.
Lord, it is issued in the year 2021. I mean, permitted to file objections in 4 weeks' time.
My lords, my
4 weeks.
But not, at least, my lord.
my lords, my
Because-
goods worth 1 crore to.
ಈಗ ಏನ್ ಮಾಡಕ 4 ವರ್ಷದಿಂದ ಇಲ್ವಾ ಅಲ್ಲಿ?
ಇಲ್ಲ, my lords, ಅದು
ಮತ್ತೆ?
I
4 ವರ್ಷದಿಂದ ಸುಮ್ಮನೆ ಇದು ಈಗ ಅರ್ಜೆನ್ಸಿ.
ಇಲ್ಲ, my lords, ಅದು goods.
Wait, sir. Yes. Learned Council, CGC, na?
ಹೌದು.
Learned CGC is the seeks 2 weeks time to, Ajay Prabhu seeks 2 weeks time to file statement of objections. List the matter on 17th April.
My lords, a date may be given. ಇಲ್ಲ,
17th April is not a date. Yes, sir.
Much.
Respondent,
I'm the petitioner in this case, my lord.
Worship, about 86 lakhs is due, and for the fifth time.
Not maintainable before this bench, my lord, may have to go before Dharwad.
ಯಾಕೆ?
Because notice issued by the deputy commissioner Bagalkote.
ಅಲ್ಲ ಇವ್ರು ಇರೋದು ಎಲ್ಲಿ?
86.
ಇವ್ರು ಇರೋದು ಬೆಂಗಳೂರು.
Sorry.
ಇದು ಯಾವ್ದು?
Sorry, bro.
ಸರ್ಫೇಸಿ.
Like that.
And why did the deputy commissioner?
About, this is the 5th time the account is falling into NPA, lordship. The petitioner,
ಎಷ್ಟಿದೆ?
86 lakhs is due. ಅವ್ರಿಗೆ
My lord, can you
they are
just
not in a,
Kindly-
they're not in a
kindly see on
position to
annexure 8, my lord. We
restructure
have
it.
already cleared on 20th of.
ಆಯ್ತು ಈಗ ಈಗ ಯಾವಾಗ ಕೊಡ್ತೀರಾ?
OD ಏನಿದೆ ಅದನ್ನ we will clear with.
ಓಡಿ ಕ್ಲಿಯರ್ ಮಾಡ್ಬೇಕು, ಅದ್ರಲ್ಲೇನು ಇನ್ಸ್ಟಾಲ್ಮೆಂಟ್ ಕೊಡಕ್ಕಾಗಲ್ಲ.
No, that we will clear before May end, my lord. And
Three
remaining we
accounts
will
are- are-
pay it in the regular course, my lord.
The 3 accounts are there, lordship. All 3 have fallen due.
One to clear
and,
ಮಾಡಿದೀವಿ, my lord, on
and
20th of February.
All
we
5
have
accounts
cleared
have
already.
been
ಆಯ್ತು.
restructured for
List
the
on
5th
list
time.
on first in the fresh matters.
My lord, we are giving one DD of 3 lakhs.
ಅಲ್ಲಿ
now.
ಬ್ಯಾಂಕ್ ಕೊಡಿ. Yes. First in the fresh matters list. Next.
Lord, it is stay may be granted.
What stay? ಏನು ಮಾಡಲ್ಲ, ಫಸ್ಟ್ ಅವ್ರಿಗೆ ಕೊಟ್ಬಿಡಿ ಡಿ ನ. You give the DD.
Every day they are coming and they are posting the notice on the board.
Don't do that.
And they have senior citizen at home.
ಎಷ್ಟು ಪರವಾಗಿಲ್ಲ. ಎಷ್ಟಿದೆ DD ಎಷ್ಟದು?
DD 3 lakhs ಇದೆ, my lord.
ಅಮೌಂಟ್ ಎಷ್ಟು? 86 ಲಕ್ಷ.
ಅಲ್ಲ, OD ಏನಿದೆ ಅದನ್ನ ಕ್ಲಿಯರ್ ಮಾಡ್ಬಿಟ್ಟು remaining we will pay it in the.
That
regular-
you sit with the bank and discuss.
We
but
we
don't-
went and we approached also. my
Don't
lord, they are
precipitate it. Yes.
Kindly, my lord.
Waste ಮಾಡೋದು ಅವೆಲ್ಲ ಮಾಡಬೇಡಿ.
Like, we have taken physical possession of the property.
Within
As per the
I don't
magistrate
expect ಹೇಳಿದ್ದಾರೆ, otherwise,
court's
List
order.
list the matter on 1st April in the fresh matters list. Next, yes.
This matter, my lord, notice issued by the deputy commissioner Bagalkote for the cane year 2024-25 bills pending. Matter may have to be heard before the.
ಇದು ಬಾಗಲಕೋಟ್, ಧಾರವಾಡ district.
Uh,
ಧಾರವಾಡ court.
ಇದು ಏನ್ ಕಮಿಷನರ್ ಇರೋದು ಬ್ಯಾಂಗ್ಳೂರಲ್ಲಿ ಸ್ವಾಮಿ.
ನೀವಿರೋದ್ ಬಾಗಲಕೋಟೆ.
It's a recovery certificate. So
My lords, we have challenged this thing, demand notice issued by the Kane Commissioner, my lords.
not deputy commissioner.
ಅಲ್ಲೇ
It
ಮಾಡ್ಬೇಕು.
in Bangalore. My lords, it may be
Part
adjourned,
of cause of action you can always take. That's a different thing.
my lords, it may be adjourned to any day this week. Mr. Ajay Karkol will argue them.
He's not there.
No, he's indisposed today.
Indisposed.
Personally.
All right.
If the lordship
Counsel for the
declared clearly-
petitioner submits that the arguing counsel is indisposed for the day. Let's the matter on Friday. Friday fresh matters. Next.
88.
Lords, I'm appearing for the petitioner in this matter.
ಕಟ್ ಮಾಡಿದೀರಾ ಮಾಡ್ತಾ ಇದೀರಾ ಮಾಡ್ಬೇಕು
ಸರ್ವೇ ಮಿಲ್ಲರ್
ಯಾಕೆ?
ಅಲ್ಲ ಪ್ರಾವಿಷನಲ್ ಆರ್ಡರ್ ಕೊಟ್ಟಿದ್ದಾರೆ ಅದನ್ನ ಚಾಲೆಂಜ್ ಮಾಡಿಲ್ಲ.
My
ಬರೀ
lords,
ಕರೆಂಟ್ ಕನೆಕ್ಷನ್ ಮಾತ್ರ
my
ಕೇಳ್ತಾರೆ.
lords, the provisional order, my lords, they say that has not been served upon the petitioner, my lords. Even the notice that's been
ನೀವು
issued.
ಚಾಲೆಂಜ್ ಮಾಡಿದ್ರೆ ಮಾತ್ರ ಸ್ಟೇ ಕೊಡ್ತೀನಿ. ಅಲ್ಲಿ ಸ್ಟೇಟಸ್ ಇದ್ರೆ ಮಾತ್ರ ಇಲ್ಲಿ ಸ್ಟೇ ಕೊಡೋದು.
My lords, for a moment, kindly take page number 12, my lords. Even the notice that they have issued to the petitioner is issued in a different name, my lords. Krishna Reddy ಅನ್ನೋರು ಕೊಟ್ಟಿದ್ದಾರೆ, but petitioner's name is not reflected in the.
Correct. ನೀವು tenant ನೀವು.
No, my lords, I am the owner of the property. I have also annexed the sale deed. At
Yes,
page,
yes.
my lords, at page 14, my lords, I have annexed the sale deed. I am the owner of the property, my lords. However, the notice has been issued to a different name.
It's a B Khata property.
My lords, even the Kata is
Don't.
annexed at page 26.
ಈಗ you
my
challenge that and come back.
My lords,
Just the matter on 2nd April.
my lords, I might be direct-
ಅಲ್ಲಿ ಏನು ಯಾರು ಇರಲ್ಲ ಅಲ್ಲಿ. Yes.
my lords, the copy might be served upon me, my lords.
Copy serve ಮಾಡಿದ್ರು.
I will provide the.
Yes, list on
R1 and R4.
2nd April. Next. Satish K.
Please, my lord.
ಏನಿದು?
17A, my lord, covered by the.
Entry ಮಾಡ್ರಿ ಇದೆಯಲ್ಲ?
ಇದೆ.
Respondent Lokayukta, my lord.
ಎಲ್ಲಿ BB Patil?
Yes, please, lord. I have to file my objection, my lord.
Learned Counsel BB Patil seeks 2 weeks time to file statement of objections. Objections, if any, by the next date. Interim order subsisting will continue till the next date of hearing. List the matter in B group on 17th.
Please.
Yes, next.
This is a matter, my lord, where CCB had already closed the disputes as civil in nature. R4 thereafter began to illegally harass the petitioner, my lord, in a private dispute that's ongoing before R5 and the petitioner. We've challenged the same, my lord.
Your lordship, here she had given a complaint in the month of November. So a petition
Copy
was
of which was
registered.
not made available to us.
Just a petition was registered and we intimated them. In view of the CCB findings, we will not pursue. That is the.
If that submission is placed.
Learned petitioner is before this court seeking the following prayer. Heard so. The learned AGA on instructions would submit that they are not pursuing the petition so registered against the petitioners 3 months ago, na? 3 months ago, the submission is placed on record. Therefore, in the light of the said submission, it is needless to observe that the police would not harass the petitioners on any account. In the light of the aforesaid circumstance, the petition stands disposed.
Of the CCB report.
In view of the CCB report, in view of the CCB report, the petitioners, the respondent police shall not harass the petitioners on any account.
It's available in Annexure H, my lord. That's it.
Within bracket Annexure H. Yes, next.
Grateful, my lord.
The Karbati Muxman.
A group matter 91.
Work with respect to 2021, my lord, then a huge amount is due. Lakshmi kindly 25 crores. And in fact, they are not paid. My representation, your Lakshmi.
I'll give instruction, lordship. I'll verify the statement which they have filed.
Learned counsel for the respondent to secure instructions and produce the payments made to the petitioners till today. As the allegation is, the last 8 years, the payments that are legally due are not paid. List the matter on 15th April in preliminary hearing. Next. B group, sorry, yes. 16th April.
92.
My lords,
Yes.
petitioner challenged the KPID proceedings, my lords. Initially, attachment was made and that came to be cancelled. Stays there, my lord.
Greenbirds Agro.
List the matter of 2 weeks interim order granted earlier stands extended to the next date of hearing. Next.
Please.
93.
Then compassionate.
GM periods.
Hmm.
Okay, I appear for petitioner, my lord.
Hmm.
And petitioner father was actually issued with a license to distribute the essential commodities
Hmm.
in 1986 to 87.
Hmm.
Then it was given to his daughter, that is the petitioner,
Hmm.
in 1992.
Hmm.
The KES PDS control order came into force in the year 1992, wherein they have given the order where we have to renew the license in every 3 years.
500 ration cards illa anta. Yes, list heard the learned counsel so and so at the request of the learned HCGP, list the matter on Friday. Yes, next.
94.
Paying for responsible bank.
Oh, for the petitioner, my lordship. My lordship, as per the interim order, we have complied with the.
Complied.
Counsel for the
They
respondent.
paid 1.5.
Respondent submits that the interim order has been complied with. The compliance with the interim order would not mean that the petitioners would not continue to pay the equal monthly installments. In the event they would falter, it is open for the bank to take appropriate action in accordance with law. Close ಮಾಡಿದ್ನಾ?
ಅದು 1.5 lakh ಕಟ್ಟಿದ್ರೆ account become regular as well.
The learned counsel for the respondent submits if
They are
another
like 2 weeks.
1.5 lakhs is paid, the account would become regular.
My lordship, as per our
So
statement,
regular.
there
In
is
the,
a one.
in the light of the aforesaid circumstance, the petition stands disposed, reserving liberty to the petitioner to knock at the doors of the appropriate fora in the event of need, ordered accordingly. Next. Parola.
Life comment premature release committee, madam.
So your lordship here,
Petitioner having served 19 years, 7 months.
List the matter on Thursday in the fresh matters list. Next. Idu adena Pradeep? Same order.
Deeply obliged, grateful.
This is a fresh
Settlement.
matter, I think it's listed for reporting settlement. It's coming up for the first time, I don't know.
Okay.
Your lordship,
Yes,
listed
list
for
the matter in the fresh matters list day after tomorrow.
preliminary hearing.
Move matter the settlement.
ಅಲ್ಲ ನಾವು ಮೂವ್ ಮಾಡಿಲ್ಲ
Cooperative society ತಾನೆ? ಇಲ್ಲ ಇದು ಯಾರು ಬೇರೆ petition. Number ಬೇರೆ ಹಾಕಿ. Sorry.
Day after, preliminary hearing.
List day after tomorrow in the fresh matters list. Yes, next.
98, great time to file objection to the.
Wait.
Open hearing 98.
ಅಲ್ಲ one ನಿಮಿಷ. 98 madam.
Relaxation of condition.
No, we'll finish that part heard matter. Further hearing ಆಮೇಲೆ ತಗೋಣ. ಇದು ಅಬ್ಜೆಕ್ಷನ್ ಹಾಕಕ್ ಟೈಮ್ ತಗೊಳ್ಳಿ ಬೇಕಾರೆ ಅಲ್ಲಿ ಸ್ಟೇ ಆಗಿದೆಯಲ್ಲ
ಆಗಿದೆ ಬಟ್ ಇದರಲ್ಲಿ ಮ್ಯಾಟರ್ ಬಿಟ್ವೀನ್ ದಿ ಕೋರ್ಟ್ ಅಂಡ್ ದಿ ಅಕ್ಯೂಸ್ ಅಷ್ಟೇ ಅವ್ರಿಗೆ ಏನಿರುತ್ತೆ
No, there is some mistake in the order that I have passed. See, I should not have let all the contentions kept open in the operative portion and said it is a full blown trial.
ಇದು ರಿಲ್ಯಾಕ್ಸೇಷನ್ ಆಫ್ ಕಂಡೀಷನ್
ಇದು ರಿಲ್ಯಾಕ್ಸೇಷನ್ ಆಫ್ ಬೇಲ್ ಕಂಡೀಷನ್ ಅಲ್ಲೇ ಮಾಡಿ
ಏನಾಗಿದೆ ಇಷ್ಟೇ
ಅಲ್ಲ ಅಲ್ಲೇ ಮಾಡ್ಲಿ
ಅವ್ರು ಮಾಡ್ಲಿಕ್ಕೆ ಬರೋದಿಲ್ವಲ್ಲ he can't relax, he can only permit.
No, coordinate bench, the regular bench, special court ಅದ್ರ ಮುಂದೆ ಹೋಗ್ಬೇಕು ಅಂತ ಹೇಳ್ತೀರಾ, ನಾಟ್ ದೇರ್.
ಅಲ್ಲ ಯುವರ್ ಲಾರ್ಡ್ಶಿಪ್ಸ್ ಆರ್ಡರ್ ಇಟ್ ಹ್ಯಾಸ್ ಟು ಕಮ್ ಬಿಫೋರ್ ಯುವರ್ ಲಾರ್ಡ್ಶಿಪ್. ನನಗೇನ್ ತೊಂದರೆ ಇಲ್ಲ.
ಅಲ್ಲಿ ಬೇಲ್ ವಿಷಯದಲ್ಲಿ ದಟ್ ಇಸ್ ನೌ ರಿಲ್ಯಾಕ್ಸ್ ವಿತ್ ದಿ ಅಪೆಕ್ಸ್ ಕೋರ್ಟ್.
ಅಲ್ಲಲ್ಲ ಈಗ
ಆಯ್ತು ಅವ್ರು
ನನಗೇನ್ ತೊಂದರೆ ಇಲ್ಲ. ಲೆಟ್ ಇಟ್ ಗೋ ಟು ದಿ ಅದರ್ ಬೆಂಚ್ ಫಾರ್ ಯುವರ್ ಲಾರ್ಡ್ಶಿಪ್.
ಕರೆಕ್ಟ್ ಅಲ್ಲ ಜನರಲಿ ಬಿಕಾಸ್ he is now the special court judge. His lordship is now the special court judge.
May direct the registry to list
the registry to place the matter before the bench having appropriate roster of the special court matters. Urgency idre move ಮಾಡ್ತೀರಾ ಅಲ್ಲೇ? Yes.
Your lordship may give us a date, my lord, directing the registry to list it on particular date.
ಅಲ್ಲ ಅದು
Anytime next week.
ಮೆಮೊ ಕೊಟ್ಬಿಡಿ ತಗೊಂತಾರೆ.
ಅಲ್ಲ anytime during next week.
The learned senior counsel Rajesh pleads urgency in the matter. Therefore, the registry is directed to list the matter on the days on which the honorable court would take up the matters concerning special court matters. Yes, next.
89.
Yes. This case appear to petitioner.
We'll see. This ready or you have to come here. You can't appear on.
I'll come also.
Yes.
2:30 p.m. 2:30 p.m.
Come on 16th April at 2:30. Yes.
17th August.
Alala,
70
100,
Lordship.
100. 100.
Appear for
My
respondent.
lord, appear for the petitioner.
100, there
Seal
is
number.
some dereliction on the part of the registry. I want to pass an order and then I'll place it before the regular court.
Please.
Yes.
Please, please, my lord, interim order earlier granted may kindly be extended.
Interim order idare continue ಆಗುತ್ತೆ. Yes.
Please, grateful. Great.
101.
For the petitioner counsel.
My lord, 100, if I may make a submission.
ಇದೇನು ಲೆಟರ್ ಏನ್
No, no, not on merits, not on merits.
ಒಂದು
my
ನಿಮಿಷ
lord.
ಸರ್, ನಿಮ್ದು ಆಯ್ತು, ವೇಟ್.
Sorry, Mila.
Please.
Yes. Why have you communicated the file was lost and other things?
I have not, Mila.
Codil file. Give the letter to him.
No, my lord, I'm not aware of it. Mila.
ಇದೆಲ್ಲ madam. It was recalled and it was directed that it will be reheard, correct?
It was disposed of, my lord. It was
I
heard.
know that 52A.
52A as well as Tufan Singh, my lord. Paritosh
Correct.
was relied upon.
Correct.
And on the basis of Paritosha, the request was that, my lord.
That's all right. Now
Yes.
I had heard it completely, but there was some communication sent. Anyway, we'll tell. Heard reserve. Yes.
Yes.
Now we'll reserve it and pass.
Yes, yes.
Kindly. Serial number 49, 49.1 and 49.2. If there are time constraints today, it may be had on 1st April.
1st April we'll have it.
The petitioners are also here. I am for the respondent.
ಎಲ್ಲ ಮೂರು ಅವತ್ತೇ ಮಾಡ್ತೀವಿ. ಅವತ್ತೇ ಮಾಡ್ತೀವಿ. ಇದು ರಿಜಿಸ್ಟ್ರಿಲಿ ಹಾಕ್ಬಿಡಿ. Yes. It will come list on 2nd April. Yes.
Please.
Madam, it is not before me. Okay. Not before me. Yes. ಕರೆದು ಬಿಡಿ ಹೇಳ್ತೀನಿ.
All
Madam,
three
3 ಇಂದ
matters-
ಕರೀರಿ, 102 ಕರಿಬೇಡಿ.
all three matters on 2nd April.
Yes.
Please.
Lordships, I appear for the petitioner, my lordships,
Ah.
seek a week's time for compliance with the office
Yes,
objection.
5th time, 6th time.
Lordships, within 1 week, we will comply with the office objection.
Finally, a week's time is granted, failing which the petition would stand dismissed without hearing any submission of the petitioners. Next,
Obligement.
same order. ಎಲ್ಲ ಸೇಮ್ ಆರ್ಡರ್ ಮಾಡ್ಬಿಡಿ, ಒಬ್ರಿಗೆ ಒಂದೊಂದು ಯಾಕೆ. Up to 111 ಸೇಮ್ ಆರ್ಡರ್.
Not 9.
ವಿಡ್ರಾ ಮಾಡ್ತೀರಾ? 109 withdrawn in terms of the memo.
Make a submission, my lords. Detail number 51, my lords.
ಫ್ರೀಸಿಂಗ್ ತಾನೆ, ಏನ್ ಅರ್ಜೆನ್ಸಿ?
His credit card.
ಎಷ್ಟಿದೆ?
25,000, my lords.
25,000.
1,000.
I'll pass that order. Wait.
Okay.
Yes. ಕರೆದು ಬಿಡಿ 230.
Copy for the petition. Matter pertains to ozone urbana matter, my lord. Companion petition, already there's an interim order.
Number, tag the petition so and so, same order. Divide. Yes.
Mentioned both, there are several petitions, not main petition.
One code. Next. Lakshmikant. ಅಲ್ಲ ಸಾರಿ ಲಕ್ಷ್ಮೀಕಾಂತ್ ಅಲ್ಲ, ಏನದು ಇಲ್ಲಿದೆ ಮೇಡಮ್ ಲಿಸ್ಟ್.
Demand notice of 3 lakhs melos from Chescom.
ದಿವ್ಯ ತೇಜ್, ಯು ಆರ್ ದಿವ್ಯ ತೇಜ್.
It's my colleague melos.
ಹಾ, ಎಷ್ಟಿದೆ?
2 lakhs.
ಏನ್ ಬೆಸ್ಕಾಮ್?
Chescom.
ಡ್ಯೂ ಇದೆಯಾ ಅಷ್ಟೊಂದು? 2 ಲಕ್ಷ ಇದೆಯಾ?
Fine amount.
ಫೈನಾ? ಡೆಪಾಸಿಟ್ ಮಾಡಿ 50%.
There is exams for the daughters melos. They have disconnected.
25% ಡೆಪಾಸಿಟ್ ಮಾಡಿ.
ಅಲ್ಲ.
The petitioner shall there shall be an interim order of stay as spread for subject to the condition that the petitioner would deposit 25,000 out of the amount that is demanded, i.e. 2 lakhs.
For restoration, disconnect ಮಾಡಿ.
In the if the deposit is made with the KUB, at any time from today, the electricity connection shall be restored in favor of the petitioner, which will remain subject to the result of the. Next.
The point for your lordship, kind consideration, my lord. I am so far the new of the pre-bid meeting, the certain queries are raised. Your Lakshmi, so far the technical bid I qualified. For the financial bid, I quoted in as per the tender document, only it relates square meters. So Lakshmi, I appreciate. Now, pre-bid meeting, there is the lump sum amount that's cited. Now, even otherwise, whatever I quoted in a pre-bid meeting as per the, what I quoted is 46.63. If it is converted into as per the evaluation, it comes to I am in the L1. Only my limited purpose is, Your Lakshmi, direct them to consider my representation after the financial bid is open now and decide the evaluated tender. That's all. That is.
Lordship.
Other two are in all these crises arises. Other two are the quoted in lump sum. That is later it was correction was made and it was in your may request, my lord, page. Your Lakshmi, kindly the corrigendum was issued. That is on 104. Your Lakshmi, it's a lump sum and format attached shall be considered while quoting the tender. Earlier, my lord, I quoted as per the tender document only. In that is at page 55.
ಏನ್ ಬೇಕು ಸರ್?
Rates quoted per square meter per month.
ಏನ್ ಬೇಕು?
Nanigenill only thing, let them consider my request for the annexure E.
ಏನ್ ರಿಕ್ವೆಸ್ಟ್?
That is request to consider square meter into a
Consider square meter.
Square meter I submitted.
Square meter you have
Your
submitted.
annexure F E may be.
ಒಂದ್ ನಿಮಿಷ ಯಾವ್ದ್ರ ಸ್ಕ್ವೇರ್ ಮೀಟರ್?
They have just served the copy.
ನಿಮ್ದು ಹೊಸ. Yes.
Kindly have it.
We are served on Malipatil and the council on record. Your Lakshmi, just I am not taking more than 1 minute. Annexure E may be.
Day after tomorrow, fresh matters.
The only thing is that we may issue work card. That's all the only.
Subject to result of the petition.
No, if they consider it, they will let me start.
Their representation.
Status quo till.
Square meter.
Even otherwise, emergency L1.
His representation was given when the tender notification was called. He has not given the representation at all.
ಅಂದ್ರೆ ಟೆಂಡರ್ ಕೊಟ್ಟಿಲ್ವಾ?
Representation ಕೊಟ್ಟಿಲ್ಲ.
ಯಾವ್ದಕ್ಕೆ representation?
ಕೊಟ್ಟಿದ್ದೀವಿ annexure E. Kindly see page 120.
420?
120.
ಅದೀಗಿಲ್ಲ ಬಿಡಿ. BNS ಬಂದ್ಮೇಲೆ 420 ವ್ಯಾಲ್ಯೂನೇ ಇಲ್ಲ.
120 annexure E may be kindly. Annexure E ಪ್ರಕಾರ let them look into the document and decide. That's all.
ಅಷ್ಟೇ. Look into the document and decide. We'll take it after 4 weeks. Or look into document.
Let them, in fact, work card issue ಮಾಡಬಾರ್ದು ಅಲ್ಲಿವರೆಗೂ. ಅದ್ ಮಾಡ್ಬಿಟ್ಟು ಏನಾರ
ನೋಡೋ ಡಾಕ್ಯುಮೆಂಟ್ ನೋಡೋವರೆಗೂ ವರ್ಕ್ ಆರ್ಡರ್ ಇಶ್ಯೂ ಮಾಡಬೇಡಿ.
ಅಷ್ಟೇ. That's all.
I have to go through the papers.
ಅದಕ್ಕೆ ಅದ್ ಮಾಡೋವರೆಗೂ ವರ್ಕ್ ಆರ್ಡರ್ ಇಶ್ಯೂ ಮಾಡಿ.
I have served now. I have not gone through the document only. I am not aware whether a representation was given also.
List
day after tomorrow in the fresh matters list.
Until then, your Lakshmi, status quo regarding that is a decision or so far the bid is concerned.
No.
That's all the only the short request.
No.
If I am L1, then only I will be voting. What otherwise?
In the event the petitioner is L1.
Exactly.
Work order shall not be issued to anyone else till day after.
No, I have not seen the paper.
In the event.
Yes, exactly.
You know how to take advantage of this order.
In the event.
Yes, next. ಅದನ್ನು ಹೇಳ್ಬೇಕು. ಅವ್ರು ನಿಜವಾಗ್ಲೂ L1 ಇದ್ರು ಹೋಯ್ತು ಈಗ. Yes.
89 lakhs.
ಏನ್ ರಾಜು?
Residential property ಮೇಲೆ
ಎಷ್ಟುಂಟು?
89 ಲಕ್ಷ ಇದೆ.
ಅಷ್ಟೊಂದ?
ಅಲ್ಲ, residential property ಅಲ್ಲ.
10-10-3-3-4-4. Yes.
3 months at least. One of the member is suffering cancer. He invested.
4 ವಾರ 8 ವಾರದಲ್ಲಿ 10% ಹೇಳಿದೀನಿ ಅಷ್ಟೇ. 10 ಲಕ್ಷ ಅಲ್ಲ 10%.
ಅಲ್ಲ, total 10%.
Residential
property.
6 weeks.
Total 10%.
6 weeks ಮಾಡಿ ಸಾಕು. 10 ಇದೆ. ಎಷ್ಟಿದೆ?
Sir, I'm the auction purchaser. I've deposited 25% of the amount which amount.
Forfeit ಮಾಡ್ತಾ ಇದ್ದಾರೆ ಈಗ?
They want to forfeit. There's a litigation before the
Respondent. Pegasus ಯಾರ appear ಆಗ್ತಾರೆ? Emergent notice to the Francis Xavier is directed to accept notice for the respondent petitioner to serve set of papers upon the aforesaid council. List the matter on 4th April in the fresh matters list. There shall be an interim order of stay till the next date. Yes. ಎಲ್ಲಿದೆ? ಸೇಲ? E-auction notice, 30 lakhs. 10, 35 lakhs, 10, 10, 3, 3. Next. Action, huh? ಸ್ಟೇ ಕೊಟ್ಟಿದ್ದೀವಿ ಸರ್, ನೀವು ಇಲ್ಲದೆ ಇದ್ರು ಕೊಟ್ಟಿದ್ದೀವಿ. ಶಾಪ್ಸ್ ಆಮೇಲೆ ತೊಂದರೆ ಆಗ್ಬಾರ್ದು ಅವ್ರು ಪೂರ್ ಪೀಪಲ್ಗೆ ಅಂತ ಕೊಟ್ಟಿದ್ದೀವಿ. ಕಾಂತರಾಜ್ ಸರ್ ವೆಯ್ಟ್ ಮಾಡಬೇಡಿ, ಅದು ರಿಸರ್ವ್ ಮಾಡ್ತೀನಿ. ರಿಸರ್ವ್ ಮಾಡಿ ವಿಲ್ ಪಾಸ್ ಆರ್ಡರ್ಸ್. ಐ ಹರ್ಡ್ ಯು ಕಂಪ್ಲೀಟ್ಲಿ. ಅಯ್ಯೋ ಮತ್ತೆ ಪೂರ್ತಿ ಇವತ್ತು ಹಾಕಿ ಡಿಕ್ಟೇಷನ್ಗೆ ಐ ವಿಲ್ ಪಾಸ್ ಆರ್ಡರ್ಸ್.
My lord, I may be permitted to. There are 2 points, my lord, for your.
ಏನ್ ಪಾಯಿಂಟ್? ಹೇಳಿರೋ ಪಾಯಿಂಟ್ ಮತ್ತೆ ಹೇಳ್ಬೇಡಿ.
See, Supreme Court order says, my lord.
Correct. 50 meters.
50 meters or 30 meters.
And peso conditions prakara 30 meters.
Within 50 meters they can't grant.
See, 50 meters is mandatory. It impossible to grant 50 meters and with pesos safety 30 meters.
They will have to be, the deputy commissioner while issuing NOC, they will have to prescribe.
Correct.
What
Yes.
are the measures to be taken, which is not here,
Yes,
present here in this case.
So it's already granted, I produced in my statement of case.
No, that is during, say interim order passed by this honorable court. Blood, and the another petition, blood, I have filed it. Another writ petition, you lost my kind, is connected.
ಗೊತ್ತು 2025.
Blood, his grievance, his blood, this is adjacent to his, house.
Correct.
Residential site. Blood, added to that, one more point, blood, you lost my kind, is PWD, say report is there, so you produce the annexure also. Blood, from the center point of the, state highway, blood, filling point should be within, beyond 40 meters, which is also not complied with. And then second, no, please allow me. And in the second matter, blood, I had no opportunity to file the objections at all. And your lordships have already seen saying that. So with before the expiry of the period to file.
Correct. 2011-2024 was the notice. 30/11/2024
Yes,
is the NOC. Correct. File and illa.
Yes. Well, I appreciate your lordship, remember that also.
Yes, sir.
Lord, I know short synopsis I am filing.
ಕೊಡಿ, ಏನ್ ಕೊಡ್ಬೇಕು?
Lord, in fact, my lord, I have obtained all the necessary objections, my lord. This, that time, my lord, 15 days time is not a requirement anywhere. It's not a mandatory, my lord. If
ಕೊಡಿ ಸರ್.
Yes.
ರವಿ, ನೀವು ಏನಾದ್ರು ಇದ್ರೆ ಕೊಡಿ. If you want to file written arguments also, you file.
I'll do it.
But I've heard it at length. I remember everything. Yes.
Please. In connected matter, we are not, there is no notice order, my lord, we are not filing it.
It follows. If I allow the first petition, second petition also will go. That's all.
Great. These are though, there must be conditions. Say, while issuing within, when it comes within 50
ಈಗ
meters.
ನಿಮ್ ಬಂಕ್ ಚೆನ್ನಾಗಿ ನಡೀತಾ ಇದೆಯಾ?
Yes.
ನಿಮ್ ಪೆಟ್ರೋಲ್ ಬಂಕ್ ಚೆನ್ನಾಗಿ ನಡೀತಾ ಇದೆಯಾ?
ನಡೀತಾ ಇದೆ ನಮ್ದು. See, so far as the second petition is concerned, he is not a petrol bunk owner.
Correct.
And then Tahsildar report
He's
specifically.
your neighbor.
Tahsildar report specifically states that there are house sites, so within 50 meters.
38 meters. So it is within 15 meters.
Within 50
Correct.
meters.
38 meters is what the
No
opinion
dispute as to that.
It's a report. 38 meters ಇರೋದು ಅಂತ. The submission is 50 mandatory. Next is 30 with peso
30
specification.
can't be granted at all.
30 can't be granted at all.
Yes.
Can
If
be
you are
granted between 15 and
cannot
30.
be.
50,
50 cannot be,
Kantraj
but
sir.
if you are granting,
50 and 30 ಮಧ್ಯ ಕೊಡ್ಬೇಕು ಅಂದ್ರೆ peso
Conditions
safety
are required.
conditions ಮಾಡಿ
they will have to mention the special circumstances under which they are granting and the conditions that they are imposing,
There is
which is absent in the instant case.
There is a 50 meters.
and all by the rival operator.
Yes.
Blood, right? See, as your lordships rightly observed on the other day, rival operator is not a question. See, ultimately, see, what is the danger that is to be caused is the
That we will
object of
see.
the act.
See, public safety we will never compromise.
Yes, yes.
First, no compromise on public safety. Amal we will answer rival operators
That
claim.
is the basis on which blood these rules have been made.
Yes.
That is the basis.
Heard reserved. Yes. ಎಲ್ಲ ನೆನಪಿದೆ, ಏನ್ ಮರ್ತಿಲ್ಲ.
ಅಲ್ಲ ನೆನಪಿದೆ ತಮ್ಗೆ, ಇದೆ ನಾನು ಹೇಳ್ದೆ ಇರೋದು. See, in the second petition, Lord, they did not give opportunity for me to file objections at all.
ಎರಡು ಒಂದೇನೆ, ಎರಡು ಒಂದೇ ಡೇಟ್. ಎಸ್.
ಅಲ್ಲ, ಒಂದೇ ಡೇಟ್ ಅಲ್ಲ. ಇಲ್ಲಿ, see, he could not file the objections within the time given. 15 days time was there. I don't want to repeat that also.
20/11/30/11.
ಅಲ್ಲ, ಅವ್ರಿಗೆ ನಮಗೆ ಅಬ್ಜೆಕ್ಷನ್ ಹಾಕ್ಲಿಕ್ಕೆ ಅವಕಾಶ ಕೊಟ್ಟಿಲ್ಲ ಅಂತ ಸೆಕೆಂಡ್ ಪಿಟಿಷನ್ ಅಲ್ಲಿ ಇರ್ತಾರೆ. Connected.
Yes. Yes, sir.
If there is anything, Ravi will place.
ರವಿ, ಏನು
Yes.
ಜಡ್ಮೆಂಟ್ಸ್ ಅನ್ನು ಕೊಡಂಗಿದ್ರೆ ಕೊಟ್ಬಿಡಿ. ಇನ್ನೊಂದು 3 days ಅಲ್ಲಿ ಕೊಡಿ. ಇಲ್ಲ ಇದೆ ಗೊತ್ತು. ವಿಘ್ನೇಶ್ ಏನ್ ಮಾಡಿದ್ರಿ?
ನಮ್ಮ ಅಬ್ಜೆಕ್ಷನ್ ರೆಡಿ. only thing is ವೆರಿಫೈಯಿಂಗ್ ಎಫರ್ಟ್ ಬರಬೇಕು.
ರೆಡಿ ಇದ್ರೆ ಕೊಡಿ.
ಅಲ್ಲ, ಅವ್ರಿಗೆ ಕೊಡ್ತೀನಿ. ವೆರಿಫೈಯಿಂಗ್ ಎಫರ್ಟ್ ಬರಬೇಕು. Thursday matter came up on board and Saturday holiday. There it is already on. I'll file it and
Day after tomorrow is that the
I'll-
matter
I'll-
is
Day
before
after.
DRT, day after tomorrow it is coming up. And the
26th
judge, they will
we'll seek an
post it for
adjournment.
judgment.
ನಾಳೆ ಆಗ್ತದೆ.
we'll ensure that we'll seek an adjournment before the DRT on.
My lord, that statement will be
Learned-
recorded.
Learned counsel Vignesh Shetty seeks 2 days time to file statement of objection. Counsel Madhukar Deshpande submits that the matter is before the DRT day after tomorrow, Wednesday
26th.
date haki. Learned counsel Vignesh Shetty undertakes before this court that he would seek adjournment on the said date. List the matter on Friday in the fresh matters list. Saka?
First or second?
ಆಯ್ತು, ಫಸ್ಟ್
Second.
ಸೆಕೆಂಡ್ yes.
I'll survey copy.
ಸೆಕೆಂಡ್
In fact, my lord, Thursday,
Is
Friday
sir-
matter came before the Honorable Apex Court. My lord, they
ಯಾವ್ದ್ರ ಮೇಲೆ?
ಅಲ್ಲ, ಅದು ಅವ್ರು ಯಾವ್ದು ಅಗ್ರೀವ್ ಆಗಿಲ್ಲ ಅಂತ ತೋರಿಸಿದ್ರಲ್ಲ, ಆ ಆರ್ಡರ್ ಮೇಲೆ ಆಲ್ರೆಡಿ ಸುಪ್ರೀಂ ಕೋರ್ಟ್ ಹೋಗ್ಬಿಟ್ಟಿದ್ದಾರೆ.
No, my lord, in fact, the Honorable Court said that.
ಆಯ್ತು
my
ಆಯ್ತು,
lord,
ಐ
we have to go
ರಿಮೆಂಬರ್,
to
ಡೋಂಟ್
civil
ವರಿ.
court.
ಎಸ್
Against that, my lord, in fact, my lord, we have.
ಆಯ್ತು, ಸೆಕೆಂಡ್ ಕೇಳೋಣ ಬಿಡಿ, ಯಾಕೆ
Wait.
ಪೀಸ್ ಮೀಲ್ ಬೇಡ.
Wait.
ಇದ್ಯಾವ್ದು ಮೇಡಮ್? 116, 117 ಅದು ತಗೊಂಬಿಡಿ ನಾಗೇಶ್ ಸರ್. ಅದೊಂದೇ ಬಾಕಿನಾ? 116 ಫಾಸ್ಟ್ ಓವರ್, ಅದು ಆರ್ಡರ್ ಪಾಸ್ ಮಾಡಕ್ಕೆ.
116 is the one where your lordship said.
Huh?
This is that deceased martyr.
ಓ, ಇದು
Defense.
ಒಂದು ನಾಡಿದ್ದು ತಗೊಂತೀನಿ. ಡೇ ಆಫ್ಟರ್ ಟುಮಾರೋ ವಿಲ್ ಟೇಕ್. ಎಸ್, 116, 117 ಎರಡು ಡೇ ಆಫ್ಟರ್ ಟುಮಾರೋ. ರಿಸರ್ವ್, ಸಾರಿ, ಇವತ್ತಿಂದ ಅಲ್ಲ, ಈಗ ಆಯ್ತದ.
117 is reserved.
14 ಒಂದಿದೆ ಫಾಸ್ಟ್
ಕರಿತೀನಿ. ಏನ್ ಬೇಕು ಪಾಸ್ 14 ಅಲ್ಲಿ?
40 ನಲ್ಲಿ
40 ಏನು?
1440.
ಯಾಕೆ ಪಾಸ್ ಓವರ್ ಆಗಿದೆ?
I filed a memo.
3%, 5%.
3%, 5%.
I filed a memo. What has happened is, my lord, the valuation for the previous tender.
ಅದು ಡೇ ಆಫ್ಟರ್ ಟುಮಾರೋ ಹಾಕಿ. ಎಸ್,
Please.
ಡೇ ಆಫ್ಟರ್ ಟುಮಾರೋ ಹಾಕಿ.
Well, the only thing is, my lord, what has
ಅವ್ರದ್ದು
happened.
ಒಂದು ಡಿಕ್ಟೇಷನ್ ಏನೋ ಕೊಡ್ಬೇಕು ಅಂದಲ್ಲ, ಯಾವ್ದು ಲೀನು?
I will
25,000.
I'll place this
Disposed,
memo, my lord,
yes.
in that serial number.
Copy only on Friday. Yes.
Serial number 14, I'll place this memo on record.
40.
Howದು? 14,
This
14.
14. Learned AGA files a memo, the same is taken on copy serve ಮಾಡಿದಾರ? Same is taken on 14 ಗೆ ಹಾಕಿ ಮೇಡಮ್. ಅದು
14. Even so, block my credit card.
ಯಾವ 51 ಅವ್ರದಾ? that will be on same ground ತಾನೆ.
Yes. Case, my lord, 2 intimations, my lord, that has to be recorded. ಅವ್ರು ಹೇಳಿಲ್ಲ ಅದರಲ್ಲಿ. There are 2 intimations.
ಎಲ್ಲ ಆಯ್ತಲ್ಲ ಮೇಡಮ್? 49 disposed, yes. ಈಗ ತಗೊಂಡ್ಬಿಡಿ ಅದು. ಜಯ ನೀವು ಹೊರಡಿ. ಬೇರೆ ಏನಾದ್ರು ಇದೆಯಾ ಮೇಡಮ್? ಜೀವ ಇರ್ಬೇಕಾಗಿರೋದೇನಿದೆ? ಯಾವುದಿಲ್ಲ. ಜೀವ ಈಗ ನೀವು ಫಸ್ಟ್ ಮುಗಿಸ್ತೀರಾ?
ಅಲ್ಲ, ನಾನೇ ಮುಗಿಸ್ಬಿಡ್ತೀನಿ. ನಾನೇ ಮೊನ್ನೆ ಚೇಂಜ್ ಆಫ್ ಮೈಂಡ್.
I have completed the list. Take your time. Yes.
One judgment additional ಕೊಡ್ತಾ ಇದೆ. Remaining judgment whatever they have cited, I have marked. Just I will take 15 minutes, not more. But I was.
ಇದನ್ one judgment ಇಷ್ಟು ದೊಡ್ಡದ?
ಅಲ್ಲ, ಅದರಲ್ಲಿ ಒಂದು ಅಡಿಷನಲ್ ಜಡ್ಜ್ಮೆಂಟ್ ಇದೆ, ಜಸ್ಬೀರ್ ಸಿಂಗ್. Rest of the judgment already cited.
All right.
Just I wanted to refer a portion mark ಮಾಡ್ಬಿಟ್ಟಿದ್ದೀನಿ because
Paragraph.
Lord, in page 15, your Lordship can just be saying. This is regarding the power of the session judge while dealing with the application under 306 and 307.
Para 5.
Para 5,
Ah.
Lord, kindly have what transpired in that case. The session judge, by his order dated 4/10/1990, rejected the application of the respondent number 1 after assessing the evidence sought to be adduced against the appellant in some detail. It was held that the evidence of respondent number 1 was not necessary to bring home the guilt of the appellant. It was also held that any evidence given by the respondent number 1 would be weak evidence, not only because respondent number 1 would be an approver, but also because respondent number was a convicted offender and had been released on parole because of mental sickness. The session judge concluded that no purpose would be served at all in granting the pardon to respondent. Why I am referring to this is the contention urged in my case also. The evidence of the accused number 1 may not be helpful to the prosecution because there is overwhelming evidence. And also they have alleged certain conduct issue also. Therefore, the reason for which the subject judgment was rendered, I am showing. The Lordship kindly have a next parameter, para 6. The purpose they have stated, I will not read that para. I will straight away draw the attention of the court to para 18. Although the power to actually grant pardon is vested in the court, obviously the court can have no interest whatsoever in outcome, nor can it decide for the prosecution whether particular evidence is required or not to ensure the conviction of the accused. That is the prosecution job. Then, my lord, next page they refer to Pascal Fernandez. Then para 19. Judged by this standard, the first order of the session judge refusing pardon to respondent number 1, even though it was actively canvassed by the special public prosecutor, was wrong. It was not for the session judge to have considered the possible weight of the approver's evidence even before it was given. Then, my lord, para 21. In contrast, the power of tendering pardon under section 307 is restricted to one consideration alone, namely the obtaining evidence from the person to whom the pardon is granted relating to the offense being tried. Therefore, then, my lord, I'll take to para 38, your Lordship. Last 3 lines. Page 24. The powers were independent so that when the magistrate rejected the grant of pardon under section 37, it did not take away the power of the jurisdiction of the district magistrate to entertain a further application for grant of pardon. ಅದರಲ್ಲೂ ಕೂಡ ಸಿಮಿಲರ್ ಒಂದ್ಸಲಿ ರಿಜೆಕ್ಟ್ ಆಗಿ ಇನ್ನೊಂದ್ಸರಿ ಅವರು 64 ಅಲ್ಲಿ ಕನ್ಸಿಡರ್ ಮಾಡಿ therefore my submission is not as per this judgment, observation made in this judgment. The trial judge had no duty to weigh the evidence. Lord, it was only the opinion of the prosecution regarding the witness. Only to that this section, Lord, I am referring to. Lord, the next issue is regarding the culpability. Lord, kindly have a look at para 42 of the Suresh Chandra Barrett.
Iga in continuation with that submission or what?
What?
ಅವತ್ತಿಂದ ರಿಪ್ಲೈ ಇನ್ನು ಕಂಟಿನ್ಯೂ ಮಾಡ್ತಾ ಇದ್ದೀರಾ?
ಹೌದು, ಅವತ್ತಿನ ರಿಪ್ಲೈ ಕಂಟಿನ್ಯೂ ಮಾಡಿ.
ಆಯ್ತು, ಆಮೇಲೆ
para 42 your Lordship kindly.
Page 40.
Page number 51.
Page 51.
51. Para 42 nalli.
Yes, sir.
Para the bottom in the 6th line mele. The basis of the tender of the pardon is not the extent of the culpability of the person to whom the pardon is granted, but the principle is to prevent the escape of the offenders from punishment in heinous offences for lack of evidence. Therefore, culpability, comparative valuation of the culpability is not there. To that extent, I am referring the judgment of Suresh Chandra Bedi. Lord, then, Lordship, kindly have a look at para 28 of the Suresh Chandra Bedi. This is regarding the procedural irregular.
44.
The learned counsel for the appellant strenuously urged that. Page 44.
Page of para na?
Page 44, para number 28.
28.
28.
Yes.
Learned counsel for the appellant strenuously urged that there was utter non-compliance of clause A and B of subsection 4 of section 306 of the Code of Criminal Procedure, inasmuch as after recording of statement of the approver Ramsagar Vishwakarma under section 164 of the Code of Criminal Procedure and after tendering him pardon, the approver was not examined as a witness. Then, my lord, they will discuss the provision, and in the bottom, 306A. Secondly, clause B of 306(4) mandates that approval shall be detained in custody. All these issues they have referred. And finally, they said it has to be tested on the basis of the prejudice. Then, my lord, kindly have a look at the Santosh Kumar Bariyar, para 27, page number 109. Para 27 ನಲ್ಲಿ court frames two issues. Two principal questions, therefore, which arises for our consideration are: A, whether the learned session judge acted illegally in granting pardon to Kumar Gaurav, PW1. Then, my lord, the finding is at para 34.
Yes.
In our opinion, the submission of Sushil Kumar does not merit acceptance. Subsection 4 of section 306 is procedural in nature. It is necessary to be followed only by magistrate, as he would not have any jurisdiction to try the case himself. Therefore, my submission is not. Reading of all these judgments, 306, the procedure which they are claiming is violated, applies to only when the magistrate accepts.
Not to the court of session.
Not to the court of session. Then, my lord, the reading further, the learned session judge before whom the case is committed for a trial must be informed as to on what basis pardon had been intended. Section 307 does not contain any such conditions. The power of the learned session judge is independent of the provisions contained in section 306 thereof. The condition mentioned in section 307 refers to the condition laid down in subsection 1 of section 306, namely that the person in whose favor the tender has been tendered will make a full and true disclosure of the whole of the circumstances within his knowledge. The power of the session court is not hedged with any other condition. Therefore, my lord, it is clear that except the first condition for full disclosure, other things are not applicable. Then, my lord, Lordship may kindly have a go to Srinivasalu's statement. I argued the day before yesterday, my lord, there are two stages where this pardon is granted. But, my lord, in this judgment, the Honorable Supreme Court segregated it to three stages. Para 60.51, your lordship may kindly see, page 185.
Yes.
65.1. Section 301 divides a criminal case into three stages, namely investigation, inquiry, and trial of the offense. Then, my lord, a chief magistrate, judicial magistrate, or a magistrate is empowered to grant pardon to any person at any of the three stages, namely the stage of the investigation, the stage of the inquiry, or the stage of the trial. In contrast, the magistrate of the first class can grant pardon only in two stages, namely the stage of inquiring into or the stage of trying the offense. Subsection 2 of section 306 makes the provision of section 306 applicable to any offences triable exclusively by a court of session or a court of special judge appointed under the Criminal Law Amendment Act 1952, and to any offences punishable with imprisonment which may extend to 7 years or more. Subsection 3 of section 306 obliged the magistrate tendering pardon not only to record the reason for doing so, but also state whether the tender was accepted by the person to whom it was made. Subsection 4 of section 306 make it mandatory that every person accepting a tender of pardon made under subsection 1 shall be examined as a witness, both in the court of the magistrate, taking cognizance, and in the subsequent trial. Subsection 4 also imposes an additional condition that a person accepting the tender of pardon shall be detained in custody till the termination of the trial, except when he is already on bail. A careful look at clause A, B of subsection 4 shows that the procedure prescribed therein is applicable only to cases covered by subsection 1. Then, my lord, I will not read the rest of the thing. Para 68 point, your lordship, your lordship may kindly. Because there the power of the special judge is considered.
No doubt.
The magistrate of first class is also empowered to tender pardon in 2 stages.
Para 78, 79,
Yes,
80 ನೋಡಾಯ್ತು.
Before that,
Yes.
Lord, I'll read one paragraph in 78 ಅಲ್ಲಿ, one
Correct.
line I wanted to stress.
ಓದ್ಬಿಡಿ.
But in cases where a special court itself is competent to take cognizance and also empowered to grant pardon, the procedure under section 306 of the court gets bypassed. Therefore, my submission is the judgment of the trial court is as per the procedure laid down in the Act. There is no arbitrariness. There is no perversity which is shown to this honorable court. Therefore, the order is in order. The order of the trial court is in.
Page 204 ಓದಲ್ವಾ?
204. Threat.
ಬೇಡವಾ?
ಅಲ್ಲ.
ಓದ್. ನಾನು ಅದು ಓದ್ಬಿಟ್ಟೆ ಅದಕ್ಕೆ.
ಮತ್ತೆ ನಾನು ಓದಲ್ಲ. I don't want to waste time. ಅದಕ್ಕೆ ಪ್ರೊಡ್ಯೂಸ್ ಮಾಡಿದ್ದೀನಿ. ಆಮೇಲೆ ಚೇಂಜ್ ಆಫ್ ಸರ್ಕಮ್ಸ್ಟೆನ್ಸಸ್ ಅಂತ ಹೇಳಿ. Lord, they have referred to several judgments relating to the PL 482 and all that. Lord, my submission is, when the consideration of the session court to decide an application in 306 is only the consent. Lord, the only the change of mind as noted in the trial court could be the change of circumstances. And the trial court has considered, and it is recorded in the order sheet about the threat perception and provided secret. 207, your lordship may kindly see. There, the threat given by A9 was brought on record also. Therefore, my submission is, my lord, the order of the trial court is justified. And regarding pen drive, your lordship said it is not required. Bad answer, I will not go to that issue. That's all.
Yes, sir. 2 issues only.
ಇನ್ನೊಂದು irregularity ಮೇಲೆ ಹೇಳಿದ್ದಾರೆ 460G, your lordship may kindly note.
ಅದು ಬೆಳಗ್ಗೆ ಹೇಳಿದ್ರು.
ಕ್ಲೀನ್ ಆಗಿ ಅದರಲ್ಲಿ ಪಾರ್ಡನ್ ಅಪ್ಲಿಕೇಶನ್ ಅಲ್ಲಿ it will not issue at the proceedings ಅಂತಲೇ ಬಂದಿದೆ.
ಎಸ್ ಸರ್ ಹೇಳ್ತಾರೆ ನೀವು ಹೇಳ್ತೀರಾ? ಅವ್ರು ಹೇಳ್ತಾರೆ ಸರ್.
Just the 2 issues, my lord. I'm not
The
going to go more
only
than
thing that sprang into action was PC Act.
PC Act. So according to them, if there's PC Act, section 5(2), if it comes into play, 306 and 307 has no relevance at all. My lord, directly I'll give the judgment itself.
Because that is procedures.
My lord, sir, this is in the case of Bangaru Lakshman versus State, 2012 1 SCC 500. My lord, this is a case under the Prevention of Corruption Act. Now, during the stage of investigation, my lords, one person turns an approver. His statement was recorded. My lords would get that at paragraph 2, my lords. At the point of investigation, the special judge grants pardon to an accused. Then the question was, my lords, they challenged in saying if a charge sheet is not filed, the special judge does not get any jurisdiction, so he could not have granted pardon. It is in this context, court goes into section 5, 306 and 307. The relevant paragraphs, my lords, is at page 503, paragraph right in the bottom, my lords, 5(2) has been extracted.
Revolting to reason.
More importantly, in saying, be deemed to have tendered under, it's a deeming provision. The deeming right in the bottom, 5(2) may be noticed.
Correct. If you see 24, if that is accepted, then it would amount to revolting to reason and by doing violence to the plain words of the statute.
Paragraph 8 ಅಲ್ಲಿ
That's
ಕೂಡ
why I
ಹಾಗೆ
said
ಹೇಳ್ತಾರೆ.
it's procedural.
8, 9, my lords, paragraph 8, 9, and then paragraph 19, which says 5(2) is only a deeming clause. It cannot have any effect to 306 and 307. It has to be read together. And then 24, as my lords pointed out, 23 ali, just the 23, my lords,
Yes.
following the aforesaid well-settled principle, we must hold that the deeming provision introduced in section 5(2) of the PC Act is not for fettering the power. So, my lords, power which they would exercise is relatable to 306, 307, 308.
We'll consider.
And paragraph 24 makes it even more clear, my lords, about how we'll have to read this together. And not that because it is under 5(2), it's a special enactment, it prevails over the court. No, nothing of that kind, my lords. It's only a deeming provision. It only recognizes that the special court can grant pardon. But you fall back on 306 to 308.
Ultimately, it is interpretation of Pascal.
It's interpretation.
Rascal
My lords,
Fernandez.
paragraph 39 and 40, my lords, harmonious reading of these sections is what they say, how you will have to read it. So the special court, when they exercise the powers even before a charge sheet, they say they exercise it under 306, 307, all this read together, harmonious reading. This is the answer to the most important contention in saying, my lords. Because it is under PC Act, 306 to 308 would not have any application. My lords, the other aspect of it, again, as a continuation of this, Srinivas Lu, my lords, already read it. That was also a case under the PC Act. And even in that case, my lords, ultimately they would say, my lords, what is to be seen is 306 to 308. The last portion, which my lords has already pointed out, my lords, the last portion of it, the procedure to be adopted, which we get in 65 onwards and 80. These two paragraphs make it apparent.
65 to 80. 80 is where the
My
conclusion.
lords,
Yes.
because the whole discussion starts from 58.
Correct.
From
Up
58.
to 58 is whether sanction is required or not.
My lords,
Section
58
19.
onwards comes to the aspect of pardon.
Pardon.
And where they would end it is at 80 odd, my lords, where they lay down how it is done. And also there, 5.2 is considered of the PC Act, even in that. So both these judgment, my lords, would put to rest whether only under the PC Act 5.2 is applicable or you have to read the whole thing together. And my lords, most important, though so many times we have pointed out 306, my lords, 306 subsection 2, please notice, my lords, it's only for a sessions court and a special court. My lords, can I just point that out, my lords, for them to say, other than 306(1), all the others will not apply to 307 would be totally incorrect by the very reading of the section itself. Please notice in the section, this too may be noticed, my lords. This section applies to whom does it apply, my lords?
Court of session and talle ide.
Mate, how is the contention?
Any section applies to any offense triable exclusively by the court of session or by the court of special judge appointed under criminal amendment so and so. Any offense with imprisonment, that's all right.
My lords, where they say may. ಒಂದು ನಿಮಿಷ ನಾವು ಮುಗಿಸ್ತೀವಿ.
ಮುಗಿಸ್ಬಿಡಿ.
I can't give pardon at all.
My lords, magistrate.
The maximum sentence he could impose under section 29 of the CRPC is 5 years.
5 years. That is magistrate. So
Magistrate.
question of pardon ಬರೋದೇ ಇಲ್ಲ. It is only to the court of session.
Exercising his jurisdiction under section 306 and carrying on with the trial of the case.
Please notice there B also, my lords. An offense punishable with
Extend beyond 7 years.
up to.
Up to 7 years or more.
My lords, in the IPC, we have about 87 sections, my lords, in the IPC, where they say up to 7 years. So the intention is which goes up to 7 years and beyond.
Beyond.
So, my lords, the.
That is why before it is till 7 years. And
No.
It's only magistrate.
How? So, my lords, if it is going to be an offense up to 6 years, up to 5 years, no question of pardon. The offense under the IPC should read it is punishable up to 7 years, like 420, 472, like that 87 sections. That is where pardon can be granted. So, my lords, if 2 is seen, now that whole argument in saying, my lords, we can't have 2, 3.
No, that's what, see, there is already exclusive, this section applies to offense triable exclusively by the court of session.
So, my lords, how can there be an argument to say?
Now, what Nagendra Naik is wanting to tell is, the offense is not exclusively triable by court of session in this. It is the special court. Is that your submission?
It is triable by session.
Session only.
ಇಲ್ಲ ಇಲ್ಲ ಇಲ್ಲಿ ಅಲ್ಲಿ ಸ್ವಲ್ಪ
302 ಅಲ್ವಾ? Triable by session only.
ಇಂಟರ್ಪ್ರಿಟೇಷನ್ ಹೇಳ್ತೇನೆ. Offense is, my lord, 302. FIR is filed before the magistrate.
All right.
When it is until committal, it will be before magistrate.
Right.
The offense.
ಈಗ ಒಂದ್ ನಿಮಿಷ. Offense triable exclusively by the court of session after committal.
ಇಲ್ಲ ಹಾಗಲ್ಲ.
ಮತ್ತೆ?
ಈಗೇನಾಗುತ್ತೆ ನಾನು ಅದಕ್ಕೆ ಎಕ್ಸಾಂಪಲ್
302 is exclusively triable by the session. So until it is committed, it remains before the magistrate.
Magistrate.
Correct.
Yes.
Now, what do you mean by this? This section applies to any offense triable exclusively by the court of session.
ಅದನ್ನೇ ನಾನು ಹೇಳ್ತಿದ್ದೀನಿ. ಈಗ 302 ನಲ್ಲಿ FIR ಆಯ್ತು.
ಹೌದು.
ಇನ್ವೆಸ್ಟಿಗೇಷನ್ ಕಮೆನ್ಸ್ ಆಯ್ತು. ನಾನು ಅದಕ್ಕೆ I read 65.1 in Srinivas Lu.
Correct.
There are three stages. Enquiry, investigation, enquiry and trial.
Yes.
Before charge sheet, IO brings an accused and files an application saying that I want to tender him pardon under 306. There, the offense is triable by the session. But the magistrate has the power to decide whether this man has to be
Pardoned or not.
treated as approver or not.
Treated as approval.
The stage makes a difference.
We'll see.
My lords, could I just?
But it is applicable to sessions.
Aye.
Sessions of.
Yes. Yes, Sandesh sir.
Sorry, my lords. 2 I pointed out, my lords. Please now notice even 3. Every magistrate who tenders a pardon under subsection 1 shall record his reasons for so doing. This reasons for so doing was not there in 337, my lords. So in Pascal,
Earlier code.
Irrilla. So in Pascal's case, when they said is reasons required, they said it is not required because this section doesn't require it.
No, now it is.
Now it is
in the
required, so it's
statute.
been incorporated. And in that B, where a tender was or was not accepted by a person to whom it was made. Acceptance, my lords. Please notice this, my lords. For an offense up to 7 years, if they say you will have to have an acceptance, then, my lords, for a more heinous offense, let's take it one which is punishable with death. Could the logic be for that you don't need acceptance? It defies, my lords, what is the requirement under this section. I will point out now what they say is 306(4). That the distinction was drawn because as it stands under 306(4), at 2 stages, my lords, it contemplated evidence to be recorded. Please notice 306(4). All the judgments they are relying on is
306(4).
4. Please notice now 4, my lords. Every person accepting a tender of pardon.
Yes.
So it starts with accepting a tender of pardon, we get in 4.
So first acceptance should be there.
Acceptance.
Yes.
And then, my lords, made under subsection 1A shall be examined as a witness in the court of magistrate taking cognizance of the offense and in the subsequent trial. So under this section, my lords, they said you will have to have it as a dual purpose before the magistrate and in trial. That the Supreme Court says no. Any one place, if it is done, is sufficient. This is all that the interpretation that has taken place to say one place you have it.
Let's see.
And the 308, my lords, 308, the wording says, where in regard to a person who has accepted a tender of pardon made under 306 or 307. So acceptance of pardon under 306 or 307. So again, 308 makes it very clear on it. So, my lords, the last aspect which I just wanted to bring to the notice of the court is, now what they're requesting the court to do is, read something that is not in the section by saying deemed acceptance. Now, in penal law, my lords, it is absolute strict interpretation of the statute. Now, in 337, 338 was there, legislature. ಅಲ್ಲ middle ಅಲ್ಲಿ
ಅವ್ರು ಮುಗಿಸ್ಲಿ ಸರ್.
ಅಲ್ಲ ಅಲ್ಲೇ ಒಂದು ಕ್ಲಾರಿಫಿಕೇಶನ್
ಆಯ್ತು, ಒಂದ್ ನಿಮಿಷ. ಅಲ್ಲಲ್ಲೇ ಬೇಡ. ಎಸ್.
337, 338 was there, my lords. 1973 comes the amendment. In their wisdom, they feel we are not segregating an application filed by the prosecutor with that of an application filed by an accused. The interpretation now which is sought to be made is, please treat it differently, which is not there in 306. Treat it differently. If it is going to be one of an prosecutor, then acceptance is required. But if it is going to be one of an accused, no acceptance is required. We can't read something what is
The
not there.
statute does not say so.
My lords, that's
It is, no, that's there.
and basic thing in criminal law, my lords, penal provision, strict interpretation. We can't come to mischief rule, prospective, golden rule. So in my respectful submission, my lords, I thought of the submissions given, these were the only aspects which I wanted to point out legally, my lords.
I only wanted about PC Act and nothing else.
My lords, both the judgments, I think,
Nothing else. Other things you had already submitted, it's all right. Only PC Act, because the only new thing told today was that.
yes, my lords. Srinivas Lu touches upon even the previous judgment in Bangarlu, my lords. Para 67, it's there.
ಹೇಳಿ ಸರ್.
ನಾನೇನು ಓದಲ್ಲ. 65.1 of Srinivas Lu and 66. ಅದಷ್ಟು ತಾವು ಇನ್ನೊಂದು ರೌಂಡ್ ನೋಡಿದ್ರೆ ಐ ಥಿಂಕ್ ದಿಸ್ ವಿಲ್
65.1 and 66.
66. ಯಾಕಂದ್ರೆ 66 ಅಲ್ಲಿ 307 ಸ್ಪೆಸಿಫಿಕ್ ಆಗಿ ಹೇಳ್ತಾರೆ ಅಂಡ್ ಸ್ಟೇಜಸ್ ವಿಚ್ ಹಾಕ್ತಾರೆ. ಹಾಗಾಗಿ 306(2) ನಲ್ಲಿ ಇಟ್ ಅಪ್ಲೈಸ್ ಟು ದಿ ಅಫೆನ್ಸಸ್ ಪಯಬಲ್ ಬೈ ಸೆಷನ್ ಅಂತ ಹೇಳಿದ್ರೆ ಇಟ್ ಈಸ್ ನಾಟ್ ದಿ ಪವರ್ ಆಫ್ ದಿ ಸೆಷನ್. ಇಟ್ ಈಸ್ ರಿಲೇಟಿಂಗ್ ಟು ದಿ ಅಫೆನ್ಸ್ ಬಿಫೋರ್ ಕಮಿಟಲ್ ಸ್ಟೇಜ್. ವಿ ಆರ್ ಇನ್ ದಿಸ್ post committal stage.
Because according to you, the words used in 306(2)
yes,
is The offense triable by the court of session, not, what difference does it make?
It makes the difference.
What difference?
ಏನಾಗುತ್ತೆ ಅಂದ್ರೆ
Offense triable by the court of session or the court of session, what difference does it?
ಅಲ್ಲ ಏನ್ ಡಿಫರೆನ್ಸ್ ಆಗುತ್ತೆ ಅಂತ. Offense triable by the court of session, which was before committal, it will be pending before magistrate. Magistrate has power under 306. Once post ಅದನ್ನೇ ನಾನು ಶ್ರೀನಿವಾಸ ಪ್ಯಾರಾ 66 ಒಂದು ನಿಮಿಷ ಎರಡು ಲೈನ್ ನೋಡಿ. Section 307 of the code empowers the court which the commitment is made to tender pardon. The power can be exercised at any time after the commitment of the case, but before the judgment is passed. This is the distinction.
I will consider. Ashte. I have to seek pardon now.
One closing statement which I wanted to make. While reading, my lord, interpreting 306, 307 and 308, where the entire dimension of the section, my lord, the core and my lord, fulcrum means, my lord, evidence. What of evidence? Obtaining of evidence. But the dimension in which it is asked, my lord, is part of it, when I go here.
Well, the evidence is the here. Evidence is the soul, but what is projected is the part. In fact, 306(1) is the soul of the provision. Complete discovery, complete revelation of true facts. True facts. That is the soul of the provision. Idella incidental.
If they say for 307 it is not required, please offer us a logic why it is not required. When the lawmakers have felt that it is required for this purpose.
ನಾನು ಹೇಳೋದಲ್ಲ, ಸುಪ್ರೀಂ ಕೋರ್ಟ್ನವರೇ ಹೇಳಿದ್ದಾರೆ ಜಡ್ಜ್ಮೆಂಟ್ ಅಲ್ಲಿ. ನಾನೇನ್ ಹೇಳಕ್ಕಾಗತ್ತೆ?
Will consider. I think arguments ಆಗಿದೆಯಲ್ಲ.
You require, if it is a death sentence, you don't require. If it is a death sentence, you don't require. If it is a sentence less than 5 years, it is required. If it is a death sentence, hanging, it is not needed.
If they say we don't want it, why not when it is required?
ನಾನು ಹೇಳಿದ್ದಲ್ಲ ಶ್ಯಾಮಸುಂದರ್.
Pascal Fernandez.
Pascal Fernandez ಅಲ್ಲಿ.
Pascal Fernandez ಅಂದ್ರೆ
that is followed even now. It is not reverse.
1.2 ಯಾರೋ ಇದ್ರಲ್ಲ, ಸೇಮ್ ತಾನೆ ಅದು? ಸುನಿಲ್ ಕುಮಾರ್ ನೀವೇ ಇದ್ದೀರಾ? ಅಲ್ಲ, ಸೇಮ್ ಸಬ್ಮಿಷನ್ಸ್ ತಾನೆ? Heard reserved. Yes. Finally.
one sentence.
Yes, sir.
Pascal Fernandez repeatedly, my learned friend Mr. Raju referred to it.
Yes, sir.
And he also said, when I submitted to your lordship the other day, that unless and until the prosecution were to contend that without the evidence of the approver, it is rather difficult for the prosecution to bring home the guilt of the companion accused of the approver. That is the statement which the prosecution is required to make when the prosecution is called upon to have its say on the application filed by the accused. My learned friend Mr. Raju submitted to your lordship that where is it contemplated? Well, that is contemplated, my lord, by way of law that is laid down by the Supreme Court, even in Pascal Fernandez case. Paragraph 15, just to recapitulate, my lord, the submission. Three sentences.
Yes, yes.
That's all, not more than that. But I have referred to Pascal Fernandez, Suresh Chandra,
Yes.
and Somveer Singh also. I have referred to 3 judgments. The proper course for the special judge is to ask for a statement from the prosecution on the request of the prisoner. If the prosecution thinks that the tender of pardon will be in the interest of successful prosecution of the other offenders, whose conviction, kindly mark this, whose conviction is not easy without the approver's testimony, it will indubitably agree to the tendering of pardon. Well, in fact, the other day, your lordship made a note of it that 153 witnesses, eyewitnesses,
Yes.
motive, conspiracy.
8 eyewitnesses.
8 eyewitnesses, total 153 witnesses.
8 eyewitnesses, 10 heads of evidence.
Motive, conspiracy,
ಎಲ್ಲ
recovery,
153.
eyewitness.
Each head has 10 witnesses. First, eyewitnesses are 8.
My lord, in the
It is lacking. Learned judge, my lord, in the entire improved order doesn't say even remotely why there is the possibility of it.
My lord, even in one nimisha, in Somveer Singh, what the court would say, in fact, your lordship pointed out even before I could invite my lord's kind attention to this judgment. As already discussed above, it is only the lack of evidence which could justify grant of pardon to one of the accused. Any such application is to be examined minutely and cannot be accepted as if it is a matter of right. This is precisely what has been held in Ashok Agarwal's, Kumar Agarwal's case. And
We'll
one
consider
submission which
everything.
came to be made by Mr. Raju is that there is no pleading here. Well, the less I say about it is better. Pleading a criminal petition and all. Now, in what we have questioned in the criminal petition is the legality and correctness of the order passed by the trial court, which in fact is not based on pleadings. Pleading is found in paragraph 8 of my statement of objections to the application filed by the first accused. That is the pleading. Illala pleading.
We have burdened the court with so much.
ಅದಕ್ಕೆ ನಾನೇ ಅಪ್ಲಿಕೇಶನ್ ಹಾಕ್ತೀನಿ ಪಾರ್ಡನ್.
306, my lord, it reads tender pardon accompanied. 307 otherwise, it is says, it reads with the title, power to direct tender pardon. My lord, in fact, it's the next stage. It was then not, if it was then not considered, it was then not necessitated, even during the trial, the power is still bestowed. It doesn't mean, my lord, that I'll not follow those.
You be rest assured, I'll consider everything and pass out. Yes.
We know that.
Sir.
We know for certainty that.
Yes, that is what.
No doubt.
Because it is not the earlier petition in the 10, it is now tenfold submissions are made.
More legal issues are
More legal issues have arisen.
Well, in the earlier petition,
It was only 164 statement.
Justified in asking the magistrate to record the
Yes,
statement
that's
at section
what
164.
we have held. Now
Because
there are
164, recording of 164 by the magistrate only during investigation of the crime, not after the commencement of the trial before.
there
the
are
sessions court.
larger legal issues here. We will answer.
Deeply obliged.
I'll reserve.
Hope your lordship would pardon us if you have tried your lordship's patience.
It's all right. Yes. No, it's a learning to me also, sir. Yes. Status, Allah, restored status quo ante.
Although your lordship would say interim order automatically continues.
That will continue.
But I have
Till
a
the
duty,
disposal.
I have a duty to request your
Yes,
lordship
yes,
to
don't
continue the
worry.
interim
It will
order.
continue till
Till the
since I have
disposal.
reserved it, will be continued till the pronouncement of the judge.
Please, deeply obliged.
Yes. 7? ಇದು ಅದು 7 ಎಲ್ಲಿ ವೆಂಕಟೇಶ್ ಅರ್ಬಟ್ಟಿ.
Here for the respondent.
Just to, before Mr. Melod's, I had completed my, ಒಂದೇ ನಿಮಿಷ.
ಅವ್ರು ಮಾಡಿರ್ತಾರೆ, ನಾನು ಆಗಿದೆ ಅಂತ ಅಷ್ಟೇ ಬೇರೆ.
ಒಂದು ನಿಮಿಷ.
ಮಾಡಿ
ಅವ್ರು ನಿಮ್ದು ಆಗಿದೆ ಬಿಡಿ.
I had
Are 6 kind of petitions are there. You also made your submissions.
ಒಂದೇ ದಿನ ಮಾಡೋದು.
ಎಷ್ಟು ದಿನ ಮಾಡ್ಬೇಕು ಸರ್?
ಅಲ್ಲ, ನಾನಿದು ಸೀತಾಸೋರೇನ್ ಹೇಳ್ಬೇಕು ಅಂತ
ಆಯ್ತು,
ಅದು
ನೀವು
ಹಾಗೆ
ಹೇಳ್ಬಿಡಿ.
ಹೇಳಿ ಅವ್ರು ಆಗ್ಲಿ.
ಅವ್ರದ್ದು ಆಗಿದೆ, ನೀವು ಹೇಳಿ.
ಆಗಿದೆ ಅಂದ್ರೆ ಸಮಾಧಾನ ಅಂದ್ರೆ Lord Sita Soren, may I just request Lord to take
One
para
nimsha.
1-1.
Any other counsel is waiting for any order? Part in person.
Posting, my lord.
ಪೋಸ್ಟಿಂಗ್ ಇಷ್ಟೊತ್ತಲ್ಲಿ ಮಾಡಕ್ ನಾಳೆ ಆಗಲ್ಲ, ಶುಕ್ರವಾರ ಮಾಡುವ. ಪಾರ್ಟಿ ಇನ್ ಪರ್ಸನ್ ನೀವು ಕೊಡಿ. ಯಾವ ವಾಟ್ ಇಸ್ ದ ಮ್ಯಾಟರ್? ಸರ್ಫೇಸಿ
Miscellaneous matter.
ಎಲ್ಲ ಮಿಸ್ಲೇನಿಯಸ್. ಏನ್ ಹೇಳಿ?
PMS college versus ಈಗ civil rights enforcement cell.
ಸಾಕೇಶ್ ಶ್ಯಾಮು, ನೀವೇನಾ ಸಾಕೇಶ್ ಶ್ಯಾಮು? ಹಾ ಕೊಡಿ. ಎಸ್, 4 ವರ್ಷದಿಂದ ಕೇಳಿದ್ದೆ ಇದನ್ನ, ಮತ್ತೆ ಯಾಕೆ ಈಗ?
Colleges created to.
ಆಯ್ತು ಕೊಡಿ. ಯಾವತ್ ಬೇಕು? ಶುಕ್ರವಾರ ಆಗ್ಬೋದಾ?
Thursday.
ಶುಕ್ರವಾರ ತಗೊಳ್ಳಿ. ಹಾ, ಶುಕ್ರವಾರ ಕೊಡಿ ಮೇಡಮ್, ಅದು ತಗೊಳ್ಳಿ. ಆಯ್ತು. ಎಸ್ ಕವಿತಾ ಮೇಡಮ್, ನೀವಿರ್ಲಿಲ್ಲ ಆದ್ರೂ ಸ್ಟೇ ಕೊಟ್ಟಿದ್ದೀನಿ ನಾನು. ಹಾ ಆಯ್ತು. 10-10 ಐ ಥಿಂಕ್ 3-3 ಏನೋ ಹೇಳಿದ್ದೀನಿ. ಹಾ ಎಸ್
Sita Soren.
ಕೊಡಿ. ಪ್ಯಾರಾಗ್ರಾಫ್
119 onwards.
ಕೊಡಿ.
It is under a separate head itself.
ಒಂದು ನಿಮಿಷ.
But facts are at para 3. I will not trouble my lords taking this. Facts are at para 3, your lords. Yes.
facts are at para 3 onwards, why reference was made, then kindly come to my lord para 6 at page 667 on top right hand side. Page 667, para 6. Adralli, the reference order is extracted para 24. Para 6 of this judgment at page 666 on the top right hand side.
No, sorry, sir. Yeah.
Para 3 onwards is the reference order.
Yes.
Para 6, your lordship may kindly come.
Correct.
Para 6 on top right hand side, 667 page number. Idralli reference order, 5 judgments reference order is extracted.
Correct.
Kindly come to 24.3 on the next page.
Yes.
Thirdly, the judgment of Sri of S.C. Agrawal, Justice
Yes,
S.C. Agrawal
got
has
that.
specifically dealt on the question as to when the offense of bribery would be complete. The judgment notes that the offense is complete with the acceptance of the money or on the agreement to accept the money being concluded and is not dependent on the performance of the illegal promise by the receiver. The receiver of the bribe would be treated to have committed the offense even when he fails to perform the bargain underlying the tender and acceptance of the bribe. This aspect bearing on the constituent elements of the offense of bribe elaboration needs elaboration in judgment of Justice Agarwal, but is not dealt with in judgment of majority. Now kindly come to Milord in this context, kindly come to para 119. The caption for para 119 is part 4 of the judgment. On top, Milord, 709 page
Yes,
number,
sir.
the right hand side.
Yes.
Delivery of results is irrelevant to the offense of
Correct.
bribery.
ಇದಾದ್ಮೇಲೆನೆ ಅದನ್ನ ಸ್ಟಾಪ್ ಮಾಡಿದ್ ನಾವು. ವರ್ಕ್ ಪೆಂಡಿಂಗ್
Yes.
ಅದೆಲ್ಲ ಸ್ಟಾಪ್ ಮಾಡಿದ್ದು
Work
ಕನ್ಸಿಡರ್
pendency
ಮಾಡೋದು
is
ಓನ್ಲಿ
not an
ಬಿಕಾಸ್ ಆಫ್
issue.
ಸೀತಾ ಸೊರೆ.
Yes, Lord. Here in the same same under the same part 4, para 121, the new section 7 is extracted. Para 124, the old section 7 is extracted. Kindly now come to para 127. Neeraj Datta is
Correct.
extracted,
Yes.
where Honorable Justice Nagaratna's judgment.
It's clarified by Justice Oak later.
Yes, but it does not dilute nor the position that whether the bribe amount is received
Justice
or not.
Oak has clarified saying that the judgment of the Constitution bench nowhere dilutes the position of demand and acceptance.
And Milord, even non-receipt of the bribe amount by
Correct.
one of the accused
Those
does not mean.
Those rudimentary things that are found in
Yes.
section 7 is
Yes.
not diluted is
Yes.
what is said.
Yes, Milord. So failed trap, Milord, under the caption of failed trap, if not one accused is said, Milord, he did not receive the amount, so Milord, benefit has to be given to him or proceedings against him has to
If
be.
some other accused has received in favor of him will not become failed trap.
Yes,
All
that's
right,
what.
failed trap is the one where you could not trap the person at all and you go back, come back, go back, come back.
But Milord, Milord, fancy submissions, I would say, not senior Milord, fancy submission, failed trap anta bartare, ashte. That has to be understood to be that. So Milord, in that context, para 127.
All right.
There, Milord, para 127, I'll skip, Milord, the extracted portion. At page 713, kindly see, Milord, this is the relevant portion also. Consequently, the actual doing or forbearing to do the official act is not a constituent part of the offense. All that is required is that the illegal gratification should be obtained as a motive or reward. For such an action or omission, whether it is actually carried out or not is not relevant. So, Milord, whether he is authorized or not, whether the accused is authorized or not, whether he is accepting on behalf of, but the moment there is a complaint referring to one or two persons, the moment there is not a reference to an official favor, whether that accused is not entitled to do it, authorized to do it, or empowered to do it, not that pales into insignificance is the up to paragraph 131 minutes. I'll stop at that.
Ashtana?
Look, this is not there in my note.
No problem.
No, because my lords, this, so far as this judgment is concerned, my lords, I had pointed out a classical example in saying, I promise Arbati that I will transfer him from point A to B, provided he gives me 10 lakhs. Now, as soon as he gives me 10 lakhs, offense is complete. It is not dependent on me transferring him to point B. This is all Sita Soren is.
Yes.
Demand and acceptance should be proved because it's sine qua non. But the work need not be done.
That's what.
That's all.
Yes,
So, my lords.
that's what is said. That's all right.
And probably, I don't know with their.
There is one interesting thing of all. Berella, it's conventional. Reverse trap is one thing that
Interesting.
is
My lords,
first time emerged.
my lords, the latest judgment now is, my lords, on 7th March 2025, Madan Lal versus State of Rajasthan.
Yes.
Their Lordship Justice Vinod Chandra and Sudhanshu, my lords. There they hold demanded
Sudhanshu
acceptance.
and Vinod Chandra.
Yes, my lords.
Yes.
Demanded acceptance sine qua non.
Correct.
This, if required, I will give it 7th March 2025.
ಕೊಡಿ ಏನೇನ್ ಕೊಡ್ಬೇಕು
That
ಕೊಟ್ಬಿಡಿ.
only, my lords. Because they were under the impression, my lords, even if you just make a demand but don't really accept it, it amounts to a, no, it doesn't. Demand acceptance sine qua non, the work if I have not done, irrespect. That's what it is.
Illustration 2.
That, my lords,
Illustration 2.
illustration ಗೆ
ಅಲ್ಲ
ನಾನು
ಇದೇ
note
ಸೇಮ್
ಕೊಟ್ಟಿದ್ದೀನಿ.
ಎಕ್ಸಾಂಪಲ್ ಇದೆ, ಸೇಮ್
That-
ಎಕ್ಸಾಂಪಲ್ ಇದೆ.
Illustration answer ಮಾಡ್ಕೊಂಡು, that was the argument done. 4
That
points.
illustration
I
also.
will remind Mr. Arbati what his argument was regarding the object of 2018 amendment and illustration under section 7, which was not there
senior
in the old act.
overshouts me, Milord, it does not, Milord, it's not.
If the
Milord, the illustration is there.
Milord.
The same illustration which Leonard Senior gave as an example, ನನ್ನೆಲ್ಲೋ ಕರ್ಕೊಂಡು ಹೋಗ್ತೀನಿ.
4 points which said.
I'll ಇಟ್ಬಿಡಿ. I'll take it later. ಇಲ್ಲಿ ಈ ಕಡೆ ಕೊಡಿ. ರೇಖಾ ಮೇಡಮ್ ಈ ಕಡೆ ಕೊಡಿ.
This was the 4 points argued by Mr. Arbati, 8 points argued by Mr. Had done this, given
this why-
answering the whole contentions of this.
No, actually, Arbati sir, you had extensively argued this. ಸೀತಾ ಸೋರೇನ್ ಒಂದು ಹೇಳಿರ್ಲಿಲ್ಲ ಅಷ್ಟೇ.
ಹೇಳಿರ್ಲಿಲ್ಲ.
ಅದೊಂದು ಹೇಳಿರ್ಲಿಲ್ಲ.
Illustration is also covered here in
But illustration ಇದು extensively had argued.
That I am not denying.
Yes.
But illustration also, what is there? Illustration, same example given by Leonard Senior. ನನ್ನೆಲ್ಲೋ ಕರ್ಕೊಂಡು ಹೋಗ್ತೀನಿ ಅಂದ್ರು, ದುಡ್ಡು ಕೊಡ್ತೀನಿ ಅಂದ್ರು, ಅಷ್ಟು ಹೇಳಿದ್ರೆ ಸಾಕಲ್ಲ. The train example which is given here, ಅಷ್ಟು ಡಿಮಾಂಡ್ ಮತ್ತೆ ಇದ್ರೆ ಸಾಕು ಅಂತಾನೆ ಇದೆ. That is the second illustration.
ಅಷ್ಟೇ. I had reserved all these matters.
Please, ma'am.
Complaint serve ಆಗಿದೆ ಎಲ್ಲದರಲ್ಲೂ.
Serve ಆಗಿದೆ.
But I request
My
all,
lords.
Lord, in all cases complaints are not, sir. So your lordship may disconnect and not reserve those matters. ಹೌದು. ಹೌದು.
ಇದ್ರಲ್ಲೆಲ್ಲ ನಾನು I told serve ಮಾಡಿ ಅಂತ.
I leave it to my lords. There are about 4 or 5 cases.
All served. I have got the note on. In Arbati sir, ಇನ್ನು ಬೇರೆ ಯಾವ್ದು ರಿಸರ್ವ್ ಇದು ಫರ್ದರ್ ಹೆಂಗ್ ಮಾಡಿದ್ರಲ್ಲಿ ಸರ್ವ್ ಆಗಿದೆ ಇಲ್ಲ ನಾನು ನೋಡ್ತಾ ಇಲ್ಲ.
ಇದ್ರಲ್ಲಿ
ಈ 6ರಲ್ಲಿ ಸರ್ವ್ ಆಗಿದೆಯೋ ಇಲ್ವೋ ಅಷ್ಟೇ.
ಅಲ್ಲ ನನ್ನ ಲಿಸ್ಟ್ ಪ್ರಕಾರ
ಲಿಸ್ಟ್ ಪ್ರಕಾರ ಅಲ್ಲ, ಇಲ್ಲಿ ಹ್ಯಾಂಡ್ ಸಮನ್ಸ್ ತರಿಸಿದಲ್ಲ ಮೇಡಮ್ ಎಲ್ಲ ಸರ್ವ್ ಆಗಿದೆ. ಅದೇ ಸರ್ವ್ ಆಗಿದೆ.
That's, it has taken, served, and we have also put the, it's there on record.
I'll we will first note in an order sheet that all of them are
If
served.
lords are satisfied, I have no issue. I just wanted.
Satisfied
If
person.
it is Lord, ಅಲ್ಲ 2-3 served.
And these complaints will never come. When you register the complaint like this and go, they will never
Quite
come.
possible.
Yes.
My lord, ಇದರಲ್ಲಿ ಫ್ಯಾಕ್ಟ್ಸ್ ಮೇಲೆ ಆರ್ಗ್ಯೂ ಮಾಡಿಲ್ಲ, ಓನ್ಲಿ ಲೀಗಲ್ ಆಸ್ಪೆಕ್ಟ್ಸ್ ಮೇಲೆ ಆರ್ಗ್ಯೂ ಆಗಿದೆ.
ನಾನು ಆನ್ಸರ್ ಮಾಡ್ತಿರೋದು ಲೀಗಲ್ ಆಸ್ಪೆಕ್ಟ್ ಮೇಲೆ ಸರ್. ಯಾವ್ದು ಫ್ಯಾಕ್ಟ್ಸ್ ಮೇಲೆ ಇಲ್ಲ. ಏನ್ ಫ್ಯಾಕ್ಟ್ಸ್ ಮೇಲೆ ಆರ್ಗ್ಯೂ ಮಾಡ್ಬೇಕು?
ಸೀನಿಯರ್ ಫ್ಯಾಕ್ಟ್ಸ್ ಮೇಲೆ ಆರ್ಗ್ಯೂ ಮಾಡ್ಬೇಕಿಂತ, ಸೊ ಹಾಗಾಗಿ
ಎಲ್ಲ ಮಾಡಾಗಿದೆ ಸುಮ್ಮನೆ. ಎಷ್ಟು ಸರಿ ಕೇಳ್ತಾ ಕೂತ್ಕೊಳ್ಳಿ.
All been heard.
ಎಸ್ ಹರ್ಡ್ ರಿಸಲ್ಟ್.
ಒನ್ ಅಪರ್ಚುನಿಟಿ,
Obliged.
ಕೈಂಡ್ಲಿ ಹ್ಯಾವ್ ಇಟ್ ಟುಮಾರೋ.
ಬೇಕಾದ್ರೆ ಹೇಳಿ ನೋಡೋಣ ವಿಲ್ಸಿ. ನನಗೆ ಡೌಟ್ ಇದ್ರೆ ಪೋಸ್ಟ್ ಮಾಡಿಸ್ತೀನಿ.
ಪ್ಲೀಸ್
ಇನ್ನು ಬೇಕಾದಷ್ಟು ಮ್ಯಾಟರ್ ಇದೆ ಫ್ಯಾಕ್ಟ್ಸ್ ಮೇಲೆ ಆರ್ಗ್ಯೂ ಮಾಡಕ್ ಹೇಳಿ.
ಕೈಂಡ್ಲಿ.
ಐ ಆಮ್ ಆನ್ಸರಿಂಗ್ ಲೀಗಲ್ ಇಶ್ಯೂಸ್ ಇನ್ ದಿಸ್. ಫ್ಯಾಕ್ಟ್ಸ್ ಮೇಲೆ ವಿಲ್ ಕನ್ಸಿಡರ್.
ಎರಡರಲ್ಲಿ ಅಬ್ಜೆಕ್ಷನ್ ಹಾಕಿಲ್ಲ, ಅಬ್ಜೆಕ್ಷನ್ ಹಾಕ್ಬೇಕಿದೆ. ಸೊ
ಏನ್ ಮಾಡ್ತಿದ್ರಿ ಇಲ್ಲಿವರೆಗೆ?
ದಯವಿಟ್ಟು
6 ತಿಂಗಳಾಗಿದೆ ಅದು ಬಂದು.
ಎಸ್ ಪ್ಲೀಸ್
ಎಸ್ ಹಾಕಿ ಎಸ್ ನೆಕ್ಸ್ಟ್.
ಕೈಂಡ್ಲಿ ಟುಮಾರೋ.